Hey there, squad. Good morning. We are just waiting the beginning of the Tyler Robinson hearing this morning. This is a big one. So let's talk about what's going to go on today. This is a media hearing. So the defense is going to argue that TV cameras, live streaming, photographers, and some of the courtroom audio and video coverage should be restricted or even removed because they say the publicity is contaminating the jury pool. This is a very standard argument. We've seen this many, many times in lots of trials. This is something that always gets addressed, that the defense says this is going to taint the jury pool. We can't get a fair trial if we have cameras in the courtroom. Then we're going to have the prosecutors are expected probably to push back on that to some extent, that the case is of major public interest, court transparency matters. I do think that they are going to have some agreement also, though, around particular issues that might come up that maybe shouldn't be streamed. I don't know. We'll see. I know also that the defense has expert witness, Brian Edelman. He's a social psychologist. We've seen him before. He testified in the Brian Kohberger case. He's going to testify about how social media exposure can prejudice jurors. Very similar to the argument that he made in Brian Kohberger that actually assisted in the moving of the trial from Moscow to Ada County. I don't know what they're going to do with Utah County. Utah County, there are other counties near Utah County that are bigger as far as population are concerned. Utah County has a very large student population, and that might be a problem for their jury pool because students aren't necessarily eligible for jury service in the county where they're living, because if that's not their county of considered their county of residence. So that could come up. We're going to also probably hear from attorneys for the media who will, of course, say, that the public has the right to know and that they want to be present. Likely, we're going to see the judge address certain exhibits and whether those exhibits should be public or sealed or partially redacted. We may also see that some of this hearing is held behind closed doors if they're going to talk about specific things. I know one in particular that they have already addressed is the video of the shooting of Charlie Kirk. Now, we've all seen it, right? It's out there everywhere. But they are still talking about restricting it from being seen because it could be prejudicial. There may be other things as well. Now, going on sort of behind the scenes with this is that new ATF report that was recently unsealed that shows that the bullet fragments were inconclusive as to whether they definitively match the rifle that prosecutors say that Tyler Robinson used. They basically say they cannot confirm or deny that those bullet fragments came from that gun. And so that is pretty key, not necessarily for today's hearing, but just in what's going on. And then there is something else new that is going on. I don't know that this will be addressed today unless this judge really speeds up his process because he takes forever. Judge Graf is very methodical, but the defense has filed a contempt motion on prosecutor Christopher Ballard, who recently spoke to TMZ about that ATF report. So the defense's argument is that prosecutor Christopher Ballard violated the court's gag order when he gave TMZ comments after the defense filed about the inconclusive bullet fragment testing. Ballard said, quoted to TMZ, The state has ample evidence to demonstrate beyond a reasonable doubt that Tyler Robinson committed this murder, trying to minimize the bullet fragment evidence. I'm going to be real surprised if the judge does anything about that particularly. I think it's unwise. I don't know what this prosecutor's thinking talking to TMZ right now. And maybe he'll get the word that, hey, you can't do that anymore. Um, the defense says that the statement goes beyond procedural comment and becomes a public declaration of guilt. I mean, obviously, the prosecutor is going to think that this person is guilty. That's why they've charged them. They are also saying it directly risks prejudicing future jurors. It violates the judge's prior restriction on public commentary by attorneys. Now, that is true. It undermines the defense's argument that media exposure is already contaminating the case. So they'll probably mention it today. I don't know if the judge will do anything about it today. Here's what they're asking the judge to do. They want to hold the Utah County's attorney's office in contempt. They want to force prosecutors to turn over all communications with media since March 27th. And they want to determine whether prosecutors selectively shaped press coverage within evidence um, while these disputes were unfolding. So we'll see. I doubt that it is right. Why would you talk to TMZ if you're worried about media coverage in the jury pool? I agreed. Agreed. And specifically TMZ. Like, I would almost feel better if it was like KSL or one of the local news outlets. But I don't know. I don't even know what to say about it, frankly. It seems unwise. Um, so they're probably going to talk about this today. I don't know if the judge is going to address it. So we shall see if he says anything or if this will be a separate hearing. Judge Graf has a tendency to hold a lot of hearings and separate them out quite a bit. So it may be a separate hearing. The judge could warn this prosecutor. They could give them a formal reprimand or they could do nothing. So we shall see. Right. Arresting him does say that they think he's guilty. Like, what's the, it's not a big surprise, is it? So those are things we're going to see today. We should see this hearing go live pretty shortly. I already have a live feed for it. So don't have to worry about finding one today because there is one. Yay. Didn't think we'd have a problem on Tyler Robinson. So I'm going to pop off here. The hearing should start here pretty shortly. And I just want to say, welcome, squad. Glad you're here. I'm very curious to see what we're going to hear about today.
take me a moment to set up a couple things here. Appreciate your patience. All right, court is now in session. Video recording may begin. Calling case number 251-501-576, State of Utah versus Tyler James Robinson. Counsel, could you please enter your appearances?
Chad Grunander, Lauren Hunt, Ryan McBride, and Chris Ballard for the state here in the court today, Your Honor. County Attorney Jeff Gray is joining via WebEx, although I don't believe he will be making an appearance at today's hearing.
All right, thank you and good morning.
Good morning, Your Honor. Kathy Nestor, Michael Burt, Richard Novak, and Stacy Visser here on behalf of Mr. Robinson, who is seated beside me.
Good morning to defense counsel. Mr. Robinson, good morning to you as well. All right, before addressing the business that's before the court today, I want to address some preliminary matters. First, with respect to courtroom protocol, to maintain security and decorum, and the individual who exits the courtroom during these proceedings will not be permitted to re-enter until the recess. So I just want to give you that heads up. All counsel are expected to take reasonable measures to safeguard confidential communication. Such measures may include the use of screen protections on electronic devices and care to avoid the inadvertent capture of privileged or private discussions by recording equipment or by those present in the courtroom. Second, I wish to address the camera operator and still photographer, if you would both come forward. All right, so I don't mean to cause you any discomfort, but I just want to ensure the expectations of how we're proceeding today. Could you state your names and your respective roles, please?
Trent Nelson as the still pool photographer for the Salt Lake Tribune.
Thank you, Mr. Nelson.
Adam Fondren, video pool for ABC4.
Thank you. All right, have you both reviewed the court's standing decorum order dated February 24th, 2026?
Yes.
Yes, Your Honor.
And do you understand the requirements set forth in that order as it applies to your activities today?
Yes, Your Honor.
All right. Do you require additional time to review the order or to adjust equipment to ensure compliance?
No.
No, Your Honor.
All right. Do you anticipate any difficulty with complying with the order?
No, Your Honor.
All right. Well, Mr. Nelson, Mr. Fondren, I appreciate your cooperation. Thank you.
Thank you.
Turning next to discovery, counsel for the state, could you give an update?
Your Honor, on April 3rd, I filed a notice of the state of discovery with the court. I don't know if you've seen that, but I attached to that filing a 225-page document that lists the discovery that had been provided as of April 1st of this year. There's over 20,000 files. That document has about 100 files per page listed. Discovery continues to come in. I believe it was March 26th, the defense counsel sent a discovery letter requesting special discovery or specific discovery of materials, case files, underlying data, and so forth of lab materials from scientific reports. We're going to address some of that in the motion to continue the preliminary hearing today. Those materials have been requested from the FBI and ATF labs. Both laboratories are responding to that. They're reviewing it and they're providing information. As of Saturday and Sunday of this week, ATF, or some weeks ago, ATF provided to SBI their entire lab files, their entire case file. On Saturday and Sunday of this week, SBI was able to process much of that material, and we were provided at our office about 1,700 files from the scientific ATF. Just last night, I was updated that we received some more of those files, and that discovery continues. We're processing that material, bait stamping, cross-checking for duplication, and then providing those materials as efficiently as we can.
Thank you, Mr. McBride. Appreciate that update. All right, the court will now, and to the other parties, did you want to weigh in or comment on that?
Thank you, Your Honor. Richard Novak for Mr. Robinson. I think the status of the specific items of discovery that Mr. McBride was just mentioning is sort of the core of the present dispute about whether the preliminary hearing can go forward in mid-May. So I guess the best thing to do would be to reserve comments about that until the court wants to take up that motion.
Thank you, Mr. Novak. I appreciate your input on that. Well, turning to that, I do want to outline the procedure for today's hearing, and it's to do so in an orderly and efficient presentation of the issues before the court. First, we'll be addressing the motion to continue the preliminary hearing, which is set for next month. And what I want to do is I'm trying to manage time as at the same time allowing all parties the ability to present what is necessary in order for this court to make a well-informed decision. And so here's where I'm landing. As it relates to the continuation of the preliminary hearing, I will allow both sides 30 minutes to present what you wish to present to this court. This would include any allocation for rebuttal for defense. Upon conclusion of argument on that motion, the court will proceed to the pending motions concerning media access within the courtroom. Each side will be afforded up to 2 hours to present argument, examine witnesses, cross-examination, and redirect, and respond to inquiries from the court, as well as reserve time for rebuttal. So I just want to create that expectation. Knowing the expertise and experience of the parties, that's probably more time than you need, but I want to create an expectation so we know how to proceed. I encourage the parties to be succinct in presenting the evidence, and the purposes of these time allocations is for case management and not to alter or diminish any of the parties' substantial rights. Following the defense's presentation, the court will recess for approximately 30 minutes, during which time the courtroom will be closed. Proceedings will then resume with the state's presentation. If necessary, members of the media will be thereafter afforded up to 15 minutes for any responses. The court will then take a brief recess of approximately 10 minutes. Upon reconvening, the parties may proceed with closing arguments using any of the remaining allotted time. The court will monitor the time and argument will conclude upon the expiration of that time. The court anticipates issuing its ruling at a later time via WebEx, as you may come to expect, to permit full and careful consideration of the record and the arguments presented today. The scheduling of that proceeding will be addressed at the conclusion of today's hearing. The court recognizes the significance of the matters before it and the preparation undertaken by all counsel. All participants are expected to adhere to the applicable standards of professionalism, civility, and ethics. The court finds most helpful those submissions and arguments grounded in the evidentiary record and supported by controlling authority and applicable law. Counsel are expected to ensure that their witnesses conduct themselves in a manner consistent with these standards. The court will now turn to the defense. Mr. Novak.
Thank you, Your Honor. Richard Novak for Mr. Robinson. Your Honor, the three docketed pleadings that are germane to the defense's first motion to continue the preliminary hearing are our motion, which is docket number 466, the state's response, which is docket number 476, and our reply, which is docket number 493.
I can keep track of my own time, but my expectation is that I won't need all 30 minutes, but whatever I don't use, we'll see if any rebuttal is necessary.
Thank you.
So I think, if I may, the last time we were here and there was sort of a preliminary discussion about the May setting for the preliminary hearing, I think I said to the court, I don't need to reiterate what the court said to us when it set the date. But I do think, in light of the status of specific items of discovery, which I will get to, and the state's position on whether the preliminary hearing can go forward, I do want it to be clear, at least for the record, because I obviously understand that Your Honor knows what the court said, that the expression of the court back in December was that no party would be prejudiced by this setting. And I think that's important because when we look at the status of discovery with respect to the specific scientific evidence we're talking about, and we look at Article 1, Section 12 of the Utah Constitution, and we look at Rule 16, and we look at Evidence Code Section 1102, it is clear that Mr. Robinson is prejudiced by the preliminary hearing going forward as scheduled at this point. And it can't even be remedied in the next 4 weeks. I very much appreciate the update that Mr. McBride provided. He actually provided that to us before the hearing. But the bottom line is that we don't have from the prosecution team, and I'm going to explain what I think the prosecution team means in this context, data which is in their possession, which is clearly discoverable under Rule 16, which is what the Constitution of Utah refers to when it talks about appropriate discovery. And that brings up the reliability question under Evidence Code Section 1102. So there is no doubt that the ATF and the FBI have data files that represent what I'll call the digitization of DNA evidence. The DNA evidence, literally the collected evidence, is physical evidence, which is specifically addressed in Criminal Procedure Rule 16A1C. And then when it's digitized, and it may be that experts will tell me that's not the right word, but when it is converted into data that can be analyzed, data sets that can be utilized in DNA analysis, that's electronic evidence under Rule 16A1C. And we don't have that, and Mr. McBride acknowledges that we don't have that. And when I say we, I mean the defense, from either the ATF or the FBI. Now, Mr. McBride, I think, said to the court, he did say to me, that the ATF has just recently given SBI some files. SBI has turned over some of them to the Utah County Attorney's Office, but not all of them. The defense has not yet received them. So neither Mr. McBride nor I actually know if these data files, the raw data upon which all DNA analysis has been done, or have been produced from the ATF to SBI, and we don't know if it's gone from SBI yet to the Utah County Attorney's Office. The FBI has not turned over anything, according to Mr. McBride, that might include the data files, because there has been no production by the FBI in recent months in what I'll call the DNA area. We did make what Mr. McBride called a supplemental discovery request some weeks ago that set forth with great specificity the forensic related documents and materials that we want, including those data files. That's actually attached as an exhibit to our motion. But that was not the first time that we asked for these data files. And I am not casting aspersions at Mr. McBride and his team, because those data files are in the possession of their federal law enforcement partners. We're not asking somebody to go looking for a needle in a haystack. Hey, there might be some piece of evidence somewhere. Can you go looking? We know that these data files exist because we have summary FBI and ATF reports summarizing the data analysis that go all the way back to September. So I actually think that one of the questions, if I may, one of the questions, because counsel don't ask each other questions in the courtroom. We understand that all questions are asked by the court. Why hasn't the FBI turned over these data yet? And why hasn't the ATF clearly communicated until very recently whether it has and why it has not? The state's opposition to our motion does not explain why the data files have not been turned over. So now what I want to talk about is the significance of the data files. We have a right at a preliminary hearing to both examine and cross-examine witnesses. And our right to present witnesses includes presenting expert witnesses. If the state doesn't want to call the forensic examiners at the FBI and the ATF to testify about their analyses and the conclusions, that's their choice. But we have a right to present evidence that gets at these DNA issues, and we have a right to do that through expert witnesses. We cannot do that when the law enforcement partners, ATF and FBI, have not provided us with appropriate discovery. That's the word, that's the phrase in the Constitution, appropriate discovery. So that appropriate discovery is the gateway to reliable hearsay at a prelim. It is meaningless for us to have the right under the code to present and cross-examine, present our own witnesses and cross-examine witnesses when we don't have the electronic evidence, that is these data files, that comes from physical evidence, the DNA swabs. It's a meaningless right, and it frankly makes a mockery of the reliability concept. We have identified for the court in public pleadings 2 DNA experts who we have retained who are waiting for these data and for other materials so that they can advise us on whether the opinions expressed in these reports, these are ATF and FBI forensic reports on the results of their DNA analysis, whether these reports are reliable. And if they are, if they're not, cannot be determined without that underlying data, those underlying data. So we have the experts, they're waiting for the data. We don't have the data. It's not Mr. McBride's fault. It's not SBI's fault. It's the law enforcement partners who have had these data files since September. Like, it's been over 6 months. And many of the DNA reports that they produce are also dated September. And I could go through each one of them if necessary, but maybe I'll do that in rebuttal because I don't want to run out of time. So we can't present any expert testimony on DNA without having the underlying data. Second step, if the state doesn't want to call the forensics examiners from the ATF and or the FBI as witnesses, we also have the right to call them as witnesses. We have a little bit of a jurisdictional problem because we're in state court and we're not in federal court. And so we have these TUI regulations, which I'm sure the court is familiar with and are addressed in our reply brief. And I have personally been in contact with counsel for the ATF and counsel for the FBI who have not said, yes, we will make these witnesses available. They have said, why don't you get us some subpoenas, which are, by the way, not enforceable, but they're subpoenas. And could you give us a more definite statement of exactly what you want them to testify about? But I can't examine those witnesses without the data and without the data files being evaluated by our DNA experts. The state suggestion that we just put these reports in through Rule 1102 before really calls into question the concept of reliability, because there is no way for this court to evaluate the reliability of those conclusions. There is no adversarial testing. If I don't have those data, if I haven't been able to give those data to our DNA experts, if they haven't been able to tell us what they think of the data vis-a-vis the conclusions in the reports. So we have a problem with adversarial testing. It's a critical stage of the proceeding. We are basically handcuffed under the state's proposal, which is the court receives into evidence reports which we cannot in any way address the reliability of. And so this actually goes all the way up to the Utah Constitution, which says that reliable hearsay is admissible if we have appropriate discovery. Appropriate discovery, again, is the constitutional phrase. But it also implicates, because it's a critical stage, Mr. Robinson's Sixth Amendment right. And as I addressed in our reply brief, the heightened reliability concerns that the Constitution reminds us of in any capital proceeding. And heightened reliability isn't just reserved for penalty phase. And I provided the court with a number of cases which talk about heightened reliability being something that is a gloss over the entire proceeding. So the court, in my opinion, needs to, and in light of the law here, needs to say to the state, I can't do the prelim until the defense has the data files in a reasonable period of time. When are we going to get the data files from the ATF and the FBI? And if Mr. McBride, given all of his due diligence, can only say to the court, I don't know, because the FBI hasn't told us when, and the FBI hasn't told us why, then we're just going to have to wait. We're not interested in postponing this for the sake of postponing this. We're interested in having a meaningful testing of expert reports, which the state wants the court to just receive into evidence under 1102b4. And that's not reliability. That's not reliability under the constitutional test, which requires appropriate discovery first. It's not reliability under the 5th, 6th, and 8th Amendments. And I'm not in the business of telling the prosecution in any jurisdiction how they should do their job. But the state chose to proceed by way of preliminary hearing instead of proceeding through a grand jury. And this is where we are. We have a right under the Constitution to have appropriate discovery before this court receives into evidence what the statute says is reliable hearsay. And if the court says, oh, you don't need the data files, then we believe that 1102b4 is unconstitutional, as applied in this case. If we have the data files and a meaningful time to evaluate them, then the state has fulfilled its obligations under the Constitution, and the reports can be received at least statutorily as reliable hearsay, subject to our right to present evidence through direct witnesses and through cross-examination. So I think other than what I've said so far, I would be repeating myself. And if I've not used my 30 minutes, then I'll save the remainder for rebuttal.
Thank you, Mr. Novak. Turning to the state.
Is that okay if I disconnect it?
Yeah, sure.
Trina, do you mind allowing me to present? Your Honor, the court should deny defendant's motion to continue the preliminary hearing simply because the reason the defense has requested to continue the preliminary hearing really has nothing to do with the preliminary hearing. It's unnecessary, the continuance is. It's necessary to expert discovery, it's necessary to expert notice, it's necessary to a 702 hearing, it's necessary to a trial determination of the weight to give to expert testimonies, but it is not necessary to a preliminary hearing. Now, before I jump into my argument, Your Honor, is my screen sharing? Yes, can you see it there, Your Honor, on your?
Well, let's see.
We're not seeing anything at council table.
I'm not sure if it's being presented yet.
Make sure I've got my settings right here too. Well, I'll assume that will come up as I'm talking, Your Honor. But before launching into my argument, I want you to understand my structure here, okay? My first point that I'm going to make is the defense has not shown that a continuance is necessary to the purpose of a preliminary hearing. Maybe necessary for other reasons, this material, but not necessary. Maybe this material and discovery of this material is necessary for other purposes, but not for the limited purpose of a preliminary hearing. And the second point is the rules don't require expert notice before the preliminary hearing. Look at Article 1, Section 12, Rule 16, Rule 7B, Rule 1102. They don't require expert notice before the preliminary hearing. Now, I want to start with that first point, which is the real standard, the salient principle from whether it's Longcrier or Lopez is you don't grant a continuance unnecessarily, right? Axiomatic, right? That's the salient principle from those cases. That's what common sense says. You don't unnecessarily continue a hearing, right? Why? Well, because it causes delay in the proceedings. In this circumstance, this is not a nominal delay. We're talking at least 6 months for the defense to get this material, review it, and consult their experts, and for their experts to be ready to present expert testimony. But more likely, even more than that, because there's litigation surrounding some of this expert investigation. One of the tests right now has not been performed because there's an objection to it. We're waiting to litigate that issue, depending on what some of the expert discovery shows. In addition, we're probably going to object to some of the expert discovery requests the defense has made and that they made on March 25th. So this is at least a 6-month delay, probably much longer than that, because some of these expert issues have to be litigated. And when you consider the purpose of the preliminary hearing, right, it's an initial stage of this process, right? It's designed to protect a defendant from having to sit in custody and wait for all the trial preparations without there being any showing of any evidence, right? The Rule 16, the preliminary hearing is designed to ferret out groundless prosecutions. Probable cause is a very low standard. Reliable hearsay is admissible. The court doesn't weigh the evidence at this stage. And that's because this is a very early stage of the proceeding. And the rules contemplate discovery and investigation ongoing throughout and even past the preliminary hearing and even all the way up until trial. So the question is a continuance necessary for the purpose of a preliminary hearing? And to understand that, you have to understand two things. One, what is the purpose of the preliminary hearing? And two, what is the evidence that's likely to be presented at the preliminary hearing? And then you get to three, is a continuance necessary? First, the purpose of a preliminary hearing is clear. There's very few principles in Utah law that are more clear than this. There is one purpose to the preliminary hearing and one purpose only, and that is to determine probable cause. Every time a defendant or a trial court tries to expand the preliminary hearing beyond that, whether it's on constitutional due process grounds or discovery grounds or something else, the courts uniformly and repeatedly reject those arguments. There's only one purpose. It's clear in the Constitution. It is to determine probable cause. It's not a discovery hearing. It's not a due process notice hearing where the defense learns what the state's theories are, what evidence the state is going to present at the trial. It is not a suppression hearing under the Fourth Amendment. It's not an admissibility hearing under the rules of evidence. And it's certainly not a 702 hearing. It is only one thing, a probable cause hearing, and that's it. That's important because that relates to what a continuance being necessary means, right? Can the defense show they need to continue this hearing because it's necessary to a determination of probable cause? If they can't, it's unnecessary and it's going to infringe on the victim's right to a speedy trial, as well as the state's ability to present the case. Justice delayed is justice denied, as the saying goes, and that's because it affects a victim's right to a speedy trial. It affects the public's perception of legitimacy of the prosecution and the judicial system, and it has real effects on the evidence that may be presented at trial. Witnesses become unavailable, memories fade, evidence grows stale. And so the court should not be granting a motion to continue and delaying the proceedings unless it's necessary, especially for such a lengthy period. The next stage in understanding whether or not a continuance is necessary is one, understanding the purpose, the limited purpose. Two is what's the evidence going to be at the preliminary hearing, right? Because if you understand what the evidence is going to be, then you can determine, well, is what the defense wants to present, is that going to affect the probable cause determination, right? The only way to know that is to know kind of what the evidence is going to present. That's why Lopez says you listen to the evidence first, and then you should consider, in that case, whether or not the defense should be able to subpoena the victim. Listen to the evidence first, then you ask the defense, well, what are you going to present? And will it be necessary? Will it be relevant to a probable cause determination or not? Put another way, will the defense be able to show that whatever evidence they want to present is likely to defeat probable cause? If they can't make that showing, it would be an unnecessary continuance. So let me give you a proffer of what the evidence will be at the preliminary hearing. There's really four categories of evidence. The first is surveillance from UVU. Now, UVU has a great surveillance system, and they capture the defendant coming on to campus at about 7 a.m., or I think about 8 a.m. Okay, it's clearly him. He's driving his gray Dodge Charger. I should say he's from St. George, so this isn't just a casual passing by Utah Valley University. This is a 3.5-hour drive from his home, 250 plus miles from his home. They capture his car pulling into the Utah Valley University parking structure. He gets out of the car. He's wearing his favorite Hurley hat, a maroon t-shirt, shorts, and Converse shoes, the same clothing he's wearing when he turns himself in the next day. Clearly him. There's good facial images and everything. He walks around campus and he scouts campus out. He then leaves the campus. UVU surveillance then captures him return later. He returns on foot right before the Charlie Kirk event. He's wearing a disguise of sorts. He's wearing a baseball cap, different baseball cap, pulled low. He's got sunglasses on, a different shirt, different pants, but the same Converse shoes. That's all seen in the surveillance. He's limping because there's a rifle down his pants. The surveillance captures this individual. Again, I don't want to overstate the evidence because the pictures of his face at this time are not as definitive as they were earlier because of the sunglasses and the hat. But it captures his face, captures his appearance, his height, his build, all consistent with how he looks earlier in the day and how he looks today in court. But he makes his way to the rooftop, makes his way to the sniper's perch on the rooftop, takes the shot, and then runs to the northeast, drops off the building and runs the northeast of campus into a wooded area. That's all captured on video. Okay, that's the first category of evidence, is the video surveillance that shows the defendant on campus taking the shot. The second point is circumstantial evidence tying him to the rifle. Right, in that wooded area, police find the rifle. In the rifle is wrapped in a towel. In the rifle, they found 4 rounds, and these are 30-06 Remington rounds that have, 1 has been fired, 3 have not, consistent with the shot at Charlie Kirk. And all of these rounds are unique in that they have inscriptions on the brass. There's etchings on the brass with little political messages. Well, after the defendant turns himself in, there's a search warrant at this house. In that house, police find a Dremel tool, and they also find the same make and model of ammunition, Remington 30-06. And not only that, but one of these rounds has etching on it, consistent with the etchings on the rounds found in the rifle, right? The etching found at his house says test shot, right? So that's the second category of evidence, is the circumstantial evidence tying him to the murder weapon. The third category of evidence is confessions. The state will present evidence that he left a handwritten note at his apartment for his lover to find. In that note, he says, I had the opportunity to take out Charlie Cook and I took it, right? This note was written before he left St. George and came to Orem, and was left in his apartment. His roommate finds it, roommate/lover finds it, and this initiates a text message conversation back and forth between the lover and the defendant, where the defendant says, yeah, I shot Charlie Kirk. And I'm summarizing. Shot Charlie Kirk. I left the rifle behind. I had to leave the rifle behind, but I'm going to pick it up and then I'm coming home. Then he also confesses to a group of friends on a messaging application. Before he turns himself in, he says, hey guys, it was me. I did it. Thanks for all the good times. Goodbye. And the final confession is an acquaintance, is a former law enforcement officer, and he helps arrange the defendant turning himself into the sheriff's office. And when he's talking to that former law enforcement officer, he says, I got rid of the clothing I wore. Right? So there are 3 categories of evidence that have nothing to do, that show probable cause, have nothing to do with the DNA evidence, which is what defendant's issue is here. The 4th category of evidence is that DNA evidence. And you have to understand what that DNA evidence is. The towel that the rifle was found wrapped in was sent to the FBI lab for testing. There was also a screwdriver found on the sniper's perch that was also sent to the FBI lab for testing. The rifle itself was sent to a different lab, the ATF lab, for DNA testing. And both labs tested those materials completely independently of each other, different analysts, different labs, different locations. Both of them come back showing the defendant's DNA on those materials. Okay, the screwdriver, the towel, and the gun. I say they found the defendant's DNA on those materials. The experts and the reports that we'll present at the preliminary hearing were much more precise than that, right? Really what they say is there's astronomical odds that this DNA belongs to anyone but the defendant. But you'll see that, and I think you take my meaning here. The point is that there is substantial evidence of probable cause, far exceeding what probable cause requires. And it comes from a variety of sources. And so the defendant cannot show that the material he wants to present at the preliminary hearing would defeat probable cause. And in his reply, he says, well, that's circular, because how could we make that showing if we don't have the underlying data to be able to attack the DNA evidence? Well, first of all, that attack wouldn't even affect those first 3 categories of evidence, right? The confession, the circumstantial evidence tying the defendant to the rifle, or the video evidence, right? But even if they were to find some expert that would say both labs independently got this wrong, and even if they're to find that kind of expert, which I think is speculation and probably against the grain, but regardless, you take that assumption, it still wouldn't defeat probable cause, because at this stage, the court doesn't weigh contrary evidence, right? The standards are very clear. At this stage, because it's such an early stage with such a limited purpose, the court views all evidence in the light most favorable to the state, right? That's State v. Virgin. So in summary, the defense has not shown that the motion to continue is based on the purpose of the hearing, a fair determination of probable cause. They just haven't shown it, and they haven't even tried. And I think one of the reasons they haven't tried is because they know that these are experienced practitioners. They know what the standard is here. It's low. The evidence is viewed in the light most favorable to the state. They're not going to be able to defeat a confession, multiple confessions nonetheless, or DNA evidence, right? And if the continuance was granted, it would affect the victim's right to a speedy trial. And frankly, like the Lopez case, it would obviate the repeated and express admissibility of reliable hearsay at preliminary hearings. And that leads me to the second point, which is a textual analysis. So the defense says, well, Article 1, Section 12, Rule 16 require expert discovery before the preliminary hearing. Let me try to see if my computer will present again.
It's not outputting video.
Let's see. I'm showing it's connected. Oh, there we go. Great. Okay. So let's look at the text of the rules, right? Utah Constitution, right? Here it is. Article 1, Section 12. Where the defendant is otherwise entitled to preliminary examination, the function of that examination is limited, right, to one purpose, as I said earlier, to determining probable cause. Nothing in this Constitution shall preclude the use of reliable hearsay evidence as defined by statute or rule, in whole or in part, right? In any preliminary examination to determine probable cause, if appropriate discovery is allowed as defined by statute or rule. Is it allowed? Well, Rule 16 allows it. That's the end of the inquiry. Well, the defense says, well, no, but it has to be complied with, and that's fair, I guess. So let's look at Rule 16. So here's what Rule 16 says. Look at the mandatory disclosures, and there's a distinction here that I think is important. One is the use of the language here, prosecution team. When we talk about mandatory disclosures under A1, we're talking about what the prosecution team has, right? Prosecution team has been interpreted in case law to mean the prosecutor as well as the law enforcement people who are working on this case. But if you go down to the timing of mandatory disclosures, it's different language that's used here, right? And I've highlighted the portion that applies here. 8, there it says, in every case, all material or information listed under paragraph A1 that is presently and reasonably available to the prosecutor must be disclosed before the preliminary examination. Okay, the different language is the prosecutor versus prosecution team. Had the Supreme Court Rules Committee, and as approved by the Supreme Court, had they wanted this to mean full discovery of everything in everyone's possession before the preliminary hearing, they would have said so, right? The rules of statutory construction say you presume all omissions are intentional, right? They use distinct language here, and they did it for a reason. The reason is because the preliminary hearing is such an early stage of the proceedings, right? We all know investigation at the preliminary hearing stage is continuing. We all know the state, the prosecutors are still getting material from the investigative agencies. We know investigative agencies have processes for getting reports and approving reports and disseminating reports. We know expert witnesses, oftentimes by the preliminary hearing, haven't even started their work, right? The Rule 7B says the preliminary hearing has to take place within 14 days where it's requested, right? This is a very early stage of the proceeding designed to protect the defendant from having to sit in custody where there's no showing of probable cause. And the rule itself, Rule 16, makes clear that discovery is ongoing. It foresees that discovery is going to be ongoing throughout the trial. So the defense argument that Rule 16 requires full discovery of this material before the preliminary hearing is a contra-textual reading. But even so, you look under A1, and what does A1 actually require as mandatory disclosures? Well, there's a specific provision that talks about scientific tests and experience. It's A1B, reports and results of any physical or mental examination, of any identification procedure, and of any scientific test or experiment. We provided those reports, okay? What the defense wants is complete and total expert notice and expert discovery. We've even complied with A1 as it relates to what the prosecution team has with regard to the reports. Okay, so Article 1, Section 12 doesn't require discovery before the preliminary hearing. Rule 16 doesn't require full, complete discovery before the preliminary hearing. Well, is there any other provision of authority we should be looking at here? Well, how about the provision of authority that is directly on point with regard to expert notice? Let's take a look at that. 77-17-13. 1A, if the prosecution or the defense intends to call any expert to testify in a felony case at trial or at any hearing, excluding a preliminary hearing held pursuant to Rule 7, the party intending to call the expert shall give expert notice, right? It's hard for the defense to make an argument that expert notice is required before the preliminary hearing when that's not even an against the grain reading. That's a completely contrary reading to the statute directly on point. The court would have to find that this section does not apply, and it's just impossible to do that. Well, the defense may say, well, we're not requiring expert notice. What we're asking for is just discovery here. Well, no, what they're asking for is, in fact, expert notice. Rule 77-17-13 talks about what expert notice is. If you look at B, right, it's a CV of the expert, the report, written explanation, and then 2 says an expert's anticipated, if it's based on specialized data, the witness shall provide the opposing party the information of that specialized data upon request. Well, the expert notice request, let's see if I can find my list here. What's this one? Let me give you a list of what the defense requested in their March 25th request. And I should mention, the defense is right. This was not the first time they asked for this material, but when they asked for this material, this specialized data underlining the report, I responded by saying, look, I don't know exactly what you want. You know, you talked about like certain software files and stuff like that. Will you please put it in writing so I don't lose what you want in the translation? And so they did. So on March 25th, they gave me this supplemental discovery request, and that's what I've relayed to the agencies. But what they want is lab case files that the government intends to use in its case in chief. I should note that the FBI has provided a lot of this material already. I provided a case file that's 380 pages long. I think they're back in October, as well as about 77 other files that list their policies and procedures. And those are listed in that 225-page document that I attached in my April 3rd filing. But they list CVs of analysts, accreditation documentation of the labs, accreditation documentation of the programs used to interpret data, standard operating procedures and protocols, STR databases and frequency tables, chain of custody documentation, data files underlying the analysis, software names and software versions used, developmental validation of instruments and processes, internal validation of instruments and processes, proficiency tests of analysts, audit records. All of that material may go to expert qualification, the qualification of the labs, the methodologies, may go to 702 issues, but it doesn't go to probable cause, okay? Especially when you've got to view this evidence in the light most favorable to the state. And the final reason why we know that expert discovery, expert notice is not, oh, I didn't finish my point here, which is this material they're requesting is expert notice. Like that's what they're requesting here is expert notice under 77-17-13, which expressly does not have to be given before the preliminary hearing. And I should say, regardless of the fact that we're not required to give expert notice before the preliminary hearing, we're doing our very darndest to do so. And we shouldn't be penalized for being on the ball and getting ahead of things by trying to get the expert reports and investigation done as soon as we can. To the contrary, that's the kind of behavior and due diligence that should be encouraged and incentivized. And if you say, no, you can't have a preliminary hearing until all of that is done, it does create chaos in the system, because it says, if I want to have a preliminary hearing early, I'm going to stop my investigation once I hit probable cause, because then I don't have these discovery problems before the preliminary hearing. And that is not the type of conduct we want to incentivize. And the rule doesn't incentivize that conduct. And this comes to my final point. The defense knows it. Okay. I know that Mr. Novak has made his argument here, but the defense knows that this kind of material is not required before the preliminary hearing. And how do we know the defense knows it? Because the defense has said so. In one of their earliest pleadings in this case, docket number 16, I think it's 16, the defense counsel filed their request for discovery. This is the formal request for discovery that's filed, I think, docket 16. And in that docket, they recognize the discovery is an ongoing process. You get down to page 11, and the defense cites Rule 16 saying, prosecutor's duty to disclose material is ongoing. In every case, all material that is presently and reasonably available to the prosecutor must be disclosed before the preliminary examination, right? But here's the key phrase that I think shuts the door on this argument the defense has made. It's highlighted in red there. And I quote, defendant acknowledges he does not have a right to discovery prior to preliminary hearing pursuant to Article 1, Section 12 of the Utah State Constitution. That's it. The defense concedes this point. Now, the point I'm making is what the defense makes right here in the next sentence. However, defendant relies upon this initial discovery request through trial, post-preliminary hearing, to enforce their rights encompassed in the Utah Constitution to a fair, speedy trial. That's the point I'm making, is the state should be pursuing expert investigation, their due diligence, getting the investigation done as early as possible, and providing that discovery as it comes in on a rolling basis, right? And that's what we want to have happen. We shouldn't punish the state and the victims and everyone else by delaying the proceedings when the state does exactly what has been done here, which is getting on top of those things early, right? I think that's all I have, Your Honor. Do you have any questions for me?
I will. I'm going to turn to defense for their rebuttal and then have questions for both parties. Thank you, Mr. McBride.
Thank you, Your Honor.
We're on one piece of equipment. Thank you, Your Honor. I do want to respond directly to a number of the arguments that Mr. McBride made, but I also want to refer the court back to the accusatory pleading which initiated this case, which is the information. The information specifically relies upon two types of DNA evidence. First, the information, and it's actually the probable cause statement in the information, docket number 1. At the bottom of page 3, the probable cause statement alleges that DNA consistent with Robinson was found on the rifle's trigger. Second, the probable cause statement in support of the information says in the middle of page 6, the rifle, ammunition rounds, and towel were sent for forensic processing. DNA consistent with Robinson's was found on the trigger, other parts of the rifle, the fired cartridge casing, 2 of the 3 unfired cartridges, and the towel. We have not received the discovery, and I'm not talking about expert notice. I will address that. We have not received the physical evidence and the electronic evidence that supports those assertions made by Mr. Gray when he swore to the probable cause statement attached to the information. We are not talking about the broad scope of expert notice, of expert discovery that Mr. McBride is talking about. We're talking about physical and electronic evidence, which first, the information was based upon, as I just said. And then second of all, as Mr. McBride acknowledges, the state intends to present the limited DNA evidence that it has without even having the data files been made available to us. And I want to drill down on this very specifically because I think it's appropriate, but the state sent us, but did not file with the court, a memo outlining the witnesses they intend to call at the preliminary hearing and the exhibits that they intend to offer at the preliminary hearing. And I'm going to respect that it's their present plans, and it's not something that necessarily should be filed under seal, filed publicly. But as Mr. McBride acknowledges, that includes 3 DNA reports. We have those reports. We just don't have the data that the authors of the reports relied upon for those conclusions. And I'm not talking about their CVs. I'm not talking about their published writings. I'm not talking about their prior testimony. I'm not even talking about all of the things that Mr. McBride acknowledges we've asked for and that there may be a fight about later in terms of discoverability under Daubert, under 702. We're talking about a core data file. It's literally a data file, one from the ATF and one from the FBI that they generated back in September that hasn't been provided to us. So we can't provide that to our experts to help us assess whether or not there are reliability problems with the reports that the state wants to offer through 1102B4. So we're not talking about the slippery slope and months of litigation of Daubert type expert notice. Mr. McBride is right that at a certain time and place, there will be discovery litigation related to experts and then admissibility litigation related to experts. That's not what we're talking about here. We're talking about very concrete data files that our experts are waiting for. And when I say data files, I literally mean the digitization of physical evidence obtained from our client and from these objects. We didn't choose for the state to present DNA evidence at the prelim. That's their choice. And that's why we are having this dispute right now. The question that I think this court needs to also address is when Mr. McBride talks about what discovery is, quote, reasonably available to the prosecution. How can this court conclude that not having these data files is reasonable, given that the ATF and the FBI generated these data files from the swabs months ago? They've concluded their work, as far as we know. They've generated reports. The state believes that the reports are sufficiently final that they would offer them into evidence in a preliminary hearing. So I think this court should make the finding that those reports are reasonably available and that they should be produced to us. Mr. McBride, probably because he can't, still hasn't told the court why we don't have the data files. So where Mr. McBride, with all due respect to his advocacy, because he's a fantastic advocate, he goes into the slippery slope of expert discovery and expert notice and Daubert, and that's really not what we're talking about here. We're also not talking about the bullet fragment further testing issue, which has previously been described as the January 9th motion, which the court unsealed. That is not a DNA issue. That is about what happens to a bullet fragment when a federal law enforcement lab wants to do what they call destructive testing. It's not to get DNA off of it. It's to look at whether that bullet fragment can be related to the other evidence in the case, because the ATF's first conclusion as the courts, that they couldn't say either way where that bullet fragment came from in terms of firearms. So that is not what we're talking about here. There is a ballistics report that the state wants to offer into evidence at the prelim, but we're talking about DNA reports. And I do want to say, however, that we are not suggesting that the preliminary hearing be postponed until this dispute about the destructive testing of this bullet fragment is resolved. But it was a federal law enforcement lab that said, we're not going to permit a defense expert to observe the destructive testing, and we're not going to videotape the destructive testing. We're going to do this behind closed doors. But that's not what we're talking about here today. That's a different issue for a different time. And I don't think it has anything to do with when the preliminary hearing occurs.
Mr. Novak, just to be consistent, do you have some final thoughts as your time is coming to a close?
Yes, thank you. My final thought is that this court should direct the state attorneys to find out when the data files will be produced. And once we know that date and they actually are produced, then we've already told the court that there's a concrete amount of time that our experts need in order to analyze them. Otherwise, I've already argued about the constitutional legal principles that are at stake here, and I think that the court has those in mind. I also want to say, finally, the Lopez case has nothing to do with this. I understand it's a Supreme Court decision, but the Lopez case is about a defendant who tried to serve a subpoena on the victim of a sex offense to have the victim testify at the defendant's prelim. That is not what this is about. We're not fighting about a subpoena. We're not talking about victim testimony. It's really not applicable. Thank you, Your Honor.
All right. Well, I'll have questions for both of you. I'll start with Mr. Novak. Again, thank you both for your presentations today in such a succinct manner. The court appreciates that. So one of the questions that's before the court, and Mr. Novak, it goes to the heart of the matter for this court as the court is weighing whether the continuance should be granted or not. Has defense reviewed all the discovery that has been presented up until this point in preparation for a preliminary hearing set for next month?
We have reviewed the discovery that is tied to the exhibits that the state intends to offer at the prelim where there is discovery available. If the court is saying, have you reviewed the thousands, have the lawyers reviewed the thousands and thousands and thousands of pages of discovery that are well documented in the index that Mr. McBride provided the court privately? The answer is no. Our paralegals are doing their best to organize it, but have counsel reviewed that discovery, and have we had a reasonable time to do so? No, because it's gigantic and it's voluminous. We know that some of it has nothing, some of it has been provided in what I guess the state would call an abundance of caution, 30 days worth of of surveillance video from UVU. We don't believe that we even need to review 29 of the 30 days. So we're not going to waste time and resources reviewing hundreds of surveillance camera hours without some suggestion that we need to. And we don't believe that we do. Have we reviewed, every FBI report interviewing people who claim to have known Mr. Robinson or known his roommate? Yeah, we've reviewed all of that. Have we reviewed the forensic materials that we have received? Yes. Have we reviewed all the law enforcement reports about the events at UVU? I mean, I can only speak for myself. No. Because it's so voluminous that we haven't had that time.
Well, in really the heart of my question is, have you reviewed all the discovery that has been passed that enables you to be prepared for a prelim next month? That's that you're saying is applicable to what you understand the state will be presenting, or what you need to review. Just because the state says they're going this direction, you have to do an independent determination of the discovery on what you need to review to be prepared. And so my question is, have you done that, and are you there?
No. So for example, we received a couple months ago an external hard drive that had thousands and thousands of gigabytes, I don't even know how many, of material taken from digital devices, taken from search warrant returns from what I'll refer to as social media communication platforms, Discord and all of the others. No, I haven't had time to do that. Absolutely not. My clients, so there's a huge download of my client's cell phone. There are downloads of many digital devices. No, absolutely not.
But my question is, in order for you to be prepared, you've made the argument there's a lot, and there's no dispute that there's a lot of discovery, to say the least. But you've also said that you don't need to review it all. You just want to review what's relevant for the preliminary hearing. And so my question goes to, have you reviewed all the relevant discovery that's been passed to be prepared for a preliminary hearing that you have in your possession now?
I can only speak for myself. I'm not going to speak for other counsel, but the answer is no. The answer is no, but I am not able to, maybe this isn't the court's question, but I'm not even able to approach this fourth category of evidence that the state wants to offer at the prelim, which is the DNA evidence, because we don't have the underlying data files to be able to assess what to do about those reports. So if the court said to me, Mr. Novak, have you reviewed all the drone images that they want to use? Have you reviewed all of the video that they want to present? Have you reviewed all of the UVU surveillance? And by the way, this is a letter we received on April 4th. Have you reviewed all the Discord chats that they want to present? No. And I believe I've been diligent.
Would you like time to confer with your counsel? Because I need to know that information. I need to know that if we move forward with the preliminary hearing, either next month or a different date, that there's effective assistance of counsel moving forward. And that's one of the factors is, have you reviewed the necessary discovery? Typically in criminal cases, defense attorneys say, hey, I haven't been able to for whatever reason. And the court recognizes that, right? Like, I get it, but I need to check that box and say, okay, defense is saying we're ready to go forward with the discovery that has been provided. That's a part I want to be sure is been accomplished. And so as you're presenting for the defense, I would ask you to confer with your counsel, because I understand that you've probably parsed out different areas for each counsel given what's there, but I need that answer as it relates to the defense team.
I now understand the import of the court's question, and I appreciate that the court has clarified that. So we can we can present that information verbally. We can present it shortly thereafter in writing, however the court wants to present it. But I understand that. So I'll just give the court by way of an example. I have not personally, and I don't think any of the other counsel have, but we should probably take a short break and we can discuss that, reviewed significant portions of the electronic discovery. And when I say electronic discovery, I mean images of device downloads, as well as, sort of cloud-based information produced to the state pursuant to subpoenas for chats, postings, gaming communications. I mean, the primary platform is Discord with a capital D. It's a thing,
Sure.
right? So I think I'm just repeating myself, and maybe that's because obviously I would want to speak with my
Sure.
co-counsel
No,
and
I-
not speak for them.
And I respect that. I understand that you're being cautious and you don't want to present something that someone may or may not ever review. I respect it, and you'll be given time to do that. But that's an important factor for the court to determine.
Totally understand. I mean, we've been trying to focus on the very specific items of discovery that we don't have, which relate directly to evidence that the state wants to present at the prelim. And the court is asking, I think, very helpfully, a broader question. And the court is not challenging, the court is not really confronting us on the question of diligence. So I'm not even going to go there, but obviously there's been a lot of pretrial litigation on a lot of different issues. And as the court knows from our filing yesterday, there's more coming.
Right. No, and I appreciate that. And the court's intent is I just want to make sure that when we move forward, we can move forward properly and uphold the constitutional rights of Mr. Robinson and all parties to ensure that what we do is proper and appropriate, because quite honestly, I don't want to do it again. And so I recognize, and I can do so very diligent and have worked extremely hard. Obviously I'm not in your offices. I don't know your communications, but it is evident to me that both sides have. And so the purpose of that question is that's just a checkbox I need to know to move to that stage. And only your team has that answer. And again, and I recognize the amount of discovery that's is out there. And so it is no way to impugn defense at all, saying, well, you're not doing your job, you're not working hard. Not at all. I just want to know that answer. And so that's
I
the
appreciate
sole
that.
purpose.
And I didn't feel that the court was making those assertions. And I want to say, we hear that the court doesn't want to do it again. Mr. Robinson and his family don't want to do it again. Counsel don't want to do it again. We know that the state doesn't want to do it again. And we also don't want Mrs. Kirk and her family to have to go through it again, because that's actually, in my opinion, the greatest harm to surviving victims in a case like this is the long run when cases don't proceed as the Constitution requires.
And so going to that point that you just asked, so how do you propose the court balance your request for a potentially large, a long delay against the constitutional rights of victim representative Ms. Kirk in her right to a speedy disposition of the case? For example, I noted in your motion, you stated that your DNA expert needs, I believe it was 6 months.
That was her estimate.
And so how do we balance that? And I appreciate your statement, but going to your statement as it relates to Ms. Kirk's right to a speedy disposition of a party outside, right? Not counsel from either side, but it seems like we're going to be held to the timeline of somebody outside who's an expert who's saying 6 months. And that concerns the court about that is a potential hang up of, well, we can't move forward until we comport with their timeline. And that's concerning. So how do we reconcile that?
Well, first of all, if the expert needs 6 months, the data files were available in September, which was 6 months ago. And so I actually think, while I will answer the court's question, another important question is, why haven't the FBI and the ATF provided data files that they utilized 6 months ago? And Your Honor can't answer that question. And I can't answer that question. And obviously, Mr. McBride can't answer that question. And so I actually think, and I don't purport to speak for the victim representative, but that's a question that the victim representative should be asking, at least through her counsel, is why haven't the federal law enforcement agencies, which took responsibility for this analysis, provided the data? Not the CVs. I mean, I've actually examined at least one of these FBI forensic examiners in another case. I have her CV. That's not my issue. We cited in our reply brief the cases which show that the victim's right to a speedy trial does not, I'm sorry to use this word in the current environment, but that's the word we use, does not trump, lowercase t, the defendant's constitutional rights. We do not want the victim representative and her family to have to wait any longer than we have to wait. But it isn't sufficient for the state to say, we've turned over gigabytes and gigabytes and the defense, doesn't really need to review it before the prelim. That's not, obviously, and the court, I think, tends to agree with what I just said, that doesn't make a lot of sense. So we do respect the concerns of the victim representative and her family, but we can't constitutionally shortcut Mr. Robinson's right to the adequate assistance of counsel. And I think, as we said in our brief, when the state doesn't give us the data that their law enforcement partners have and have had for 6 months, we can't be constitutionally effective. And, and again, I keep talking about Mr. McBride because I appreciate his advocacy, but if the state didn't want to have to deal with Article 1, Section 12, the concept of appropriate discovery, this court's need to apply constitutional standards of reliability, Mr. Gray could have presented this case to a grand jury. And instead, what Mr. Gray did was he filed an information with probable cause that relies on multiple assertions of DNA results. We should have had that discovery under a different rule immediately. If he had reports that are based on these data files, when he filed his information and probable cause, those data files existed. Those data files must have existed on September 15th or whatever the date of the information was. And here we are past April 15th. So I will confer with my colleagues on the court's question. We will obviously answer it because it's an important question. If the court has other questions for me,
I do. And
I'm
so
prepared.
going to the state's argument that there's these 4 prongs that can be pursued in regards to the categories of evidence, and that the standard is clearly articulated in State v. Virgin, and so my question for you is, if the state's presenting evidence that can meet the standard in any of the 4 prongs, is it necessary that all the discovery for all the prongs be turned over in order for the defense to be ready to proceed at the prelim?
I'm not going to speculate about how the state's presentation at a preliminary hearing would go as to prongs 1, 2, and 3, nor could I concede that without seeing the way the witnesses testify and which reports are actually received into evidence that they establish probable cause. It's the state that wants to present DNA evidence through summary reports, not through the witnesses who wrote the reports, not through their own state lab analysts. So it's not for me to comment on categories 1, 2, and 3. I understand what Mr. McBride is representing, but I can't comment on what this court will think of that evidence. but it's the state's decision to present 3 different DNA reports, at least at the current time, according to the memo that they gave us earlier this month. And it's their federal law enforcement partners who have not complied with that reasonableness test. And that's got to be imputed to the prosecution because we don't have it. Nobody's accusing anybody seated at council table or over there of stalling out anything. And I think the court deserves to know why the FBI and the ATF haven't turned over these data files.
Well, I mean, I understand, but that doesn't get us to where we are today. The why doesn't help us right now.
Well, the why might tell us when. I mean, your Honor is absolutely right. The better question is when. And then when we get them and our experts look at them, maybe there is a refined assessment about how long that takes.
So my final, I'm sorry.
No.
My
That's
final
all.
question is I'm trying to avoid a slippery slope of, wait, we need one more thing. We need one more thing. We need one more thing. Are you saying, my understanding is, and I have, I understand to a small degree, given my experience about what you're requesting. You're requesting the lab notes, like all the underlying data that was put in to generate the DNA reports and the findings. Is that my understanding? What you're requesting is that is still outstanding?
What is actually outstanding is, yes, but most importantly, the data, the electronic quantification, digitization of physical evidence taken from our client and certain objects that leads these forensic examiners to conclude that there are matches. Mr. McBride says, oh, there's 2 different things, and so they're both right because they each independently reach the same conclusion, but they're testing different objects in different labs with different protocols. We don't even have those data. Yes, with respect to the court may be asking me a question that is better addressed by Mr. Burt because he's the one who specifically crafted the discovery request, and I know that Mr. Burt has reviewed more of the DNA forensic discovery than I have, but I can tell the court that without those data files, we can't even start to analyze, to understand, to appreciate the conclusions, the statistical analyses, the roots of those tests. So yeah, the bench notes and the protocols that were followed, yeah, that's all important, but we don't even have the data files. And there's no reason that I am aware of that has been provided why the ATF and the FBI, first of all, the ATF, why they provided it in the last 3 weeks and why the FBI still hasn't. And so I don't think it's going to be a dribble of this and that and this and that. It should have all been produced, some of it 6 months ago, because we have DNA reports from September of 2025 that Mr. Gray relied upon for his information.
I guess what I'm trying to do is I want a bright line of saying this is exactly what we're requesting, and it's the court's decision if that's necessary or needed to proceed with a preliminary hearing. I just want it to be so clear that we know, okay, it is, hypothetical. We need a blue pen that is Bic or whatever that is so definitive there is no question, because what I'm trying to avoid is, well, okay, they provided this, but it's not exactly it. They provided this is not exactly it. And I respect your position. I understand it. I just want to make sure there's no ambiguity. And that's why I'm trying to distill this to its finest point so I know exactly what you're asking. Because when you say data files can be anything. I want it to be clear as day so nobody can say, well, I didn't realize it was that. And you're saying the FBI hasn't turned over the data files. That is a very broad statement. And so I want to make sure we distill it to, it is this exactly. So the prosecution can say, okay, well, if we need to communicate with our their federal partners, then they can, and they can say, this is what we needed. But if it's just a broad, we're missing data files, that's difficult for the court to weigh whether it is actually necessary in order for the preliminary hearing to proceed.
So I think then what the court is maybe requesting or maybe suggesting is that there's going to be a continuum from what data we need in order to be constitutionally effective at this prelim versus the continuum from that all the way over to what is more in the nature of expert notice, 702 Daubert issues before a trial. And as long as the state's position is none of what you're requesting, not even the digitization of the DNA taken from Mr. Robinson and the DNA lifted from these objects, if the state's position is that that's just Daubert discovery, then we can have the conversation with the court and we can give the court our view of where the line is between what is data that should be reasonably available to us now versus what is Daubert. But Mr. McBride's position is we don't even need the digitization of the DNA swabs in order for this preliminary hearing to go forward. So if the court, I'm not trying to obviously put words in the court's mouth, but if the court's saying, I'm not going to go that far, but I need to draw a line somewhere, then we can take our discovery letter, which we gave Mr. McBride, and we can tell the court, these are the things that we think we need in order to be able to go forward in the preliminary hearing, and we acknowledge that these other things are more akin to expert notice, Daubert, and Rule 702 issues. We can do that, and it wouldn't take long, but and I think it's an appropriate way for the court to say, I'm not able to guarantee Mr. Robinson effective assistance of counsel at a preliminary hearing until the defense has these pieces, and the others can wait. So I understand the court's question, but it does require looking at a 3 or 4 page discovery letter and drawing a line somewhere, or maybe it's yes, no, yes, no, yes, no, or you know what I'm saying.
No, but to be quite blunt, that was the hope of the court for today. You're asking for the continuous because some discovery hasn't been provided, but I want to know what that is in order for the court to weigh that.
Well, we will do that today. We'll do it the moment the court wants to take a break. We can do that,
Okay.
and we can tell the court these are the things that we think that all the different authorities that I've cited require now versus the things that Mr. McBride is saying are expert discovery. And then the court will make its determination of which bucket each of those items goes in.
Sure, I appreciate that.
I think that's fantastic.
All right, thank you, Mr. Novak. I think I've asked plenty of questions. I want to afford the other side the
Always open to
opportunity
questions, Rob.
to have that same experience. All right. All right, turning to the state. All right, so the defense has emphasized that this is a capital case which triggers an Eighth Amendment requirement for heightened standard of reliability at all critical stages of the proceeding. How does the state's proposal to proceed with highly technical, uncross-examinable forensic hearsay reports without defense having access to the underlying data, I use that word loosely, satisfied this heightened constitutional requirement and the defendant's Sixth Amendment right to effective assistance of counsel?
Well, my tendency is to say, well, if you require these experts to come in and testify, we're doing the same thing that happened in Lopez, that was rejected by Lopez in obviating the admissibility of reliable hearsay. And I don't think that just because it's a capital case, you throw, the baby out with the bathwater here. The rules are the rules, and they satisfy constitutional muster, and they don't change because it's a capital case. Should we pay special attention to them? Absolutely, we should, and we should keep in mind what's at stake here. But it doesn't mean there's a completely separate set of processes and rules that apply to a capital case, right? It's just that we are very rigorous in the analysis of how we apply those same rules to these facts. So I think reliable hearsay is still admissible, and that's where we are. The rules govern, and the rules clearly don't require expert discovery and expert notice before the preliminary hearing. I don't think there's any way to read the rules to require that.
All right. One of the other issues that's been brought up is defense argues that the FBI and ATF act as your law enforcement partners and therefore are part of the prosecution team. How do you reconcile your position that you only need to provide what is physically present and reasonably available to the prosecutor under Rule 16A2 with the broader definition of the prosecution team? Does the state have an affirmative obligation to compel its federal partners to produce the underlying forensic data for this hearing?
I don't think for this hearing. I think the state does have an obligation, absolutely. I think that obligation, the case law is very clear that obligation certainly applies by trial, right? We've seen numerous cases reversed because the prosecutor has not gone out and gotten material that's in the possession of a law enforcement officer. Some of that stuff, the prosecution probably couldn't have gotten anyway because it was hidden by police officers, right? But yeah, certainly by trial, the defense is entitled to all this material. I can't say all of it because there's probably going to be some objections to some of the material they've requested, like the source code for some of the proprietary software developed in this case or used in this case. But they're entitled to most of that stuff, and we're going to provide it. And that because that's the basis of 702 hearings and also admissibility under 702 and weight questions at trial. But at the preliminary hearing stage, no. The state does not have the same obligations, the same discovery obligations that apply at trial. Now, that doesn't mean the state can put its head in the sand either. What I think is important under Rule 16 is what is reasonably available to the prosecutor. And that's what we're doing here. The point of my April 3rd filing was to say, Judge, look at our over 20,000 documents or files that we provided to the defense. You can see in there, and we asserted at that time we'd provided approximately 100% of the materials that we have, right? And you can see that we're not burying our head in the sand and saying, don't give us anything else, guys. We don't want to know. No, we're saying, give us everything. And as soon as stuff comes over, we send it out. And you can see in there the dates that we receive materials and the dates that we push them out. And we're talking within a week, generally speaking, sometimes within days, no longer than probably 2 weeks. We're pushing everything out that we get. And so what is reasonably available to the prosecutor? What does the prosecutor have in his possession? Those are the materials that we've provided, and we've satisfied Rule 16. What we can't do is bury our head in the sand and say, don't give us anything else. And that has not been what's happening here. But neither do the rules require complete expert discovery and discovery of these highly technical data files. And that, your line of inquiry with Mr. Novak just a minute ago raises the importance. Yes, the defense, I can't tell you the first date that we had an oral conversation where they said, hey, we need the data files. And I remember a conversation we had, I can't remember, Mr. Bird, if it was with you or Mr. Novak, and I said, well, look, assume I'm an idiot. I don't understand what data files are. Tell me exactly what you need. And they say, well, we need the software files that can be used in the software program so our experts can run it. Okay, put that in writing so I understand and don't misrepresent what you want. And so when did they put it in writing? March 25th. So once I got it in writing, that's when we started looking through. I looked through my file and analyzed, do we have this stuff? Have we provided it? Help me understand what's going on. And after I did my analysis, I sent it off to the labs and said, hey, I've done my analysis of what I think we've provided here. Will you guys look at this and see what you think you've provided? And then tell me if if you haven't, get it to me. If you're not going to, tell me why. And we had that communication. We had a communication about that this week with both ATF and FBI. And I think a lot of this material they've requested, we have provided it. Some of this material is provided clear back in October, most of it. A 380-page digital case file from the FBI, disclosed October 24th, debate stamp 79, CVs of 3 of the analysts from the FBI. There's case notes were provided October 24th, that's Bates 122, and Bates 845 to 848. 73 files of policies and protocols, validation, testing procedures, analysis, proficiency procedures, provided October 24th and on December 9th. Now, the ATF lab, they were continuing to do investigations, or excuse me, not investigations, but expert scientific work on this case until the end of February. They chose to wait until they finished to compile all of their case files and to get them to us. We're talking thousands of documents. It takes, you don't snap your fingers and have them all together. It takes time to put them together. Once they got them together, they sent them to the SBI for processing, make sure that the detectives, investigators are aware of the materials, and they provide them to us. We bait stamp them and send them out. And those are the materials we received this week. Okay, so there's been no delay here. And we've done what's required under the rule. But I think the important point is to go back to the purpose of the preliminary hearing, because what you're talking about here is, have we completed full expert notice? I mean, I know Mr. Novak says, well, that's not what we request. Well, that's what we understand, and that's what the pleadings seem to request. And this material, these data files, those are materials covered under full expert notice under 77-17-13, not under Rule 16, and certainly not under there's no mention of when this material has to be provided elsewhere. So I just don't see how this is necessary for the limited purpose of the preliminary hearing, particularly in light of all the other three categories of evidence here. I think this is why Mr. Novak couldn't talk about whether or not this discovery material of expert material would affect the probable cause determination. This is why the Lopez analysis is so important. It's because you can hear the evidence, you can listen to it, and you can say, you know, there's the confessions, there's the circumstantial evidence, there's the video evidence, and then there's the DNA evidence. I don't even need to consider the DNA evidence. And there's probable cause here. And that's the state's position, is that there's probable cause regardless. And there's no showing the defense can make that would say it's going to undermine probable cause here. That whatever their experts say, best case scenario for the defense is they get an expert that says both labs messed up. It doesn't affect probable cause because you weigh the evidence in the light most favorable to the state with relation to the DNA evidence. And there's all this other evidence anyway, a confession. That's clearly probable cause. So I would ask the court to hold off, deny the motion for now, hear the preliminary hearing evidence, and then let the defense make their showing. And if they can make a showing that undermines probable cause, fine, give them their continuance. And at the same time, have them tell us exactly what data files they're talking about here, because that's exactly what I asked for, and they gave it to me on March 24th, less than a month ago. So that's the process I think you should follow. And, you know, I know the other thing the defense has said is, well, look, the state doesn't have to use this evidence. They're right, we don't have to use the evidence, but we're not going to not use it where the rules allow it. We're not going to back down because of an argument that's meritless in our view. We're entitled to use it, we're going to use it. If the court decides not to rely on it, that's fine. You know, so that's my position on that, Your Honor.
Final question, and I appreciate both sides in their presentations. Is there a reason that you recognize that the defense would be entitled to a continuance?
Well, I think there's two components to that in my mind. First is, you know, in a lot of cases, we will stipulate to a continuance, you know, out of professionalism, preparation. There's a lot of things that we stipulate to continuances on, but generally we're talking a 2-week, you know, maybe a month continuance. Here, this is a significant continuance that we think violates the victim's right to a speedy trial and affects our ability to get justice in the case. But the second component is why, yes, we would absolutely stipulate to a continuance under some circumstances. This case, it's hard to say because there's these 4 different categories of evidence that I've told you about. And the failure of any one doesn't mean the rest fail, right? Each one of these categories of evidence really establishes probable cause on their own. So it's hard to say why we would agree to a continuance in this case. You know, I mean, well, I'm thinking of a recent case I had where defense counsel's father died right before a trial. I stipulated the continuance, okay? Sure. Something like that happens, of course, we're gonna extend that professional courtesy to the defense. You know, as it relates to preparation, I don't think the defense needs to, and this kind of goes to your question to defense counsel, hey, are you gonna render effective assistance? And I'm thinking, you know, if I were in your shoes and they say they need more time to be prepared, yeah, that's a legitimate concern. And would I agree to a continuance for them to be prepared under certain conditions? Absolutely. You know, for example, let's say they hadn't reviewed the 35 exhibits we're going to present, right? We've narrowed it down, you know, given greater notice than is required by the expert notice statute. In fact, you know, more than a month's notice of all the exhibits and witnesses we're going to call. There's 6 witnesses we're going to call. There's about 35 exhibits we're going to provide. Most of those exhibits were provided to them clear back in 2025. The last one I think was provided, maybe I've got it on a list here, but I know you have it in that letter I sent, Mr. Novak. But the last one was provided there's a tool marks report that was provided March 12th. Okay, so under these circumstances, no, they can review these 35 exhibits. We've got plenty of time to review them. I'm sure between all of them, they've reviewed all these exhibits. They're the DNA reports. There's photos of the rifle found, photos of the rounds in the rifle, surveillance video of the defendant on the scene, video of the shooting itself from people in the crowd, those type medical examiner's report, doorbell camera video of the defendant approaching in his car. The defense has all this. They can be prepared on time. So yes, there are circumstances, but I don't see them in this case.
Thank you.
Now back to the request that the court made for a little more clarity. Exhibit F to our motion is Mr. Burt's discovery letter, which Mr. McBride and I have both been speaking about. And Mr. Burt is prepared right now to tell the court which pieces of the discovery letter we view as core discovery that we're entitled to before the state offers any DNA evidence at the prelim, and which pieces of that discovery letter are more in the nature of expert notice under Daubert. So if the court wants to hear from Mr. Burt right now, we don't have to delay that, but I want the court to understand that Exhibit F is probably the template for that.
All right, and I'm happy to hear from Mr. Burt. Is more time needed, Mr. Novak, to confer on to my first question about the discovery that's been reviewed?
Yes, I think that would have to happen during a short break.
Would a 15-minute break help accomplish that?
Very much so, and I'm sure others would appreciate it.
All right. Well, let's turn to Mr. Burt, and then the court will take a 15-minute break, recess. Mr. Burt.
So, Judge, to simplify a pretty complicated issue, this DNA testing, it's a black box technology. That technician processes a sample, puts it into a genetic analyzer, and what he gets is electropherogram, these little squiggly lines. I'm sure the court's familiar with that. But the machine that they put the sample into generates internal electronic files. And when the FBI or the ATF analyzes the samples, they can adjust the parameters to decide how low of a level do they want to look at the sample. And they have set standards. If it falls below a certain level, they don't want to look at it. That's just the way they do it. And in this case, what you have on all the samples, they're what are called complex mixtures, up to 5 people in each of the samples. So when they have that kind of a situation, then they use another software program called STR Mix. And they run this program, which also has internal files. And that program supposedly sorts out whether various people can be identified with a sample. So of the information we requested initially, way back on September 16th, we requested all electronic files. And in dealing with the FBI and the ATF for many years, when you make a discovery for electronic files, they know, Mr. McBride might not know, but the FBI and the ATF knows that what you're talking about when you're asking for electronic files is the machine output that can be used by another expert to reconfigure where the DNA readings are taking place. And they can only do that when they have the underlying electronic data from the genetic analyzer. So the FBI was given our initial discovery request, And I don't know, I've done probably 100 cases with either the FBI or the ATF. And when you ask for electronic discovery, you get two things. You get the case file, and that contains all the underlying notes of the analyst who is processing the scene. You get the electropherograms, which are the little squiggly things. And you typically get a disk with the electronic files on them. Those files cannot be read by lawyers. It requires software that lawyers typically can't afford, $10,000, $20,000 for the software packages, but they can be analyzed by the experts. And that's the information that we're asking for here. And so it's not correct that we didn't ask for this stuff in the beginning. We did. We did have a subsequent discussion where Mr. McBride said, I'm unclear on what electronic files mean. And so I did provide in a letter specifying exactly by file extension names exactly what that meant. And in the discovery letter we sent to him, to answer the court's question, what's essential here, item number 6, data files, please provide copies of all computer data files created in the course of performing the testing. And then it specifies both raw data and processed data. These files should include all sample files, FSA and or HID files, matrix files, standard files. Any DNA expert would look at that and know exactly what we're asking for. And again, it's standard. It's all it is pressing a button. They can put that on a disk and give it to you within the day. But for some reason, it wasn't provided. And so that's item 6. That's essential information. And the second essential piece of information in this discovery letter is item 9, the STR mixed data. And under that category, we've listed 6 elements of the electronic data related to the XTR mix. The rest of the discovery requests are broader in scope. And as you were told, that's going to be worked out. But the 2 key elements that we don't have are 6 and 8, or 6 and 9 in this discovery letter. If we had that information, we could get it to the experts. The experts could look at it, see how complicated it is, give you better estimates how long it would take to put together their analysis. And their analysis, we have to depend on them because we don't have the expertise or the software to be able to read these data files.
So, and I appreciate that clarity. That's exactly what I was looking for. My next question is, let's hypothetically assume, and the court is not trying to indicate any direction.
Sure.
But let's hypothetically assume I say that's not necessary to move forward at the prelim. Is your expert ready to testify?
Ready to testify at the prelim?
Yes.
The expert would be prepared to come in and explain to the court what they could opine based on the information they have. But the bottom line of the opinions would be what they stated in their declarations to the court. Without the underlying data, it's impossible to draw conclusions. Part of it, the issue here, the specific issue is the STR mixed data that we're asking for includes the internal validation records. The internal validation records tells the lab how many people in a mixture they can reliably assess using the software. And we cited some cases to the court in the continuance motion where courts around the country are struggling with this issue. There's a certain number, if you surpass, that you can't reliably sort out a mixture. So the experts would come in and tell the court that, but they'd also say, till I see the internal validation files, the underlying data files, I wouldn't be able to tell the court whether they can reliably sort out these mixtures or not, because I haven't looked at what their files say.
So, and I appreciate that, but my question is, have you received the lab notes? I understand it sounds like, in order to simplify it, there's some internal settings for these machines, calibrations and such.
Right.
That is separate than lab notes. Where
Right.
Now, I just want to make sure I'm on understanding. Have you received the lab notes for the DNA that the state is intending to move forward on as they've given you notice? Have you received that data?
We've received the case file, the lab notes, I'll call them, from the FBI, not the ATF. So we're missing the ATF lab notes. We do have the FBI lab notes, but those lab notes will tell you how the sample was processed up to the point when it was put into the machine. It will not tell you anything about whether the machine reliably spit out the number of contributors in the sample or how they sorted out how they're matching one of the 5 or 6 people in each sample to Mr. Robinson. That's where we're lacking the information. So I have reviewed the lab note files that tells me how they process the sample. But the critical issue here is, can they reliably sort this out given the complex mixture that they're dealing with? And so that question cannot be answered based on the information that we have and we reviewed.
Thank you, Mr. Root. I appreciate that.
Thank you.
It provides a lot of clarity. All right, let's go ahead and we're at the 12 o'clock hour. Let's break for 15 minutes, come back at 12:15 to confer with defense in regards to discovery. And then we're going to transition to talking about the media in the courtroom. As indicated, it's not the court's intent to issue a ruling about continuing the preliminary hearing. I want to weigh the evidence, the oral argument, the information today, but I am also cognizant of the timelines. And so that ruling will not be delayed because both parties require that, as they should. With that, court is now in recess.
All right. Here's the little room, the juvenile room.
So is he breaking the rule?
This is for us to tell them how we're not prepared. That's what's
All righty. Well, that was a lot. That was really a lot. Well, I think it's pretty clear from our poll that we're all in agreement. The judge already made up his mind in this situation, hasn't he? He's pretty clear that he is not going to delay this prelim. Doesn't really see a reason to. I don't know. I mean, I get where the defense is coming from, but it does seem as though the standard for a preliminary hearing in Utah is probable cause. And they don't actually need all of that all of those very specific reports on the DNA to speak to probable cause at this point. Obviously, they have to have all of that prior to trial, but we are a long ways from trial. Let's be honest. If this trial happens in 2027, I will be surprised. And maybe they'll make it happen because, they seem to really think that Erica Kirk has speedy trial rights, which no, she doesn't. The Sixth Amendment of the Constitution gives Tyler Robinson the right to speedy trial. He can keep that or waive that. That is his right. Utah law offers some speedy trial right to victims. Erica Kirk is considered the victim in this case because she was Charlie Kirk's spouse. But that does not supersede the constitutional right that belongs to Tyler Robinson. That's just the bottom line. Like, she doesn't really have speedy trial rights in the way that Tyler Robinson has speedy trial rights. He has not waived his speedy trial right because he hasn't even been arraigned yet. He can't be arraigned until after the preliminary hearing because they opted to not do a grand jury. They are doing preliminary hearing again, or they're doing preliminary hearing, which takes longer. It takes more time. Grand juries usually happen quicker. Prelims take longer for reasons like what's happening today. There's a lot of legal fights that happen prior to a preliminary hearing that don't happen before a grand jury because grand juries are secret. Prelims are public, right? And the fight leading up to a prelim is public. So there's just a lot of reasons why this is taking forever already. And it just is going to take forever because this is a death penalty case. And so the Eighth Amendment also means that they have to be super, super careful about every single step through this process. Just heightened awareness of everything because the stakes are as high as they can get. You all know I'm anti-death penalty. I've talked about it a lot. This is one of the reasons, I think, because it just slows and bogs the legal system down. And, we can get into we don't have time to get into all of the reasons why I'm anti-death penalty today. But anyway, very interesting argument. I think it's all pretty moot because I think this prelim is going to go ahead in May. I don't think that the judge is going to give them any more time. And maybe he'll offer them a shorter amount of time. Maybe he'll give them an extra couple of weeks or something, but they're asking for 6 months. I mean, that's a lot. That's a long time when you consider he's sitting in jail. He hasn't even been arraigned. He hasn't been given the opportunity to admit, deny, like none of that. I suspect he's going to waive the speedy trial, considering how long this is all taking and the fights that the defense are making really does indicate that this is going to take longer than what speedy trial would allow for, right? So I do think that's very possible. But you know how this works. I mean, we watched this just recently in Idaho with the Brian Kohberger case, and there were tons of fights, right, leading up to trial time, because that's the defense testing if they've got anything that's going to go anywhere. And ultimately, if they don't, that's when the potential for a plea might happen, right? That's what the defense is determining. And particularly in a death penalty attached case, the number one priority is to keep their client from getting the death penalty. I mean, ultimately, of course, they would like to see them exonerated, but we know that the way that the death penalty affects trials, affects juries, they have to death penalty certify jurors, which means that you can only be on this trial if you are willing to give the death penalty. If you say no, I would never be able to be on a jury for a death penalty case because I would say no. I won't give anyone the death penalty. I don't believe in the death penalty. I think it's wrong. I would never make it onto this jury. So the jury is already skewed toward the death penalty before the trial even begins. So the defense's job here is they're going to test everywhere that they've got to test to see if they've got anything that would exonerate Tyler Robinson or would get the death penalty dropped as a remedy for a problem. Remember that happened to Lori Vallow Daybell in Idaho because of major discovery violations on the part of the prosecution. The judge actually had to drop the death penalty from her case. Her attorneys said that was a huge win for them. That was the win they really that was the only win they thought they could get, you know? And so they did go to trial with her because the death penalty was no longer attached. Anyway, so there's a lot there's a lot of strategy here on the defense's part. I don't think that they're going to get a 6-month extension. Maybe they'll get a shorter one, although they weren't real clear with the judge that a shorter one would actually be of any help at all. I appreciated his questions about like, hey, are you telling me that you are going to be effective counsel here or not? Like, is there an amount of time in which you can be prepared? Reminds us all, if you watch Chad Daybell's trial, it reminds us a lot of John Pryor and his endless bitching about not having enough time that went all the way through until the verdict, until the sentencing of the death penalty. Like it was through the entire trial. Anyway, kind of the same stuff. So we'll see what the judge has to say, but I think it's pretty obvious. I've found Judge Graf to be rather obvious throughout the hearings that I've watched for Tyler Robinson. You can pretty well tell what he's going to do just in the hearing itself. Like, for example, the hearing about the one prosecutor's daughter actually being at the event where Charlie Kirk was shot. You know, and the defense wanted the entire prosecutor's office removed from this case for that reason. Like, you could tell Judge Graf, right, Christy, he definitely shouldn't play poker. No, he doesn't have much of a poker face at all. Some judges are very flat. They don't say very much in these kinds of hearings, and you really don't know where they're going to go. Voice was like that a lot, I think, in Chad and Lori's cases, in the Idaho cases. So I don't know, but I think it's pretty clear. So yeah, and looks like our poll is pretty clear about that too. We're at 100% no. They're not going to postpone. So we shall see. Now after this break, then I think we're probably going to start hearing about the media portion of this hearing, which is of course to cover the impact of the media on the trial, potentially impact on the venue, and do they need to do a change of venue? What are the parameters that the media are allowed to work within? Are there times they're going to be out completely? Is there going to be some time that we're not going to get to see in this hearing? I think there is, when they're going to discuss very specific evidence. Although I will say that I think the prosecutor threw most of it out during this preliminary hearing to begin with. He pretty much said it all. They've pretty much already said it all. That's the part that I don't really get why we're trying to hide it now. I mean, when they read the arrest affidavit when Tyler Robinson was arrested, they laid their entire case on the table. They read all the text messages. They read the note. They read everything they had. It was a lot more than what I've seen in other press conferences like that. And I know now that arrest affidavit has been released, and it's like, oh, all this information's out there. We've had it the entire time. They read it right there on the news. So we shall see. My prediction is that the judge will keep the cameras with limited parameters. You can really tell how limited, like they can't even put the camera on Tyler, basically, in these hearings. They're not allowed to show him shackled in any way. And basically, they are just keeping the angle of the camera right on the judge and the attorneys that are speaking. And we don't really even, only when they pan back do we see the back of Tyler's head. They're not showing him hardly at all. Angelic Demise says, I'm a bit behind so far, but I like the judge. Some judges want to rule over the courtroom. Some want to facilitate the case. He feels like a facilitator. He does, but his bias is very obvious too. His bias has come across multiple times that I'm a little concerned about. This is Utah, guys. There's a bias. There's a heavy bias in this case particularly. So we shall see what happens in the next period of this hearing. Pretty curious to see what the expert has to say about potential for jury pool in Utah County. He's the same expert that testified in Brian Kohberger, that helped get the Brian Kohberger case moved to Ada County. Will we see this trial moved maybe to Salt Lake County? I don't know. I'm going to look up on our break here what the demographics are of Utah County, give us a better idea of what we're dealing with, of potential size and, that kind of thing, because those things do matter very much. So I'm going to take a little break. Y'all can take a little break, and we'll be back. We are here live on True Crime Squad Trials with the latest Tyler Robinson
Testing, that works. Thank you. Court is now back in session. I wanted to give it a little bit extra time to ensure defense had that adequate time to have that discussion. What we're going to do is I'll hear from defense about that issue, and then we're going to take another brief recess. We have a technology issue that we want to address that will assist when presentation of the evidence from both sides for the next portion, and I want to make sure that's seamless. All right, Ms. Visser.
Thank you, Your Honor. Our intention is for each attorney to briefly discuss where they are at as far as rendering effective assistance of counsel at the anticipated preliminary hearing dates. I just want to note a few things. For my part, I have been doing my very best to keep up with all of the discovery productions. I certainly have not read everything. But I think it's important to note that we are just starting to find what we're missing. Although the state has indicated there are 35 exhibits for the preliminary hearing, as this court is well aware, we'll have law enforcement witnesses that also testify to hearsay from other law enforcement witnesses, which means we need to read all the law enforcement reports, right? We need to review all of the interviews that are likely to come up in that testimony. So we are in the process of determining what reports we're still missing, and there are some still missing, and what interviews we are still missing. And we are still missing interviews. And we haven't sent an updated list to the state as of today because we don't want to piecemeal it. We don't want to just ask for one thing at a time because we know it's a process to go to the law enforcement partners, get it to SBI. We are creating a list. And the discovery in this case, the only way I can really describe it is that it is like a living, breathing organism, right? Every time something comes in, we have to check our list, see if it's something that we've been waiting for, something that we've anticipated or requested. So if the court is asking me personally, if I feel like I'm ready to render effective assistance of counsel in May at a preliminary hearing, the answer is no. To determine everything that we are missing and get that requested and review it in sufficient time to render effective assistance of counsel, and just the sheer magnitude of what we're dealing with. We're dealing with dozens of law enforcement agencies, hundreds of reports. We are going through it as quickly as possible. But of course, the most important thing to us is rendering effective assistance of counsel. So if the court is asking my opinion of me right now, the answer is no.
So, Ms. Visser, I appreciate that. When will you be ready? With
So
what you have right now?
with what we have right now, so this is one of those things where you're ready when you have to be ready, right? Based off of my calendar and what I believe I need personally, well, we need the DNA. So
Well, let's focus
outside of the
only
DNA?
on what you have, what's before you now.
I would say I need at least 4 months to finish processing what I have based off of my calendar, my trial calendar.
All right. Thank you.
Thank you.
Good afternoon, Your Honor. Kathy Nestor on behalf of Mr. Robinson. I don't know if you recall, it's been a long time, but when we were first setting this prelim, I mentioned to the court that for the months of February and March, I would not be available. I was involved in a murder trial in Summit County. And so for the entire months of February and March, I was not able to work on this case. The trial ended, I think, March 17th or 18th. Then I got sick for like 10 days. So I have not been able to turn back to Mr. Robinson's case until the beginning of this month. In the time that I was in trial, we've had 7 disclosures from the state. Many of those disclosures involve thousands and thousands of pages. One of the biggest disclosures we got was on March 5th while I was in trial, and it consisted of the entire FBI file, which was massive. That's what I've been focusing on the last 2 weeks, reading it as fast as my eyes can read it. because a lot of the reports I think that are going to come out through the SBI originated through interviews with the FBI. So I've been trying to get my head around that file. And that's just one portion of one of the 7 disclosures. And there were thousands of pages. And I think I've made it through the FBI file now, but I haven't even touched any of the rest of it. And as lead counsel, I do expect to have at least a portion of the witnesses at the prelim. I share Ms. Visser's concern about, even though there's only 35 exhibits they're going to introduce, that doesn't limit the testimony that's coming in. And I feel like if I'm going to do a job, a good job, that I need to be able to be familiar with everything that officer has touched, and really what the SBI has done generally. We went to examine physical evidence this past week, this week. It took us 6 hours. We did finish what the SBI has. However, we still have never seen the gun. The gun is at Quantico. So we've never been able to look at the gun. I actually think that's really important for purposes of the hearing. So I have some concerns about that. I also have not been able to get into my client's phone. The electronics that we have required an expert because they're so massive. We had to all get these huge hard drives shipped to us from our digital expert. I have not looked at my client's phone, and that concerns me, especially because the state's indicated they may call individuals uniquely connected to my client. I'm not going to say who because I don't want to commit you guys if you call them or not. But we've been given the names of some witnesses they may call, and what is on my client's phone I think is going to be really important. So I would share Ms. Visser's request for 4 months. I will tell you, I handle quite a few murder cases in the state. I think my last murder case that we had a prelim, we continued it, I think 3 times, and there was 2 terabytes. This case has over 200 terabytes. So I think in the scheme of preliminary hearings and timing, this is not unusual or out of the ordinary for a homicide case in the state, especially one this complex. So personally asking for a little more time, setting the DNA completely aside. Even if they get up and say, forget it, we're not going to introduce the DNA, even if you say I'm not going to listen to the DNA, the rest of it is still significant. I also have some concerns that we do have a notice of intent to seek death with an aggravator. So I assume we're going to go forward with that at the prelim. No one's discussed that. If that happens, that does require really careful review of the scene itself, which I don't know that we're there yet, but we're close. I mean, we definitely have looked at so many videos. I think I've memorized the face of everybody in the crowd. But if we're going to go forward and the court has to make a decision, if you're binding over on whether or not it's capital, whether or not there's an aggravator, that's a whole nother section we have to get into. So for all the same reasons, I would ask for 4 months at least. Thank you, Your Honor.
Thank you, Ms. Nestor. Mr. Burt.
Yes. I've had 2 primary assignments in the case. One is dealing with the media litigation, which has taken substantial amounts of my time. And I'm responsible for putting the hearing on today and working with the experts. And so a lot of my time has been devoted to those kinds of preparation issues. In addition, I've been assigned the task of dealing with all forensic issues at the preliminary hearing. And those efforts so far have involved me sorting the discovery as it comes in, because it's not come in discrete packages. Discovery dump 1 might have some DNA discovery in it, and the next time we get something on DNA is in discovery package number 4. So part of my process has been going through everything as it comes in to sort of sort and get organized the various areas of discovery. And so far we have information coming in on the following areas: autopsy experts, canine deployment, crime scene photographs, DNA, fingerprints, firearms, footwear, laboratory intelligence unit discovery, question documents, state forensics, and trace evidence. So I have set up files for each of those areas. I'm uploading and organizing and reviewing discovery as it comes in each of those areas. We are retaining experts at the point in time when we feel we have enough information so that we're not paying experts to have to duplicate or do discovery review in batches. We're taking on the burden of getting it organized so that we're not spending a lot of expert resources on reviewing discovery. So we have retained the DNA experts, and we're stuck on that issue. As you've already heard, we've retained a firearm expert who is awaiting the case files from the ATF. We just got in the second to the last discovery batch the autopsy photographs that were produced in September. I think we got those just in March of this year. So those are being reviewed and organized so that we can hire a forensic pathologist who will review the autopsy report and prepare us to do whatever cross-examination we need to do on that report. But we have not yet retained that expert. So that's kind of an overview, and happy to answer any questions. I don't feel, given the state of discovery and the complexity of some of these forensic areas, that I'm in a position to render effective assistance. The DNA expert estimated 6 months. I think if we got the minimal 2 categories of information that I outlined for the court, that we could expedite that down to approximately 4 months so that they'd be prepared in that time period.
Thank you, Mr. Burt.
Thank you.
Mr. Novak.
I've already been told I used too much of the court's time, but I think I can supplement.
No, I appreciate all the efforts of every party, and I know it's important, and so that time is necessary and needed. So I appreciate hearing from you.
I'm not going to represent that I'm responsible for all of the motions and pleadings that have been filed, but I've really devoted my time to writing. And obviously the court has held many substantive hearings on issues so far. Obviously everything that we write is a collaboration, but I think that the vast majority of the time that I've devoted to this case has been the legal writing and frankly coordinating the mitigation investigation, which I'm not going to talk about beyond saying I speak almost daily with the people involved in our mitigation investigation, reviewing mitigation materials. That's where I'm focused. And obviously that's not part of the prelim. So if we were shifting to fulsome preparation for the preliminary hearing over, say, the next 30 days, I would have to basically put aside all of the writing that needs to be done and direction of the mitigation investigation, and figure out where, with my colleagues, they need me to fill in so that we are all constitutionally effective when it comes to the preliminary hearing.
And so if, as it relates to what you are maybe assigned to as it relates to the preliminary hearing, how much time would you need?
I think the estimate of my colleagues of 4 months is appropriate. And I also think that what we are all saying is whatever time our DNA experts need once they see the data that Mr. Burke so eloquently explained to Your Honor, we don't have, that's really going to be the controlling time period. We're not, in other words, we're not going to say, oh, our DNA experts are ready, but counsel are not, because I think that 6 month estimate by our expert, which was provided in a declaration, is going to be the outer limit, but that's going to be from when they actually get the data. And as Mr. Burt said, there may be a refinement of that once they see the data that's available to them. I mean, that was sort of a best assessment based on past experience, not based on what the data in this case presents in terms of the challenges for analysis.
Thank you, Mr. Novak.
Thank you.
All right, as and anything, just turning to the state, any benefit of the record that's needed?
I would just add, I haven't seen everything in the file either. That doesn't stop me from being prepared. This is a massive file. Probably, I don't know, 70, 80% of the file is running down leads that did not lead to any fruitful evidence. And so a lot of what this is categorizing evidence. And the core evidence that's required of the preliminary hearing has been provided for a long time, with the intent that I could help the defense. And this is exactly what I said in my letter that I wrote to them with the witness and exhibit list. I provided very explicitly the witnesses we would call, the Bates numbers of the reports that talked about the witnesses that we would call, including the Bates numbers of the reports of the witnesses we would use 1102 statements for. I included all of the exhibits, the Bates numbers for those exhibits, the dates on which those exhibits were provided for the defense. I see no reason why the defense can't review that material. We could probably review it in an hour or two with them, and they could sit down, look at those exhibits, look at those reports, and be prepared for the preliminary hearing, Your Honor.
Thank you. All right. Thank you to all parties. I appreciate that guidance. I've made note of it. As indicated before, we will take another brief recess. We just need to get technology set up to ensure that it's seamless as you're making your presentations. And we'll come back at the 1 o'clock hour. Council also uses time to prepare. So when we start at 1, we're ready to jump in. We'll start with defense, and that way we can be efficient with our time. Thank you. Court is now in recess.
I should go talk to you.
All right. Well, just a quick note. I think I'm going to put up a new poll because that was a pretty huge statement on the part of the defense that they literally, all of them, feel that they cannot be effective at their jobs, effective counsel for Tyler Robinson, and do this preliminary hearing in May. That is very concerning. And that gets into the realm of Tyler's constitutional rights. That could shift the game a bit with the judge. So I'm going to give us a new poll because I do really wonder, will he give them some more time? Maybe not the 6 months or even the 4 months, but maybe a month or 2 months. Remember that this team is this huge because this is a death penalty case. That's really important to remember. That's why there are this many attorneys. That's why there's so much work done on this. The fact, and Nestor brought that up, and I'm glad that she did, that this is a death penalty case. That's why this is so big. And that's also why, like Nestor's on this team, they have to have a certain number of attorneys. They have to have a certain number of attorneys who are certified in death penalty. There's a lot of rules around that. But that is, it was pretty interesting to have the entire defense team stand up and say, sorry, but we can't be effective. It may shift the judge a little bit because he can't violate Tyler Robinson's right to effective counsel, which is also Sixth Amendment. So, Macy says, I think I'm so used to Nestor getting shut down by Mrazek in the Corey Richens trial that my brain is set to no. Oh, I don't know. We're eking into constitutional rights violations. And so I think there's maybe some more potential here that's more important than the specific reports about evidence is the team being prepared. So I don't know. I'm going to put up a new poll, see what y'all think, because that was pretty wild. I've never seen an entire defense team do that before, except John Pryor, but he was a team of one. So that was a little different because he's one guy. These guys, they have a huge team, but they also have a huge case. So I don't know. I'm going to put that poll up now, and here shortly, I think we'll be seeing the remainder of this hearing being about media. So I will put us on standby for now until they come back. Thanks for being here with me.
All right.
And within that binder, there are 12 exhibits. And I think because of the time limitations regarding the hearing, we do have an agreement that there'd be no objection to introducing these exhibits. And I believe the state also has a report that they want to put into evidence. We have no objection to that. So I'd like just briefly to review with the court what's in this exhibit binder, so the court has an overview of where we're going and what the evidence involves.
All right. So Mr. Grunander, I notice you standing.
I was simply going to just indicate that that is an accurate report with respect to the stipulation from the state.
Thank you. I appreciate the parties working together to streamline. That makes it easy for the court. So thank you.
So Your Honor, in light of the agreement, I would move into evidence the exhibits that are in the binder. Exhibit A, it would be A1 through 12.
All right. And per stipulation, they are admitted into evidence and may be published at your discretion.
Thank you, Your Honor. Second of all, we have put on a hard drive that we're marking as Exhibit B all of the PowerPoints that are going to be displayed for the court, all of the scientific studies that are going to be cited by Dr. Ruva, as well as the underlying videos that are going to be displayed. Some of the videos are, because of the time limitations, have had to be edited. So we get to the gist of what we want to show to the court. But the entire video clips are on the hard drive if the court wants to look at it. I've also provided a document of all the transcripts of all the electronic media coverage from September 10th through today. It's about 6,000 pages.
I see.
But I just, in case the court wants to look at any of the material, the actual full context of some of the clips we're going to show the court, it's there. And in terms of what else, so I move that into evidence as well.
So that would be Defense Exhibit B.
Correct.
All right. And
No objection for the purposes of this hearing. And I would just say, Judge, that while these are being received into evidence, the state has no objection for the purposes of this hearing. If we move to another sort of challenge with respect to venue, for example,
I see.
we may have to revisit any sort of stipulation.
Thank you, Mr. Grunander. And just for the benefit of both parties, I meant to start with this. So we have a monitor set up here for a court reporter. I just want to make counsel aware that it could be picked up on the camera, the transmission. So if there's something that should not, please make the court aware and we can adjust accordingly. But I just want to make aware so our court reporter can look and accurately make note of what's happening in court. So just FYI.
Thank you. And Your Honor, just in terms of what's in front of the court in Exhibit A, tab number 1 is the CV for Dr. Edelman. He will be our first witness, a social psychologist and the person who conducted a survey of the community opinion. He's going to talk about that. The survey he conducted is tab number 2. Tab number 3 is his PowerPoint, which is very lengthy, and there's no way we're going to be able to get through it in the time allotted. So I'm going to do the best I can to summarize it for the court. Tab 4 is Dr. Ruva's declaration, and Dr. Ruva's, Christina Ruva, RUVA's CV. She will be our second, and we're only going to have 2 witnesses. We're originally going to have 3. We've condensed it down to 2.
Okay.
So you have her CV on tab 4. Tab 5 is the report she submitted in support of the motion that we filed back in December. Tab 6 is a supplemental report that she wrote after the state and the media filed their opposition to the motion. Tab 7 is her PowerPoint, again, very lengthy, and because of its length, we're not going to be able to present the entire thing to the court. 8 is a document that is currently under seal. It's a declaration of Amber Robinson, and the court has sealed that. So one of the issues is whether it should remain sealed. And it relates to the issue of the privacy prong of the rule that indicates the court has to take into consideration privacy concerns of witnesses and others. So that is currently private. 9 is the declaration of Matthew Robinson, also private. 10 is a declaration of Ms. Nestor regarding some threats she has received. And that's, we're not offering that as private. That's something that the court can consider. 11 is a declaration from a prosecution witness whose name is Samuel New, N-E-W, indicating his objection to being televised and the reasons for it. 12 is a declaration of another prosecution witness, James Rawlinson, indicating the same thing. And Your Honor, just to let the court know, there are over 3,000 witnesses, so we have not been able to survey any of them except the 2 that we're providing to the court in terms of whether they have privacy concerns. When we get to the argument, I'll be addressing that issue, but I wanted to alert the court that we do have witnesses who are, at least these 2 who so far have stated their opinions.
Thank you, Mr. Bird.
So I'm prepared to call Dr. Edelman at this point.
All right, and just before we do, this may not be applicable, but just to be thorough, is either party invoking the exclusionary rule?
Your Honor, we've discussed that, and I think with the agreement with the court that we would not invoke the rule, and the prosecution's expert or witness will be allowed to attend, as well as Dr. Rubo would still listen to Dr. Edelman. I think that would expedite the process.
Thank you.
That's accurate, Judge. Generally, there is an exclusion for expert witnesses. In part, that's the reason for the stipulation. The state's witness is going to be a fact witness,
Okay.
but nonetheless, the defense is not objecting to him being present.
All right, thank you for addressing that. That does streamline things. All right, Mr. Burt, just when you call
Call
your
Dr.
witness.
Edelman. Your Honor, there was one other issue I wanted to raise with the court. When the court made its ruling on the 13th, opening this hearing to the public, I believe, if I'm not mistaken, that the court reserved the issue of whether particular parts of the hearing would need to be closed. And there are certain slides, video presentations that when we get to those, I will be asking the court to take them in camera, explaining why I think so, and we just, for the record, ask the court for a ruling.
Thank you. I appreciate that heads up.
Sure.
Doctor, if you wouldn't mind coming forward, standing right here to be sworn in. Sure, go ahead. Well, either way.
Actually,
You're just going to stand right here to be sworn in, and then we'll have you come to the stand.
You do solemnly swear that a testimony you're about to give now before the court will be the truth, the whole truth, and nothing but the truth, so help you God.
I did.
Thank you. Now you can sit up there.
All right, so if you'd like to get seated, make yourself comfortable. Looks like you brought your own water bottle, but generally we have water bottles. So go ahead and get situated, and then bring that microphone close to you.
Sure.
You just want to make sure that the audio record picks you up. So, okay. Could do that. I appreciate it.
I feel so tiny in this chair. All right.
All right, Mr. Bird.
Thank you. Tell us your name and tell the court what you do for a living.
Sure. My name is Brian Edelman, and I am a trial consultant based out of California.
And what is your educational background?
I have a PhD in social psychology and then an LLM in international law.
What does a trial consultant do?
So as a trial consultant, I work more with attorneys and counties and other clients, more of as an advocate, I would say. And I do pretrial research such as focus groups, mock trials. I help with jury selection, so write juror questionnaires, oral voir dire questions, attend jury selections, give recommendations in terms of cause challenges, peremptory challenges, a lot of post-trial interviews after trials are over, so post-verdict interviews. And I also work as an expert, which is different hat. So when I'm doing this type of work, it's more as an objective person, so I'm not advocating for one side or the other. So that's a different role.
What were you asked to do in this case?
Can you speak in Mike? I'm sorry.
Sure. What were you asked to do in this
Sure.
case?
So at this point, what I was asked to do was to assess whether or not people in the community are being exposed to media coverage, how closely they're following it, and what their sources are. So not a change of venue survey. A lot of the work I do isn't change of venue. I would not classify this as a change of venue study.
Okay. Now, there's a binder there in front of you. Would you take a look at tab 1, please?
Sure.
Is that your resume?
It is.
And does it set forth all the cases you've worked on, either change of venue or doing community surveys, the kind that you were asked to do in this case?
Yeah, for the most part. I mean, I'm probably not all of them are in here, but yeah, these are most of them.
All right. Now, did you prepare a PowerPoint
I
for
did.
this case? And is that in tab 3 there in front of you in the binder?
Let's see. Yes.
And I've informed you we have some time restrictions here, right?
Yes.
Do you think you're going to be able to get through this whole?
I'm going to talk really fast. I've had a lot of coffee, so I think it will be good.
Okay, good. So if I could bring that up.
All right.
Okay. So why don't you walk us through what you were asked to, or what you're going to present here in your presentation?
So I'm not going to talk about the social science literature just because Dr. Ruba is going to do that. But primarily we'll focus on the extent and nature of the coverage in this case. And this isn't a change of venue study, so it's really focusing on what coverage has come out of these hearings, more of from the video streaming and video cameras in the courtroom. So not looking at an analysis of the prejudicial nature of the coverage per se, like we would in a change of venue survey. And then the second part is the survey that was done to see what impact this has had on the jury pool. Are people following it? What are they seeing? And what impressions they have at this point. So I would consider this like the baseline. This is the floor of where we're at right now. And we'll see what happens moving forward. And then the last section, if we have time, talks about some of the challenges cases like this pose when you're trying to pick a jury in a community like this.
Great. So you said on the first area, the social science literature, that's something Dr. Ruba is going to talk about, but did you have one key point you wanted to make there?
The only thing I want to say about it, because we'll touch on it when we get into the media coverage, is, there's a lot of research on this. And the main takeaway I want to talk about is the types of pretrial publicity that are most prejudicial is emotional pretrial publicity and pretrial publicity around the character of the defendant. So all I'm going to say is because it'll come up later.
Okay. So I'm going to skip ahead.
Okay.
To the extent of the coverage, and has the coverage impacted the jury pool?
Right. Okay. So again, this is just looking at two things. Where are we at today in terms of the extent and nature of some of the coverage, focusing on the question of whether or not having cameras in the courtroom is potentially prejudicial, and if it's creating sensational content, or is it more of a neutral nature that, people watching live streams and things like that? And then what impact has this coverage had so far on the jury pool?
And question 2 is answered by your survey?
By telephone survey, yes.
All right. So let's take a look at the first area, the media coverage.
Okay, so I just wanted to touch on the extent of the coverage. So the data here come from two different sources. The first source is called Newsbank, and that's an archive of newspaper coverage. So when it's looking at the coverage in the state of Utah, there's 831 articles in that Newsbank that are sources that are based in the state. And it's probably a conservative number because it's not exhaustive. There's things that are missed, but I'd rather be conservative than overly inclusive.
Right.
And then Utah County, 697. I believe it looked at like 15 sources primarily, 15 newspapers. It also includes Fox KSTU, the local Fox station, and there's 209 news segments that are in that archive. The last section there, that row, is from a Lexis search, which is different, and it captures transcripts. So there's 441 of those that are nationwide, but it is limited. So it doesn't include Fox News. It doesn't include, I think, MSNBC, NBC. So it's not an exhaustive list. It's only certain.
I'm sorry, it includes CNN, the major
It has
networks.
CNN. I think it has CBS, NBC, or maybe ABC or something like that, but it's missing some of the networks.
And I told the court that on his thumb drive, or on his drive that we provided, was the 441 transcripts,
Okay.
6,000 pages.
Yeah, that's right.
You've seen that.
I have seen that.
Okay. Next, I think you're going to look at the nature of the media coverage, and what was the framework you used to do that?
Yeah, so one thing I wanted to touch on is this is the American Bar Association rule, so 3.6 about pretrial publicity. It's not the rule, whatever the Utah one. This is just the ABA. And the thing that stood out to me initially is when we talk about people who work in, attorneys, people involved in the case, like what they should and shouldn't introduce to the public. And one of those things that are key factors to me are extrajudicial statements that the lawyer knows or reasonably should know, will be disseminated by means of public communications and have a substantial likelihood of materially prejudicing the adjudicative proceeding in the matter. So anything that's particularly prejudicial in nature, you shouldn't be releasing if you know it's going to lead to bias. Examples when we talk about the defendant, I mentioned defendant character evidence is particularly prejudicial. We have character, credibility, reputation, or criminal record. And then tests and things like confessions, admissions, statements given by a defendant. When we talk about tests, it could be DNA, ballistics, things like that. And then opinions as to the guilt or innocence of the defendant. And then anything they know might be admissible. So this is the stuff I look at. Are things crossing that line? Because those things are particularly prejudicial. And I think the ABA, a lot of that is driven by the research that tells us that.
Okay. We're on slide 14. What does this show us?
So the reason I point this out is because a lot of the prejudicial content that's come out so far that you see in the media and keeps being reproduced on social media, in television newscasts, is what was initially released in this press conference. So, it was the, I guess the indictment or arrest affidavit, and there's a lot of prejudicial details that are distributed in there where it's, a very long press conference. We're literally reading text messages from the defendant to his roommate, and they're prejudicial. They imply there's some degree of guilt in there, and it's reading it, the whole thing, which is then disseminated, and it gets reproduced on TV and reproduced again and again and again. It appears in social media posts, reels on YouTube, and a host of other places.
And does that reproduction include when the coverage relates to in-court appearances?
It does. So, we'll get to that, but the information that was here keeps getting reproduced in a sensational way on TV. And not only that, like here, he's reading it, but when you see it in the graphics, it shows text message that implies this is the actual text message on a phone that came from the defendant, and it's not. So it's very prejudicial and misleading.
So you say on your slide, this serves as sort of a megaphone and a distributor of certain information.
Yes, and
is within the categories you set out.
Yes, and when it's being distributed, just to point out, it's not like it's only distributed on conservative media outlets like Fox. It's on CNN, NBC, all of the networks. So it's widely being distributed to all types of viewers.
And in terms of other sources of this megaphone effect, your next, and by the way, you've got the actual video of the press conference.
Yeah, this is a clip of it.
We're not going to play that because of time limitations, but it's there if the court wants to look at it. Are there other sort of megaphone factors here?
Yeah, so this is a unique factor in this case, in the sense that people who are very influential, obviously the President of the United States, or former Attorney General, these are people that have a lot of influence and power, perceived credibility, and they're making strong prejudicial inflammatory statements. And I think that's unique. I don't usually see that in cases. And calling for the public execution of the defendant before there's been a trial, things like that are unique in nature.
Right, Your Honor, this is one of the slides I would like the court to see, and it's, as he just indicated, expressing opinions, strong opinions about whether Mr. Robinson should be executed. So the court wants to take it in public, that's fine, but for the record, I'm asking the court not to do that. I do think it's important that the court hear this, just the tone of it and the substance, I think, is very important for the court to consider. Since we are submitting it, the PowerPoint is on the drive. The court could listen to it outside of the public domain, however the court wants to proceed.
So I'll make note of that, and I'm happy to review that in
Thank you.
entirety.
If we're not going to play, just one thing that's unique about it, if we're not playing it, is
Sure.
there's inflammatory language in there that also creates in-group, out-group identification. When I think,
Could you explain that?
yeah, so it's like a lot of people identify with a political side. Unfortunately, I'm a member of the Democratic Party or Republican Party. I'm liberal. I'm conservative. So I think there's some language in that clip where it mentions, I don't remember the exact phrase, but something about like lunatic leftists or something like that are doing this. So it creates this. The out-group is dangerous, they're lunatics, maniacs, or whatever phrase was used, which creates more of danger, the perception that members of that group, that out-group, are dangerous, and there's a danger there. So that's something that comes up later as well.
And how is that kind of information more or less prejudicial?
Well, it creates, again, in-group, out-group identification, and we think members of the out-group are not like us. They tend to, they're all the same. We have to attribute stereotypes that of how those people behave. They're more likely to impact how we see them. You're less likely to have empathy for members of the out-group when group salience is high, versus members of our group we see as individuals or complex, less likely to be impacted by stereotypes, more likely to empathize with them, identify with them, things like that.
Right. Now, did you actually take a look at the court appearances that have so far taken place in this case to see what was discussed, so that you could compare what was happening in court with what the electronic media was reporting was happening?
In terms of the comparison of what's happening and what's being produced?
Yes.
Yeah, I did look at that.
So the timeline, could you explain this, what you have up here?
So this is just a timeline of the hearings that have taken place and like high level what they were. So like the initial WebEx appearance, pretty brief, and you would think that's a pretty neutral, not very significant hearing, and you would expect if you're looking at the media, it should be neutral. It shouldn't be highly prejudicial, inflammatory, since very little happened there, right? Mm-hmm. And the same thing when you have like the waiver hearing, appointment of counsel. There's not a lot of fireworks. It's not the preliminary hearing. No evidence is being laid out or anything like that. So you would expect the media not to be introducing prejudicial content, given the nature of those particular hearings.
If they were serving an educational function.
If they were educational, transparent, a summary of what occurred. These are very procedural, technical things. They're not necessarily sensational in any way.
So did you take a look at the first hearing, the initial WebEx appearance by Mr. Robinson?
Right. So this is a brief, short hearing. Where, I think he appeared on WebEx, right? And then I looked primarily at what did that elicit? What was the reaction to the media? Was it kind of just summarizing this is what happened, or was it more sensational in nature?
Okay, so let's take a look at the clip. And this is from NBC
You have been
News
watching that court
on that
hearing
date,
for
correct?
the man
Can you turn it a little
suspected of shooting and killing Charlie Kirk last week on a campus in Utah. You saw the suspected assassin, 22-year-old Tyler Robinson, there not speak.
I think we got a problem with the audio.
To thank all parties for being here, and this concludes to thank all parties for being here.
I need to. Let me check and see. That's in settings.
Is this source Yeah, the volume for the source might allow for amplified volume.
Oh, yeah, right, okay. That's what I. Let me unplug this and replug it. That's the way it happened last time. Speaker. It's not coming up. By the laptop. Okay, you can do that. Okay. Okay, so is this first slide from, it's not in there? All right, let's try that out.
There we go.
There we go. Okay, let me escape. Slide. Okay,
Did you skip the previous,
let me go back.
19? There you go.
There we go. So is this, as you indicate on the slide here, this is ABC's coverage of the September 16th, 2025 WebEx appearance?
Yes.
And in this clip, are you picking up the coverage right after the court says we're in recess?
Yes.
Okay. I don't know what's going on. Frustrating. No, it's not. Getting no audio at all.
I'll try a different laptop.
I had you read that laptop first before you tried this one.
And I'm sorry.
I recommend rebooting the laptop.
Okay. Try that. Apologies to the court. Thought we had this set up. Let's do. I've rebooted.
Pull the cable out one more time. And then plug it back.
Say again.
Pull that HDMI cable out now. And you can do it. And plug it back in.
That work?
There we go.
There we go. Okay. Yes.
All
I
right.
think we're good. Okay. My apologies. So you're picking this up from the point in time right after they've shown the whole hearing,
Yes.
and this is kind of the aftermath.
Right.
You have been watching that court hearing for the man suspected of shooting and killing Charlie Kirk last week on a campus in Utah. You saw the suspected assassin, 22-year-old Tyler Robinson there, not speaking, wearing what appeared to be some kind of green vest, as the judge read out the 7 charges against him, including, of course, aggravated murder. The state making clear that they are seeking the death penalty and putting in place, the judge did, a protective order, apparently at the request of the state, for Erica Kirk, Charlie Kirk's widow. I want to bring in Danny Savalos. I want to bring back Steve Patterson, who's live for us in Utah. Danny, here too, some of the paperwork is just into us on that protective order that the court finds the defendant represents a credible threat to the physical safety of that person here being Erica Kirk. Danny, stand by for a second. I want to go back to Steve Patterson here. And Steve, it has been a remarkable series of developments over the course of the last several hours as state officials, the Utah attorney there earlier in the day described, and the charging documents, some of these probable cause documents showed step by step, almost minute by minute in some instances, how they closed in on this 22-year-old as their suspect.
They did. And in doing so, we got the TikTok, we got the charges. Also, these, the exchange of text messages between Robinson and his roommate. These are details that we simply didn't have before. One thing that sort of gels with what we saw in the text messages, this exchange again, before and after between Robinson and roommate, who believed to be romantically linked, is how cognizant and lucid Robinson appears. And I would say that for looking at this video, almost appears like the video is frozen. Just want to comment a little bit more on the physical appearance of Robinson, appearing over WebEx on video, appears to be wearing what is described to me as a safety smock. We know he's on a special hold, right? They're going to hold him there in a separate unit before they evaluate his mental health, before they put him in maybe a more different location, a more general location. They do that as a matter of procedure, right? But it is sort of interesting. He did say one thing, which was his name, which was stated clearly and firmly. And again, I want to say gels was sort of what we saw in that exchange of text messages, because He's talking to his roommate, who clearly appears to have no idea, the roommate, what is going on, or that he is the suspected shooter. And yet he's sort of talking a TikTok of what he has done and why he's done it, and admitting to do it, essentially shocking this roommate through these series of exchanges, which sort of gels with his physical appearance today. Obviously, we also heard during the hearing the Utah County following the course of action to introduce the death penalty as well. That was filed as this was being read in court. So definitely some developments here today. And just the amount of information that we got, the blanks that were filled in,
right.
Not only that, but also on the apprehension, the involvement of the mother as well, and sort of bringing him in. And also the physical evidence, the DNA found on the actual trigger of the rifle, which was tied to not only what was found on the screwdriver, but also the towel used to wrap the rifle. So an extraordinary amount of information that we got, especially with this charging document that's now in.
What's also clear from these text exchanges laid out, Steve, is that Robinson had no intention of being caught. And I say that because he said he had hoped to die of old age with this being his secret, according to what the state had laid out in this text exchange. Almost seemed panicked when describing trying to go back to return to retrieve the rifle that he allegedly shot Charlie Kirk with, not being able to do so when essentially caught out by his parents, when his parents approached him and said, we think this may have been you, tried to get in touch with him, tried to reach out. The state says that Robinson suggested or implied that he may try to take his own life here. So you can get a sense of his mindset, at least based on some of these text exchanges and what law enforcement has laid out over the course of some of these documents here. All of it, as we should note, these are the state charges here. It's possible federal charges could come.
Yeah, federal charges possible. One notable sort of omission is we didn't see any federal officials. We don't know if federal charges will be filed, although it's heavily implied that they will. One thing also is sort of the level of deceit, both with the parents. The father did something that sounded very clever. It was heard the description of the rifle that had been described by authorities, federal authorities, state authorities, and that he assumed, obviously with the pictures of Robinson himself on camera at the university, assuming this is his son, trying to get in contact with his son, trying to ask, hey, could you send me a picture of the rifle that I gave you? And of course, the son sort of ghosting him, seeming to imply, again, involvement. And also about the rifle, there was a lot of investigative work to try to figure out, was the rifle traceable? Was it bought legally, illegally? Would have been hard to trace, we now know, because this was essentially a family heirloom, something that's common in hunting families, passed down from grandfather to father to son, and that was the case here. So again, much more stark relief that we're seeing this case in, Hallie.
That's right. Robinson also telling his mother he had been out sick, had stayed home sick over the course of the 2 days that she had inquired about. Steve, I know you're going to stand by for us later on as we get potentially more on this. Danielle, let me go back to you here briefly because Steve laid out what could come next here. Obviously, the death penalty that the state is seeking. What about this protective order for Erica Kirk? Is that something that is typical in the course of an investigation like this, a prosecution like this?
Sure, yes. As to prospective victims, it's usually not entered against someone's spouse, but it makes sense here because this is not some street crime or a crime of passion. This is someone who was apparently, whether by this defendant or not, targeted. And so it makes sense to say, well, close members of the family may also be targeted as well. So it's not unusual for judges to enter those kinds of protective orders as sua sponte on their own or in response to a request from the prosecution.
Danny Savalos, thank you very much for that. I appreciate that. We have been talking now about the developing news that has occurred over the course of the last several hours, with prosecutors laying out in detail how they say Tyler Robinson carried out this murder. We're going to play a big portion of that in case you missed it earlier. We want to basically roll that tape so you can hear for yourself how the state laid this out. Take a listen.
These are the allegations.
And let me stop it right here. At this point, does she play essentially the entire press conference by Mr. Gray?
Yes.
Okay. And we didn't include the entire 27, 30 or 45 minutes, right? We clipped it to get to the end of the coverage.
On September 10th, 2025, at approximately 12:23 p.m., Charlie Kirk was shot and killed while speaking to a large crowd on the campus of Utah Valley University in Orem, Utah. Police found the suspected murder weapon, a bolt-action 30-06 rifle, nearby. Over the next approximately 33 hours, police conducted a manhunt for the shooter until the evening of September 11th, 2025, when Tyler James Robinson surrendered to police at the Washington County Sheriff's Office.
You have been listening to Jeff Gray, the Utah County Attorney, earlier laying out those minute-by-minute details on how they caught the man accused of assassinating Charlie Kirk. You saw the court hearing for suspect Tyler Robinson live before that. That was that virtual hearing. As prosecutors say, they will seek the death penalty. Robinson will remain in jail, no possibility of bail. He'll be in court again in just about 2 weeks.
And again, just to reiterate, we cut 27 minutes out of the press conference, right?
Yes.
So how does this coverage line up with what was happening in court?
Well, I think, like we said, there's an implication that there was, like, the text messages were part of the court hearings, because he implies that was part of the hearing. And then it's bringing up all of this new information or old information that has nothing to do with the hearing. So it's just rehashing. Let's remind you about the text messages, DNA, the deceit of the dad because he was suspicious of him in terms of the gun, and all of these things have nothing to do with this hearing.
I noticed the reporter when he put that graphic up of the text. By the way, was that graphic the actual phone of Mr. Robinson?
It's not. No, and it implies, and you see that throughout a lot of the coverage, like text messages. There's YouTube reels where somebody like creates a reel and reproduces text messaging so it looks like it's the real text message.
And when he's putting that up there, he says, as we heard in the hearing, words to that effect.
Yes.
But there was no mention in the hearing of text messages or anything else, was there?
Correct.
Is he confusing what he heard in the press conference with what he thought he heard in the hearing?
Well, I think he's confusing the viewers with what happened in terms of now that, there's a belief like evidence is being presented in these hearings that imply guilt, when that's just not the case.
So as you say in your slide, is this coverage sort of advancing the prosecution narrative as opposed to an educational function?
Yes.
All right. Did you also take a look at ABC's coverage?
Yes.
And by the way, the last slide was, I think, the longest slide, right?
I think so.
All right. So this is the same day.
To thank all parties for being here, and this concludes this hearing at this time. Court is in recess.
So the suspected shooter there of Charlie Kirk, the hearing has now just concluded. We know that the state is pursuing the death penalty here. We have just learned throughout this proceeding that they are going to try to find him counsel. They deemed he is indigent, so they will be providing an attorney for the alleged shooter. And the next time that he will make a court appearance will be September 29th. And then again, as you heard the judge there say, that will happen on WebEx. A couple other things that we learned here throughout this quick hearing is that he will remain in custody without bail, and that the state was also present there, and they asked for a protective order on behalf of Erica Kirk. Of course, that is Charlie Kirk's wife. A reminder to everybody that, yes, he was a conservative activist, but he was also a young husband and a young father of 2 children, and a protective order has been granted on behalf of Erica Kirk. I do want to bring in our ABC News Chief National Correspondent, Matt Gutman. He's in Spanish Fork, Utah, there for us. Matt, thank you here for being here with us. And so we just saw this proceeding play out. No surprise, right? This is not the proceeding in which this person would enter a plea. But Matt, prior to this, there was a lot of evidence that the prosecution sort of laid out for the public, including text messages, DNA, things like that, that they do plan to try to present to the judge to be admitted here in trial. But perhaps, Matt, you can just gauge for us, since you've been covering this now for so long. Tell me about your first reaction here in seeing Tyler Robinson sit down there, if you were able to see it, sitting down in this court hearing.
He was sitting down. It was via WebEx, so he wasn't physically in the courtroom, Kana, with the judge. But you could see that people were watching. You could see he was wearing this padded vest, and that's because he's been in what's called special watch in this jail here, which is essentially an isolation. He's being held to prevent him from harming himself or from others harming him. We heard from the prosecutor earlier today in his announcement of the charges that the suspect's mother had said that he was suicidal and that he wanted to kill himself allegedly instead of turning himself in. So you see him in that protective garb. The bulk of this hearing that we just saw was the judge reading the 7 charges. Of course, they are aggravated by the fact that the suspect allegedly committed this political assassination of Charlie Kirk in full view of children. So that's one of the things that has enhanced the charges against them, and one of the things that makes this a capital case, according to prosecutors here.
And I'm hoping we can just quickly go through some of those text messages that you mentioned there again with this roommate, with your prosecutors say that he was romantically involved with. And one thing they touched on in this hearing too, Matt, is the fact that in this text message exchange, we're showing some of it, but Matt, they pointed out to the fact that they believe the shooter asked his roommate to delete the exchange and then to not speak with the media, and then it's shown in these charging documents, Matt.
Yeah, we have not seen these text messages. We have heard them for the first time from the prosecutor. They also put out this charging document in which these messages were revealed. And it appears to show this exchange between the suspect and his roommate, with whom he was romantically involved, apparently. And it's very, very detailed. And in the text messages, the prosecutor says that the suspect was talking about the murder weapon, talking about where he stashed it, talking about how he stashed it, and yes, allegedly advising his roommate to delete the messages and not to cooperate with law enforcement, to get a lawyer and not talk to the media if this blows up. And eventually it did. What also struck me about these messages, at least initially, is that the suspect appeared to think that he could get away with this. He was hoping that he would never have to mention this to anyone ever again, and that they would never be able to find him. And it was only, as we've learned through these text messages presented by the prosecutor, when he realizes that he can't get back to that rifle that he stashed and take it somewhere else, and he realizes that police is right in that vicinity and he can't go get it, that he is in trouble. And that's when things start to spiral out of control for the suspect, according to these text messages. And at that point, he does appear, at least afterwards, to talk about being suicidal, not wanting to turn himself in. Eventually, he's convinced by his parents he should not do any harm to himself and that he should do the right thing and turn himself in.
Right, and the prosecution revealing this was his grandfather's rifle. It was a very important piece of family property.
Right.
Matt Gutman, thank you as always for being here with us today. I also want to bring our ABC News Washington, D.C. Bureau Managing Editor Catherine Falders for more on this. And Catherine, again, no real surprises here in this initial court appearance. I think everyone now marking their calendars here with September 29th to see what kind of counsel this alleged shooter does get ahead of time. Also notable, again, a protective order has been granted on behalf of Erica Kirk, Charlie Kirk's wife, throughout this hearing. But Catherine, I think really the prosecution made a huge effort here to lay out as much of their case publicly as they could. And they made it very clear, Catherine, in this hearing that they are ready to give over all of this discovery to the defense, the state really making an effort to have their ducks in a row here ahead of this court appearance.
Yeah, exactly. You did hear them say that, all of that information that they've gathered that we've heard about, obviously, through the press conference earlier in these charging documents. There is a lot of evidence that they have. There's mountains of evidence that they have that we've learned through public documents like the one we received earlier, and also through our sourced reporting. We know they're doing forensics, for example, on the weapon that he used, which you just discussed a moment ago. So yes, they said that they are getting fascinating, Kana, to see him for the first time from sitting there from jail. He stated his name, that clip that you're playing where you hear him talking, that was him stating his name, Tyler James Robinson. And I noticed at some points when the judge said, I'm looking at my notes, but when the judge said to him that he was going to remain in custody without bail, you could see Robinson shake his head yes. When he said that he was going to read the charges, remember there's seven counts here, 6 felony counts. When he told Robinson he was going to read the counts, you could see him shake his head a little bit of movement there, but he hasn't said really anything else, of course, other than stating his name, and he will be provided an attorney. But I do think that it is quite striking to hear and see all of that evidence that it appears that the prosecutors have gathered. Looking at the charging documents again, we of course have been really focusing on those text messages that Robinson and his roommate exchanged. It appears they exchanged on the 10th, so shortly after the shooting. Now, it's unclear whether these are all of the text messages in the possession of prosecutors. We don't believe so. There's probably more, but those were quite striking to see.
So how does that coverage stack up with educating the public about what was going on during the initial court appearance?
Well, I think you can see he's trying to, in the beginning, lay out what occurred, and she actually stops him and says, I want to get to the text messages, and brings it up again, and moves it there.
Right.
And implies again that stuff came out in the hearing. So it's kind of blended, that sometimes it's mentioned in the charging documents, sometimes it's, the prosecution made an effort and implies in the hearing again, in just focusing on the evidence. It's not focusing much. I mean, that's like a 5-minute clip, and there's very little about what happened. It does mention what happened. I don't want to act like they didn't talk about that at all, but they blend quite a bit of evidentiary information in there. And at the end of the day,
And when you say evidentiary information, are you talking about incriminating evidentiary information?
that has not been determined to be admissible or anything. So, right. It's just, here's the text messages and calling it a mountain of evidence and all that kind of stuff.
Yeah. Okay.
To thank all parties for being here. And
But also,
Did
you
also
have a
look
very
at,
stoic.
How CNN was covering this initial appearance?
Yeah, this is the same hearing.
And your understanding is the person in the CNN clip is a former prosecutor who's CNN's chief, quote, legal analyst, right?
Yes. Right.
Okay. Let's take a look at that one. That's your next clip, 24, I believe.
But also, you have a very stoic defendant who I was looking to see any emotion that he might be displaying. Hearing that the death penalty may be requested for you is a very monumental seismic moment. He had no reaction, nodding in essentially understanding alone. But then there was also a protective order that was asked for by the prosecution on behalf of Erica Kirk, now widow of Charlie Kirk, that entails that there might be an element of fear that she is experiencing, or the thought that she wants no contact either from him or anyone around him, that would make her feel more secure. Of course, she is a mother of 2 young children. You understand that. But here you've got a speaking, essentially, indictment of sorts from the prosecutor earlier today, which laid out so much evidence. It's all allegations, the statements of counsel, not evidence in a court of law. But what can come in a court of law?
Yeah.
The statements of the defendant, including all these text messages.
Well, let's
So according to CNN in this clip, the evidence that she hasn't looked at is admissible, right?
And again, mentions it was laid out today, implying that it was laid out in this hearing, and discusses his demeanor. He didn't react properly, according to her. His body language didn't, whatever the appropriate way to react is. So, focusing on him, focusing on these text messages, calling them admissible, whatever.
And I notice in all 3 of these nationally broadcast clips, there's a real focus on the protective order.
Mhm.
And tying that to Mrs. Kirk's fears, correct?
Yes.
How is that furthering the prosecution's narrative?
I mean, to me, it just goes to future dangerousness of impressions of the defendant. So we kind of talked about earlier, negative character evidence is prejudicial. And also we know from the research that pretrial publicity in fact affects verdicts and the perceived credibility of the defendant, likability and sympathy. So it kind of goes to that.
Okay. Did you also look on that for that court appearance on what the local media was doing?
Yes.
Right. And before we turn to that, did you also look at how Fox 13 captioned the importance of the hearing on the 16th?
Right. So transcript reveals Robinson's alleged confession to shooting Kirk and messages to roommate with a screen capture of the court proceeding.
So the gist of what happened in court, according to Fox, is the confession.
That's what it implies. Yes.
Yeah. Okay. Now, at the local level, did you look at this clip from
Following
KUTV?
Robinson's initial appearance in court today, we did speak with a body language expert who has been part of hundreds of high-profile criminal cases across the globe.
And some of the most compelling cases include Ryan Kohberger, Lori Vallow Daybell, Casey Anthony, Karen Reed and Alec Baldwin, Scott Peterson, P. Diddy, Gypsy Rose Blanchard, Amber Heard, Prince Andrew, Nicholas Rossi, to prolific serial killers, Ted Bundy, John Wayne Gacy. Tonight, Chief Investigative Reporter Wendy Halloran talked to Scott Rouse, who helped break down Tyler Robinson's body language. Wendy.
Well, Jamie and Mark, Scott Rouse dissected the nonverbal cues, analyzing gestures, expressions, and demeanor after Robinson learned prosecutors will seek the death penalty against him in the assassination of Charlie Kirk.
Tyler James Robinson.
Thank you for being here, Mr. Robinson. I'm Judge Graf.
Tyler Robinson appearing virtually from the Utah County Jail in a suicide robe.
It's really odd behavior for someone who should be stressed in that situation.
Scott Rouse is a world-renowned behavior analyst and body language expert. He holds multiple certificates in advanced interrogation training and has trained alongside the FBI, Secret Service, U.S. military intelligence, and the Department of Defense. He serves as an expert consultant for law enforcement and the U.S. military, among others.
I'm going to tell you from my experience what I see going on here.
I asked him to analyze Robinson's demeanor.
No big, deep breaths. We saw a couple of breaths that weren't deep breaths, but they were breaths from just, it looked like they were almost from boredom. So that was a little bit odd as well.
Rouse says when he looks at people in situations like this,
Things like this, I look for things that are missing, and those are all the things that are missing right out of the gate. And this is odd behavior for someone who theoretically should be fairly stressed at this point.
Rouse says it could be that he hasn't slept much.
Even though it doesn't look like a whole lot going on there, that's odd behavior for a situation like this. I've seen these 1,000 times where someone is being in the same situation, you're talking to them, and they've done something horrible. And they don't know what's going to happen next. They don't know what to expect. They don't know how to act during that. And this guy just looks relaxed.
Rouse recounted what facial expressions he would look for.
And you've got things called adapters where you try to get rid of built up stress and tension. Don't see any of those. We see a little bit of clenching of the jaw, and his jaw goes over to his left. I think it's his left. And that's about it. In my opinion, he's pretty much resigned to whatever's going to happen is going to happen. There's nothing that tells us he's frustrated. There's nothing in his face from an expression perspective that tells that he's worried or frustrated or angry or anything.
Rouse says there were no jerky, tense body movements, and he meticulously watched his eyes.
We can't see his blink rate very well. Blink rate tells us if someone is concerned or thinking about something or is stressed about something, because your blink rate goes up a lot. Because the normal human will blink about 15, 20 times a minute. And from what I could tell, it was a low blink rate because I was catching maybe 10 times a minute. It wasn't a whole lot. So I think from an emotional standpoint, he's given up.
No, Rouse said if Robinson was concerned about something, his eyebrows would raise. He says he didn't see that happen at all in this hearing. Mark?
All right, interesting. Wendy, thank you.
What stands out to you about this kind of coverage?
Well, now we're completely speculating with sensational conjecture because he didn't blink properly and his eyebrows didn't go up enough or whatever it is. And now it's creating this impression that this person has no emotion or empathy, like he might fit I think later it becomes a sociopath. We all heard the story of they have no emotion and all that. And this is all based off of him watching a WebEx for a couple seconds and just making these ridiculous statements because he's the body language expert now. So we can now make an assessment from this hearing that he didn't respond properly because he's, quote, given up or whatever he said. And this is all, obviously none of this is informative and it's all speculation and sensationalism.
And by the way, you're aware of the fact that the court has moved the camera from the front of the courtroom to the back.
Yes.
Right. And moving it to the back, does that still allow some room for these so-called body experts to maybe analyze how his shoulder was tilted?
If his jaw doesn't move right
much
or controlling if somebody turns around for a second, I mean, it's a courtroom. Things happen over time. So the fact that anytime there's a movement, it might spur some ridiculous story about somebody's nonverbal language is incorrect is personally, I think is pretty sensational and ridiculous.
Okay.
Following Robinson's initial.
Now, did you also take a look at the September 29th hearing?
Yes.
And what was your understanding of what actually took place at that hearing?
So this was primarily from what I remember, it was appointment of counsel in this hearing.
It's called a waiver hearing. you got on your slide waiver hearing, appointment of counsel. And again, Mr. Robinson is appearing on WebEx at that
Right.
hearing.
So hasn't been in the courtroom yet, still
So-
WebEx.
Was it your understanding at that appearance, counsel got appointed?
Yes.
Essentially. All right. So how is that covered, first of all, by Court TV? And before I show you the slide, are you endorsing the criticism that Court TV in the slide makes against the court and the prosecutor?
I'm sorry, endorsing what?
Are you endorsing the criticism that in the slide of the court and the prosecutor?
No, that's just what was said by one of the commentators.
What were you trying to assess and looking at this slide, what the perception of the public is to the in-court proceedings?
Yeah, I mean, I think it's commentary that falls on the sensational side, right? So now it's these people are pandering to the camera and it's creating a performative experience. So it's turning into like outside the courtroom, like a reality TV show in a sense. Like, I don't like what this person said or that person said. So not informative as to what's happening, but it's sensationalism, and it's just the kind of thing you want to avoid.
So let me play this for you, and then I'll ask a question about
To be live, Matt Johnson alongside my friend Kelly Craft in today for Ted and Julia. Busy day here. Let's begin this hour in the state of Utah, where the suspect in the Charlie Kirk assassination is due back in court today.
22-year-old Tyler Robinson is accused of murdering the conservative activist during an event that was held at Utah Valley University. This took place earlier this month.
Robinson is expected to appear via Zoom during that hearing alongside his newly appointed defense attorney, where we're likely going to hear a discussion as to whether or not they want to schedule a preliminary hearing.
While we wait for that hearing to begin, let's go ahead and take a look at a backgrounder on this case. This is Court TV affiliate KSTU with a closer look at the suspect, Tyler Robinson.
Robinson had confessed to them or implied that he had committed the incident.
From his apartment to his family's home, the FBI and police combed every inch of Tyler Robinson's life. His family expressing to law enforcement that he had become more political in the last few years.
Robinson mentioned Charlie Kirk was coming to UVU. They talked about why they didn't like him and the viewpoints that he had. The family member also stated Kirk was full of hate and spreading hate.
Why don't we go ahead and bring in our guest this hour to discuss as we wait for that court appearance to begin out there in Utah. Joining us now from Los Angeles, California, former Deputy Public Defender for LA County, Philip Dubé. Philip, nice to see you on this Monday.
Your Honor, we appreciate the court's comments with respect to Your Honor's role in this case. In like matter, we commit to approach this case with integrity, with professionalism and civility. We are truth seekers. We will aggressively pursue the truth in this case. Thank you.
Thank you. All right, counsel, unless there's anything else, thank you for being here. This court is in recess.
All right, and that concludes that hearing. Philip, let's go ahead and bring you in on this.
The only criticism I have was that those closing words about how we're all here to seek justice, like the warriors of justice. Attorneys and judges don't speak that way in open court. It's presumed that everybody will act with integrity, with honor, and to articulate it on the record, in my opinion, is pandering to the cameras.
All right, Philip. So
you're familiar that one of the criticisms of the court coverage in the O.J. Simpson case was that everybody, including the judge, was pandering to the camera. You familiar with that?
Yes.
And this guy from LA, he's probably familiar with that case. He's accusing the court and the prosecutor of pandering to the camera. And then this first part of the video, where they refer to the backgrounder, are you familiar with what's referenced there?
Yeah, again, it's kind of going into the background stuff again about evidence and then jumping in while they're waiting and so on, and then jumping into that.
And who is giving the backgrounder there? What the clip is of Governor Cox, is it not?
Yes, the governor.
Okay.
Yeah, reading
So-
another press conference.
So that's a sort of an incriminating narrative. And then the second part of it is, what is the perception of the public to the court proceedings being televised? And at least according to what Court TV's putting out there,
Oh, that it's a show. It's
We're
pandering to the camera.
pandering to the cameras.
Yeah.
Does that further the reputation of the judiciary, or does it detract from it?
You said what?
Does it further the reputation of the judiciary, or does it detract from it when the perception is right or wrong? And I'm not in any way endorsing what he's saying, but in terms of what's getting put out there to the public.
I think it creates pressure on everybody to have cameras in here, from the jury to everyone involved. I think this is a very high profile case, probably one of the more high profile ones I've ever been involved in. I think there's pressure on the prosecutor, the jury, everybody involved in this case. There are a lot of people watching, including very, the executive branch, everybody's involved. So I think just those comments and everything else is just pressure to me.
But those kind of comments, like a comment that a prosecutor is pandering to the camera, if that gets to prospective jurors, and that prospective juror is sitting in court as a juror and is asked to evaluate the arguments of a lawyer, and he or she already has a preconception that, oh, this is a guy or this is a court that is pandering to the camera, what does that do to the reliability of the fact finding?
It is what it is. I don't have anything else to say about it.
We'll be live. Matt Johnson alongside my friend Kelly.
What was on the September 29th, what was CNN's sort of capsule of what the hearing was about, the appointment of counsel hearing? What was their headline?
Yeah, so confessions, DNA, and his grandfather's rifle. This is the evidence so far on the Charlie Kirk shooting suspect.
What did confessions and DNA have to do with what was happening in court on the
Nothing.
29th?
And again, this is just in every hearing and everything you see, it triggers the same information and the implication that this stuff is part of the hearing. So people aren't necessarily watching the live stream. A lot of times in these courts, you're watching the coverage of the live stream, not the live stream itself. Like in the survey, not a lot of people, it's like 25% watch the live stream, but people are seeing this stuff on TV, and this is what the media coverage is. So it's not showing the live stream, it's screen captures, it's like a short summary of what happened, and then going into this information and the perception that this was evidence presented in the hearing when it was not.
And the substance of it, confessions, DNA,
Exactly.
is sending a message, is it not?
Yes.
Now, is this, again, on the December 11th court appearance, I want to ask you how Fox News covered it, and with one of their talking
just
heads
add
here.
to our comments about his demeanor in court earlier. We talked a little bit about don't try to understand the mind of a monster. Well, we do know a little bit about the mind of this monster, in that I believe he's incredibly proud of his handiwork. It makes us think a lot about Luigi Mangione. These two men inscribed notes on the bullet casings that they used to commit murders, murders that were to send a message. He committed an assassination in a very public place against a person that he had ideological differences with, entirely politically motivated. That is a person who's proud of their handiwork. So I think that when we see him loose and calm, relaxed, and smiling in court, I think that's an outer manifestation of his inner feelings, that he is very proud of what he's done, stands by what he's done, has no remorse for what he's done, and is looking forward to the world watching.
Jonathan, I see you nodding in agreement.
Yeah, I think that's exactly right, as Josh put out. When you have cases of this kind, you are off the map. You are where monsters dwell, to use pirate terms. This is where you find monsters, are in these cases. And you find people that don't think the way you do. This is one of the reasons jurors often stare at defendants whenever they can get away without being impolite. They look at these defendants to try to figure out something not just about them, but themselves. How can someone go off the map to this degree? The evidence here is overwhelming. And a lot of attention is likely to be what possesses a person like this to treat someone like Kirk as a trophy. And that is what happened.
Well, if it's true that he did it and he gets convicted of it, I guess you could say that, he thought in his own twisted mind that it was something that he needed to do, and you could never understand, as you were pointing out earlier, Professor, Trey was pointing out, the person who drowns their children and the person who bludgeons someone to death. You could just never get inside that mind to even begin to understand what's going on.
Is it your understanding?
That's right. I think that's absolutely true.
Yeah, that does it for us here.
You're understanding the first commentator, the first talking head there is an ex-prosecutor, right? And is he sounding like a prosecutor talking about the mind of a monster?
I mean, to me, it's more sensationalism. First of all, again, negative character evidence is some of the most prejudicial pretrial publicity that you can have, emotional negative character evidence, particularly in death penalty case. And you're hearing mind of a monster, he's a trophy. I mean, he's smiling. Like, what is the basis of any of this? Like, there's nothing from that hearing or anything that is relevant here. Like, this is just pure speculation and sensationalism.
Now, the second speaker, the guy who chimes in and says, yeah, this is the evidence is overwhelming. At this point in time, had any evidence been disclosed to anybody, either in the court hearing or, as far as you know, any place else?
The only thing we've had is a press conference with the charging document.
So the second guy, a law professor from Georgetown in Washington, what would have been the basis for him commenting that there's, all kinds of evidence here, agreeing that we're dealing with monsters? What is the factual basis for that?
I guess from the charging document.
Okay.
Just add to our comments about.
Now, did you also take a look on that same date of the Fox coverage? And this is from the ex-FBI agent. Is their talking head here?
Yeah, and the sociopath stuff feeds into what we've heard earlier.
Well, my first reaction is looking into the courtroom and seeing what's happening. Again, talking about Robinson, it's disgusting. He's a true sociopath. It's someone who has absolutely no empathy. They have no remorse. They have no conscience. He killed somebody. He doesn't care. He's smiling. But again, that's not going to serve well. When the trial comes to pass and the death penalty is on the table, again, jurors will not be okay with that. The other thing that I think is very important to understand is that working with these victims, I know myself when I was an FBI agent, I wanted a victim-centered approach. Erica Kirk and those in her surrounding sphere, her family, her loved ones, Turning Point family, they are the victims of this. And frankly, the American people who have had to watch this absolute catastrophic tragedy and evil live on television. I mean, it's disgusting, it's heinous, but she has a right to know. And I do think it's very important in this process that you are working closely with the victim. And I assure you that they are. She deserves to know what is going to happen. She didn't wake up one day and become a legal expert and a law enforcement expert. She is the victim of this most heinous crime. And again, God bless her. God bless her family. And I do appreciate that there are people that will step up to the line and will hold her hand and walk her through this process, as that is what she deserves. There's several other things that come to my mind in this trial, but it does come down to the judge's decision. But the conspiracy theories are despicable. They are disgusting. And you are profiting off of someone who has been murdered. And that is wrong. That is sick. And if you think that you're helping justice to be served, you are wrong. You are doing no favors for the prosecution team. There are solid law enforcement officers on these investigations. Trust that they are doing the right thing for the right reason. Look, I come from the FBI. I understand why people are in a position where they do not always trust the criminal justice system because of things that we have seen in our country. But rest assured, on this investigation, no stone will be left unturned. All eyes are on this, and there will be no mistakes made. And so please do not take the liberty to go and make up and fill in the gaps where you do not have answers. It is inappropriate. You are not helping things. You are making things worse. And if you want justice to be served, you need to let the process work the way that it should and stop putting these lies into people's minds, because you are hurting people. And most of all, you are hurting Erica Kirk, her family, and her loved ones. It is unacceptable. It cannot be tolerated. And anyone that has a clear conscience about making money and creating clickbait, that is sick.
Yeah.
Now, what about that segment educates the public about what was happening in court on December 11th?
Yeah, clearly it's not. It's in the backdrop of you see just, in a corner of the courtroom, but it's just, again, an opinion, a diatribe basically about, there will be no mistakes, no stone will be left unturned, and that the prosecutor's doing everything correctly and so on. So
Does the literature tell us anything about what impact it has in terms of who the person speaking is? Like, this is an FBI agent, ex-FBI agent. So do people listen? Does research say anything about that?
It's just like a source credibility question. I mean, yeah, I mean, law enforcement, people know who she is. I mean, it's not always the case that a stranger is seen as credible, but definitely when you hear more prominent people saying it, absolutely. And just you think about how people passively consume information. So you're not really, when you have this on, you're not necessarily highly critical of what's being said. It's passive consumption of news. So you're not questioning the source per se or thinking, well, this is maybe not appropriate. None of the evidence has been presented yet. It's editorial masked as news, basically.
I notice in this clip, she's critiquing the conspiracy folks from trying to profit from their commercial ventures.
Yeah.
And as she's making this critique, you notice the advertisements running on the side of the video. You get a loan for a car loan.
Yeah.
4.99%.
I mean, it's an ad because it's online. I mean, yeah, there's an ad there for sure. So they're monetized. Is that the point? That they're monetizing it? Sure.
Right. Is that typical of the coverage you're seeing here? In other words, especially on the social media, if you go to social media and try and pull up these clips, you get the clips, but you get a lot more, don't you?
Yeah, I mean, you're always going to get ads on social media. That's how they make money. Are you asking about more like in terms of how, like what surfaces and what becomes viral, or?
Well, we'll get to that.
Okay.
That's a separate issue. Okay. This is the, I'm going to skip
And
that
accused
one.
of assassinating right-wing political activist Charlie Kirk is
Was there also at the December 11th hearing quite a bit of focus on the tie that Mr. Robinson was wearing?
Right. So to me, the thing that stands out is you could see the impact of some of this stuff that's irrelevant. So there was a reference to his tie. It was like trans tie. And then a pro-trans tie, whatever that is. And that becomes a search term. So people want to know more about that, or, just following his court appearances and so on. So people are more engaged. They're actively searching, which is different from passive consumption.
Okay.
And just to be clear, I mean, there was an increase. I don't know what the numbers were before, but yeah, there was a significant increase in those searches.
And Mr. Burt, I don't mean to interrupt, but I just want to give you 45 minutes remaining.
Somebody just passed me a note.
All right, good deal.
I got it. Thank you.
And the country, even the world, watching as Charlie Kirk's accused assassin made its first in-person court appearance today.
Is this another segment from our body language expert?
Yes.
Where he talks about he didn't see any grief muscle?
Yes. So
what is a
apparently,
grief muscle?
do I know what a grief muscle is? I don't know. So apparently the grief muscle wasn't functioning properly to imply grief by looking at the clip.
And that was the focus of the coverage. It wasn't who got appointed, who the lawyers are, what the next procedural step is, whether he was showing a grief muscle.
Right. So again, we're just back to this conjecture of, well, nothing interesting happened in this hearing, so let's find something interesting to talk about. And it's staring at the defendant and making an assessment of what he's thinking or whether he has grief for what he did based off of his grief muscle, whether it was, I don't know if it was not doing the right thing. I don't know.
Okay. Was there also in this hearing sort of a focus on what a high level of security was necessary to manage Mr. Robinson?
Yes.
And the local KT.
New video showing what we believe is Tyler Robinson's police escort leaving the courthouse in Provo just in the last hour. Robinson accused of murdering Charlie Kirk during an appearance at Utah Valley University back in September. Thanks.
And what kind of message is that sending to prospective jurors?
Well, I think in a case like this, like I could see it creates anxiety among prospective jurors. Like this is dangerous potentially. Like there's always pressure, on a high profile case in terms of juror serving, and then adding cameras to the courtroom, risk of somebody being disclosed as who they are. And then you have, news stories about SWAT teams and all these things just to kind of at the courthouse.
And how about the inference here that Mr. Robinson has to be transported in a SWAT vehicle?
Sure. I mean,
in terms of his dangerousness.
I think it's just the nature of this case, of the danger of it.
Okay, we're going to skip that. And I want to ask you, did the court coverage then cause responses that sort of are connected with a court appearance? And in this case, you have the court appearance on the 11th, and then 2 days after, is there sort of a responsive appearance by Mrs. Kirk to the events that happened in court regarding whether the defendant should have discovery or not?
Right. Yeah.
So was this coverage on December 13th a nationally televised town hall?
It is on CBS.
Let me play you just a little segment of that. And I have a question.
What is going on? Why are there so many conspiracies spreading about what seems to be a pretty open and shut case?
This is the first time that we have seen evil on display where we have social media at our fingertips. Something so evil that happened, people are wanting answers immediately. They are wanting to figure out how to wrap their mind around this. Egyptian planes.
Egyptian
Egyptian
planes. Do you believe that Tyler Robinson murdered your husband?
Yes, I do.
Why do you think it is so hard for so many people to believe that reality?
Because it's too simple. Again, everyone always has to think there's more to the story. Well, sometimes there's not. I've seen the autopsy report. I've seen our case pulled together. I've been in constant contact with our lawyers, the prosecuting team. I've seen it all. And let me tell you this. Why in the world, why should we, prior to the trial, lay all of our hands and cards on the table for the defense team to see, to somehow then, I don't even know what they would do with it. But what I will say, and I want to get on the Egyptian plane thing, we'll take a flight on that for a second. What I will say is what I'm worried about, and I'm fascinated, just from a legal standpoint, to see how the United Healthcare trials pans out. And I say that because this is the first time where we are seeing the implications.
You're talking about Luigi Mangione.
Correct. I prefer never to say any of their names. They do not even deserve the ounce of oxygen and breath out of my body. But what I mean is it's fascinating to see how social media will impact that court case, just how it might impact mine.
Are you nervous he's not going to get a fair trial?
I'm nervous that there could be, they'll say we can't find a fair jury. Like they're going to taint the jury pool. And in that case,
that's how widespread you think these conspiracies have gone.
Yes.
That's how mainstream they become. Okay.
Egyptian planes.
So one of your categories was immiscible evidence, right? And I know you're not a lawyer, but you're generally familiar with, there are certain things in a penalty phase of a capital case that a victim impact witness can say and certain things they can't say, right?
Sure.
Like you can't express opinions about the defendant, as an example. Why is this sort of coverage prejudicial in relation to her commenting on court appearances and whether Mr. Robinson should have the benefit of discovery and her opinion about guilt and the narrator's opinion about the evidence being overwhelming?
Yeah, so I mean, I think there's a lot there. I think one, obviously, there's a lot of empathy for the victim's family, and I think that's very appropriate. So she's a credible source, I would say. I think it's not ideal to have a victim saying that due process shouldn't be complied with, the idea of discovery and why are we sharing, exchanging information, which is the way that due process works. And then the references, I've seen the evidence, I know, it's an open and shut case, essentially commenting that he's guilty and the evidence suggests that, would definitely be prejudicial and create a presumption of guilt among prospective jurors. So it's kind of like, a lot of that. I think the thing about the conspiracy theories, which are this is not the first time. I mean, if you look at like DePape case when David DePape attacked Paul Pelosi, trying to kidnap Nancy Pelosi, and Elon Musk was spreading rumors about his relationship with the victim and implying they had all that. So it's definitely not the first time. It's unfortunate it happens, but it happens a lot.
Okay. Now you have many more examples in these clips of similar things,
Yes.
right? The basic point being, we're not getting information about the court proceedings, educating the public about how the law works, but we're getting a lot of opinions going to the issue of whether Mr. Robinson is guilty or not.
Yeah, and I'm not saying this was triggered by the court hearing. I mean, I get it was in the sense that she's commenting on what happened.
Right.
Yeah, so sure.
So I want to talk to you about and we're going to skip the other examples because we're running out of time here. Let's talk about your survey.
Okay.
So walk us through that. First of all, what was the methodology of the survey?
Sure. So again, this isn't a change of venue survey, but it follows the standard practices put forth in the ASTC, American Society of Trial Consultant Professional Standards. So we're using a random digit dial technique. Everybody has a known chance of being selected. So it's not a text message sampling approach or email or anything like that. It's phone calls, cell primarily.
This is its focus exclusively on Utah County.
Yeah. So they have to be jury eligible. So they have to either be registered to vote in Utah County or have a driver's license with a Utah County address on it to be included. And then the survey is designed for initially you're just capturing general impressions of the criminal justice system to get people familiar with the study. And then we're going for this one, it's case awareness, like we would do typically, case recognition, prejudgment, just to get a feel of what's the baseline, where we at today in terms of that question, a fixed opinion question. I call it like a presumption of guilt question. Would the defendant have a difficult time convincing you that he's not guilty? So it puts the burden of proof on the defendant. And then where their source of information is, like is it getting it from local news, social media, national news, things like that. And then a couple basic recognition items, how they watched streaming, which was probably, if I did another survey, I probably wouldn't ask it that way because I think based on what we saw, like people aren't per se seeing streaming of the hearings. It's the commentary and post hearing stuff that's really coming out from that. Whether they knew about a confession, I think it's probably better text messages because that's primarily what I'm talking about, and a few other things. So
what were the key findings of the survey?
Yeah, so high level, so the recognition rate is pretty much everyone, 99%. This is based off a sample size. It's a smaller sample. Again, this is just a snapshot of 200, not the typical 400 that we would do like in a change of venue survey. And then guilt was high. So 64% believe that he's guilty of murder based off of what they've read, seen, or heard about the case. Only people that answer that question are those who know about the case. The 3 people that didn't know about it didn't answer that. Only 7% reported that he's not guilty. That fixed opinion question, you can see over 50% already believe that the defendant would have a difficult time convincing them that he's not guilty. And 35% believe he should be sentenced to death at this point. And 65% have a somewhat or very negative opinion of the defendant, which fits into all that negative character evidence that we just walked through for the last.
So based on the results of this, would you conclude that there's been so much publicity in this case that it doesn't matter whether we get any more because the jury is already, or the jury pool has already been so tainted that adding more to it is really not going to change the equation?
So the idea is Utah County is so saturated that you can't get a fair trial here. So just
right
play
at this
more
point,
coverage?
it's so saturated. The court should do nothing to try and control the publicity, and because it's basically a done deal.
Well, a couple things. One, there's also a lot of media coverage coming out of this in Salt Lake City, which would be the largest county, which is where you would typically move it to. So then what you're saying is, well, there's so much coverage here. Let's just have a free flow of sensational, prejudicial media coverage. And then down the line, when it's time for a change of venue, you can say, well, there's nowhere to move it because Salt Lake City is just as bad. So I guess you're sorry. So there's that as my first reaction to it. And then I think, look, this is the baseline of where we're at. So you still have, like for the death penalty question, it's only 35%. You're not seeing above that 50% mark yet. We don't know, like a lot of it, a big one is case knowledge. So you might find that recognition rates are high here, and I'm sure they're high in Salt Lake City and everywhere else. But it doesn't mean people identify with the case, went to the university, have personal connections, know all the case specific facts. We don't know any of that.
So in your survey, only 35% of those polled indicated that Tyler Robinson should be sentenced to death if he's convicted?
At this point, yes.
And in terms of whether he was guilty or not, you've got 64%.
Right.
Okay. What else about the survey?
So as you'd expect, people are following the case. So people are following it somewhat or very closely. Sometimes in big counties, those numbers are lower because you'd expect in big counties, there's so much else going on that it takes a lot for a case to capture people's attention. Unlike smaller communities where they're shocked and follow very closely, kind of back to the Kohberger case in Idaho. And then you can see everyone's talking about it. So 96% reported that they are talking about the case or they've heard others talking about it in person or online, which also suggests that the big county is taking on characteristics of a smaller community. And you, in terms of source, so 53% are getting the news about this case from social media. We kind of skip that, but there's a lot of sensational stuff that's being created and clips and reels and inflammatory comments and screen captures from these hearings with comments on them as well. And then people have seen something on social media about this case, 69%. And then they've seen something on YouTube, 34%. And then 45% have seen something about the case on local television as well.
Okay. What does this slide show?
Yeah, so just high level, again, this case is capturing this community's attention. Despite the size of the county, 99% recognition rate. That's very, very, very high. I don't see that very often. And they're following it somewhat or very closely already, and nothing's really happened yet. We haven't had a preliminary hearing. We haven't had the big things happen. We've had pretty procedural-esque hearings about, counsel in terms of gag orders and things like that, and they're already following it closely before the really sensational stuff starts coming out.
Okay. I think this is summary of what you've already said, correct?
Yeah.
So you mentioned this before, but in terms of where people are getting their information from, are they picking this case up from watching live stream or through other sources?
They are not. So if you go back to the prior slide, which is from the survey, this is specifically about the case. They're picking it up from social media, local television. Those are the big ones. They're not watching live streams. I think it was like 25% said they've seen like a clip or part of the live stream, but they're seeing news footage on local TV, which we already went through, that has prejudicial commentary about these hearings, whether it's the body language expert or the lip reader or any of this stuff. All that stuff is coming out in those sources, and that's what they're saying.
Okay, I'm afraid I'm going to have to stop here. I hate to do it, but I have to. So,
all right, turning to the state for cross.
Do you want this up? Or no?
I think so. Good afternoon, Dr. Edelman.
Good afternoon.
You mentioned that in your amendment, you were consultant.
I did.
And with respect to that, it's more of an advocacy-related position.
When I'm wearing that hat, yes.
When you're wearing that hat. And this hat, you're more of an objective witness.
Absolutely.
Correct. We've talked a lot about today. You've talked a lot about today. We've seen some slides about the negative pretrial publicity towards the defendant. Mm-hmm. Did you research negative pretrial publicity towards Charlie Kirk?
I'm familiar with it. Yes.
Did you research it as part of this assignment?
No.
This employee. Did you do any research with respect to negative pretrial publicity towards Erica Kirk?
Towards who?
Erica Kirk.
I did not.
Are you aware of the negative publicity that's out there?
I'm aware of the awful conspiracy theory stuff.
Okay. What about, did you research negative trial publicity towards the prosecution's case?
I've seen what that stuff is, and most of it is not from what would be considered mainstream sources. You're talking about people who support conspiracies all the time about windmills killing whales, and that Winston Churchill was the true villain in World War II. So I don't put much stock in that kind of stuff. I know it's out there. I don't think it's comparable.
Okay. What about pretrial publicity, positive pretrial publicity towards Mr. Robinson? Did you look into that?
No, and I don't think there's much of that.
But you didn't specifically look into it?
No, and there's social science literature on that, that positive pretrial publicity does not mitigate or eliminate the effects of negative pretrial publicity.
Are you familiar with Professor Christine Ruva?
That's her research?
Her research?
Yeah.
Because she would say otherwise, wouldn't she? That
Well,
positive pretrial publicity towards a defendant would tend to mitigate?
Positive mitigates? You're saying she says that?
Sure. That positive pretrial publicity towards a defendant would tend to mitigate guilty verdicts.
There is very little pretrial publicity that tends to be positive, and from my experience and what I've seen, no, it does not. You have a mountain of negative pretrial publicity, and you might have 3 stories that are positive. That does not mitigate a mountain of negative pretrial publicity.
Okay. But it would depend on what that juror was exposed to, correct?
Well,
What he or she
again,
paid attention
most
to.
of the pretrial publicity in cases like this is negative. So if you're implying that it's balanced, I would say absolutely not.
Okay. In your survey, I'm going to turn to a few of these questions. I believe it's number 2 in the binder there that you have.
Yeah.
The question was asked on question 6A, if you want to go to that
Give me
question.
1 second here. Which tab is it? Sorry.
I think if you go to number 2, tab number 2.
Okay, got it. Which question?
6A.
6A. What 3 words best describe?
Yes. You identified, there were a number of respondents that had a negative attitude towards Charlie Kirk.
Sure,
in
I
your
think so.
survey, correct?
I think that's fair.
For example, multiple people referred to him as a racist, correct?
Okay.
This is your survey.
Yeah. Again, the question above that is 64% or so have positive opinions of Charlie Kirk. So you can cherry pick comments in there, but in general, overall, people have positive opinions of him in this
But
community.
there are people within this community that have a negative attitude towards Charlie Kirk.
Yes, I'm
Correct.
sure, and nationally.
Okay. He was called inflammatory in your survey, correct?
Inflammatory?
Uh-huh.
Which comment? Oh, that's what someone said?
Yes.
Okay.
As a misogynist.
I'm not disagreeing with you. You could cherry pick as many as you'd like.
Asshole. Harmful.
Mm-hmm.
Did people respond like as if he were that he's a bully? Did you see
Okay.
that? A bigot.
Okay.
Homophobe or homophobic. Multiple people put that.
Okay.
Divisive. Prejudice.
Sure.
Evil. On the other hand, you asked what 3 words best describe Tyler Robinson, correct? And that was question 5A.
Yes.
And isn't it true that a number of people responded with not guilty or innocent until proven guilty?
Sure.
Okay. We would like people to respond that way, correct?
I what?
You would like someone to respond that way.
They can say whatever they want. Again, this isn't a change of venue survey. This is just measuring awareness of the case in where we're at today.
Okay. Multiple people responded with respect to what 3 words best describe Mr. Robinson as scapegoat, correct?
Multiple out of the 200, how many you got there that say that?
More than one.
More than one?
At least more than one.
I can see plenty of confused, radical, guilty, mentally incompetent, messed up person, lost, confused soul, very confused. I mean, I'm sure there's a array of many different things in there, from mental illness to evil to.
Let me take you to page 21.
Page
Of
21?
your survey, correct.
Next to, okay.
Do you see scapegoat about maybe a quarter of the way down or so?
I see piece of shit, sad, so bad, selfish, guilty, suspicious, troubled.
What about scapegoat? Do you see scapegoat?
I do.
Okay. A few lines down, maybe 10 lines down, do you see scapegoat, victim?
Scapegoat, victim. Okay.
Okay. That would imply that some of these conspiracy theories out there are taking hold of people within this community, correct?
Among the friends, I'm sure there's people that believe that. I never said there weren't, but I don't think that outweighs the majority of people who think he's guilty and all the other awful things. And remember, Charlie Kirk is not the one on trial in this case. It's not going to be about whether Charlie Kirk is guilty or whether he should be, what that punishment should be. It's about the defendant. So in the majority of opinions towards Charlie Kirk in this community are positive. So there are people that have negative.
Okay. Would you agree that negative publicity towards a victim has an impact on prospective jurors?
Not in the guilt phase, maybe in the sentencing phase.
Not in a guilt phase.
Not in the guilt phase. I don't think that whether or not they have a positive opinion of the victim implies whether or not the defendant is guilty.
I mean a negative opinion towards the victim.
Towards the victim?
Yes. Does a negative opinion towards the victim
does that mean
play into the mind of prospective jurors when they come in?
So if someone thinks that Charlie Kirk was a divisive figure because of what he said publicly, that the defendant's not guilty?
Sure. Well, could that have an effect on the verdict?
I don't think it will in this, no.
Okay. What does the literature say?
I don't know of any literature that would fit that scenario.
Okay. Question 6B asked about whether someone has what's your opinion of Charlie Kirk? Two of the potential responses was somewhat negative and a negative opinion.
Right.
25% of the people in our community in this snapshot have a negative opinion towards Charlie Kirk, correct?
66%, 63% negative, 25%, or I'm sorry, 63% positive, 25% negative.
So 25% negative. Thank you.
And just clear, I'm not saying change of venue.
Objection, non-responsive.
Doctor, this is not where you get to make statements. You can respond to questions, and that's something we do to make sure it's balanced. So I'll ask you to respectfully do that.
Now, question 2A reads the following. Now, I'd like to ask you about an upcoming jury trial in your community. Back in 2025, Charlie Kirk was shot and killed during an event at Utah Valley University in Orem. Tyler Robinson was later arrested and charged with intentional first-degree murder. Have you read, seen, or heard anything about this case?
Yes.
You asked that question.
Yep.
And that's where 99% of the people, there's case awareness, 99%, right? But that question doesn't really help us with respect to, can Tyler Robinson get a fair trial in this community, correct? Case awareness?
I didn't ask that question. That's not the purpose of the question. The purpose of the question is to identify what the recognition rate is, how many people are familiar with the case. Okay. That's the purpose of that question.
Okay. So it doesn't relate to whether or not he can get a fair trial. People's awareness of it.
Don't think I said that.
Okay, fairness. That's fair. Dr. Edelman, what is your understanding of the purpose of this hearing, of the motion in question here today?
To the question being towards whether or not there should be television cameras in the courtroom.
And why does it matter if there are televisions in the courtroom or there's pretrial publicity?
Because it creates sensational, misleading media coverage that undermines the defendant's fair trial rights.
Fair trial rights.
Yes.
Okay. Because of the media coverage. That's why we're here. And isn't it about impaneling a jury that could sit in judgment on Mr. Robinson? Isn't that the ultimate question we're trying to get to?
The ultimate question is, can he have a jury who has not been prejudiced and comes in with preconceived notions of his guilt, that don't have case-specific knowledge, that as the trial goes on is stimulated and activated by hearing new information. There's a difference between a jury that in a community that doesn't know the evidence and hears it for the first time and maybe convicts a defendant, and a jury that comes into a courtroom somewhere else and all the information confirms what they already know and they convict the defendant. The outcome's the same. The process is very different. And that's the problem.
Okay. So it comes down to, can he get a fair trial with a jury here in Utah County?
In Utah County? Again, I'm going to keep saying this. This is not a change of venue survey. I didn't recommend for a change of venue. My limited purpose was to assess where people are getting information about this case. Are they following it closely? What sources are getting it from? And are they developing negative impressions and a presumption of guilt? And this stuff here we're talking about, this data are the baseline, and the questions are going to get worse, or it's going to stay here.
But we end up at the same point. Can we seat a jury to sit in judgment on Mr. Robinson? Can he get a fair trial?
Not based on this. Maybe that comes down later after, when we're closer to that. The question that this survey was designed to measure is, where are people getting the source of their information? Are they seeing prejudicial pre-trial publicity? Are they following it closely? And what impact it's had so far? And what's the baseline? So leave cameras in the courtroom, and then you get more of the stuff we just walked through. And then the preliminary hearing comes out, and then witnesses testify, and all of that prejudicial stuff comes out. And then there's more negative pretrial publicity. And now we're back here in 6 months or a year, whatever it is. And we are talking about change of venue because everybody in this community has been saturated. And the numbers you see in the survey, like guilt, is now 70, 80%. And prejudgment on sentence is over 50%. And everybody knows prejudicial details. That's what we're trying to avoid.
Fair enough. Fair enough. But the ultimate risk that we're getting to is whether or not we can seat a jury here. That's why we're asking these questions about what are the effects of cameras in the courtroom.
Correct? I disagree with that. I think you can always find 12 people in any venue to raise their hand and say, yes, I can be fair and impartial. If you look at Rideau v. Louisiana, it was the most prejudicial confession the Supreme Court could imagine. It was recorded in the sheriff's office, put on TV, and all those jurors, 12 of the jurors, all of them said they could be fair and impartial. 3 of them had seen that confession, and the Supreme Court said no. So just getting people to say they could be fair and impartial, I see it all the time. I do it as an advocate when I do jury selection. It's a common thing. It's easy to get people to say, I can set it aside. That doesn't mean they can, and there's no evidence in the social science literature that supports that they can, particularly when they have case-specific knowledge. But you can definitely explain to them the law requires you to be fair. Can you set it aside? Yes. So yes, you can find 12 people here or anywhere else to do that.
Thank you. Question 3AI, if you could take a look at that.
Sure.
This is the question about, you referred to this earlier on direct. Given what you have read, seen, or heard about this case, would Tyler Robinson have a difficult time convincing you that he is not guilty of intentional first-degree murder? You asked that question, correct?
Right. So it's based on what, yes.
Now, you would acknowledge that this question shifts the burden to Mr. Robinson, that he has to prove his innocence.
Oh, I'm sorry. Which one? Oh, you're talking about, yes, I'm sorry, 3AI. Yeah, so that is a question that a judge in Tennessee came up with. Yes. And it was a measure because people would say they could be fair and impartial in the jury selection. They expressed bias and said they could be fair. And then he said, well, could you put the media out of your mind, or would the defendant have to prove that he's innocent? They go, oh yeah, he couldn't change my mind. But yes, so it was an inconsistent answer. I thought it was an interesting question, and it correlates better with other variables in surveys than can you be fair and impartial. So I use.
But it does shift the burden to the
for the
defendant
jurors,
in that question.
they think it shifts the burden. It's not telling them the burden is shifting. I don't think the question shifts the burden. I think the question is, would people already hold the defendant to that burden?
Okay. And it's your experience that that question was asked in Tennessee?
That question correlates with things like case knowledge, strength of opinion, and all these factors that you would expect the question to correlate with if it's a valid, reliable question. In contrast to, can you be fair and impartial, does not correlate with any of those things. So people with a lot of case knowledge are just as likely they could be fair and impartial as people who don't know anything about the case. So that is would be considered a questionable, like the validity of that question is problematic.
Okay. Take you to question 7A.
7. Yes.
The prosecution is seeking the death penalty for Tyler Robinson. If Tyler Robinson is found guilty of first-degree intentional murder, which sentence do you believe he should receive, the death penalty or life without the possibility of parole? Are you familiar that before, if Tyler Robinson is found guilty of aggravated murder, which is the actual name of the charge here,
Sure.
it would then go to a sentencing phase.
Right.
On a question
Very familiar with that.
of death, correct? And you're familiar that the jury would be instructed that they would be required to weigh both mitigating and aggravating
Yes.
circumstances
Is this a weighing state? So it's weighing the two. Okay.
before deciding on the question of death or life without possibility of parole, correct? Is there a reason why you left that fact out, that the jury would be, that they would have to weigh mitigating and aggravating
Yeah.
circumstances?
So again, this is a snapshot. This is not, it's, for example, I wouldn't read an instruction in a survey about the presumption of innocence, and there's like, if you look at the ASDC standards, you're not supposed to do that. This is where people are at today. It's a snapshot of their bias. It's not, oh, I think you should get the death penalty, but you'd now explain the entire system to me. So I've changed my mind. I don't think you should get the death penalty. So
Well, isn't it true that if you were to explain to them that there's mitigating and aggravating factors to be weighed, that the number of people who would support the death penalty, that would respond yes on this question, would go down?
Why do you say that?
Because you would have explained further process.
So explaining the process means that they change their opinion? Do I then have to?
If they were instructed in this question that they are to weigh mitigating and aggravating circumstances before coming to a conclusion,
the question,
wouldn't that tend to depress the number of people voting for death penalty in this snapshot?
I think you'd get invalid data potentially. First of all, you'd then have to explain how to do that. You'd have to explain, well, they don't know what the mitigators are. Then you'd have to ask like death qualification questions. Well, I think I could consider mitigation. Okay, under what circumstances? Oh, if it's self-defense. Okay, well now let me ask you another question. What about a case of intentional first-degree murder? Could you consider life then? But well, no, now I can't. So all of that stuff you'd have to include, which creates complexity, and that's not the purpose of this survey. This is not jury selection. Survey is not designed to be jury selection. It's not designed to be death qualification. It's where are people at today? And people have opinions, and that's what this is capturing. This person has an opinion that he should get a life sentence. This person has an opinion that he should get a death sentence. That's based on what they've read, seen, or heard about the case. That's what I'm measuring.
Understood. But important critical details are being left out before someone would be charged with making that decision, death or life without the possibility of parole, correct?
I mean, that again, if this was a change of venue survey, maybe I would say like, here's an important mitigator that's coming out. And then when the juror says like, I think you should get a life or death sentence, ask a question about a mitigating factor and see if they could consider that or if they could weigh that. But that's not the purpose of the survey. And maybe if it comes to that, those are things that you would typically put in those kinds of surveys. But that's not the purpose of this.
Are you familiar that in the state of Utah, if someone is convicted of aggravated murder, that there is certainly the possibility of death, life without the possibility of parole, but also 25 years to life with the possibility of parole? Are you aware of that third option?
I wasn't, but sure. Okay.
Should you have put that, had you been aware of it in your questionnaire, in your survey?
I mean, I think most people would be, from my experience of doing these and getting, the bigger thing is people are fearful that life without the possibility of parole is not actually life. And they're worried that that person will get out. So giving them an option to have a shorter sentence, I don't think is going to reduce death penalty numbers. It might take the life without the possibility of parole, and some of those people might say life for 25 years. But I don't think someone with death is going to say, no, I think I would just give them life, 25 years.
Okay. But it's another option that
it
probably should have been included.
You can, sure. I don't know if I would, knowing it. I still, maybe I would just say life or life without possibility of parole, or perhaps.
Okay. So you've talked about how surveys like yours, they're snapshots in time, right? And surveys can't predict future conduct. Is that fair?
Well, I mean, it depends on the survey. Like some surveys may, like if you ask people about if they're going to vote in the next election, and there's data there, it could predict whether they're going to vote or not, or something like that. It just depends.
Okay. But you would acknowledge that your survey here, it's a snapshot of people's awareness and feelings in the community today.
Yes.
It doesn't represent real world experience of what a juror would experience if they were summoned to jury and selected to be part of this jury.
So does the survey capture whether how a juror will react as a juror?
If they were to hear the evidence in a court of law.
No, I mean, I think I would think of this more as a snapshot of the community and then what the social science literature tells us. So we know, for example, people who have a lot of case knowledge are much more likely to convict and process information and be consistent with how they see the world. So if they already think he's guilty and they already know all the evidence, they're more likely to interpret the evidence in a manner to support that position. So we do know that. So you can kind of look at extrapolate from the survey data in that manner, but it's not designed to predict, okay, this means these 12 jurors will disregard the evidence and acquit him or convict him or anything like that. That's not the purpose of the survey.
So the purpose is quite limited in reality.
I don't think so at all. That's your opinion, I guess. I'm sorry.
But it doesn't predict future behavior.
The survey is designed to see where people are at today and make an assessment of whether or not cameras should be in the courtroom or not. And you're talking about like a change of venue survey and whether jurors will be fair and impartial in a year from now or what have you. I don't quite get the connection of how that question is tied to whether there should be cameras filming things and then making speculative conjecture about whether someone's grief muscle is flexing in the right way.
So let me ask you a question. I've asked this various ways. What's the risk of cameras being in the courtroom if it doesn't ultimately turn on seating a fair and impartial jury to sit in judgment on Mr. Robinson?
So what is the risk of inundating the jury pool with highly prejudicial, sensational media coverage that characterizes the defendant as guilty, a monster, a psychopath, a sociopath, and so on? What's the risk of that? I think it undermines that juror's fair trial rights. And I think there's plenty of case law where even when juries have been sat and they've served and there's been a conviction, those have been overturned based off of the pretrial publicity. So obviously there were 12 people in that trial that went through jury selection, were determined that they could be fair and impartial, were able to listen to the evidence and reach a decision. And then state Supreme Courts, United States Supreme Courts have thrown those convictions out based on prejudicial media coverage. So clearly there is an issue, and the question isn't, can you find 12 people somewhere in the county that will raise their hand and say, I can be fair and impartial? I don't think that's the standard.
Thank you, Doctor. You mentioned that these were randomly selected respondents. Digit dial, I believe you said. Did you add any numbers to your survey? Or were these all truly randomly selected?
I'm sorry, adding numbers.
Did you add any numbers to be called as part of your survey?
Be called?
Yes.
So the survey vendor deals with the sampling. So
Okay.
I give them the county and then
Okay.
they buy random sample. And then what they do is, so it's called replicates. So let's say they buy X thousand phone numbers and they have to work maybe like 100 numbers and they have to call each one like 3 times, different times a day and all that stuff until they can reach a resolution like, no one ever answered or it's a bad number, and then they have to open up other replicates.
Okay. Did you, as part of your survey, did you ask whether the respondents had any involvement with this case?
With involved in the case? I had
like media, law enforcement, anything like that?
No.
Okay. Did you ask whether they had a relationship with anyone that was involved in this case?
No.
The respondents?
No.
Okay. What screening procedures did you take?
I'm sorry?
What screening procedures did you take?
So the screening procedure is based off of age, right? They have to be over 18 years of age. They have to be able to speak and read English. They can't have a felony. They have to be a citizen of the United States. They have to be registered to vote or have a driver's license with a county address on it.
Okay, thank you. A few more questions about your survey questions. In question 8A, will you turn to that?
8A, yes.
You asked, have you read, seen, or heard if President Donald Trump expressed an opinion about whether Tyler Robinson should receive the death penalty or a life sentence without the possibility of parole?
Yes.
Killing Charlie Kirk. 81% responded no, correct?
To that one, yeah.
Okay. Question 9, you asked, have you read, seen, or heard if any other public officials have said that Tyler Robinson should receive the death penalty for killing Charlie Kirk, correct? And 65% responded no. Is that
Right.
correct?
32% yes, 65% no.
Okay. Question 10A reads, have you read, seen, or heard of Tyler Robinson confessed to shooting Charlie Kirk? 56 responded no, correct?
Yeah, and I think that's a poorly written question because I think the bigger question is more about text messages than when I wrote it, I hadn't seen all the media coverage yet. And I think confession usually is like the person verbally confessed, and this is more about text messages. So if we do another survey, I would probably change that the way that question is phrased.
Question 10B. Have you read, seen, or heard of Tyler Robinson's DNA was found at the scene of the crime? 65% responded no. Correct?
Yeah, I mean, I think your point is great in that we're not at a point where everybody knows all these prejudicial details, and we haven't started yet. These are the numbers of the baseline, and the idea is to prevent these numbers from going up. I think that's ideal for you and the defense and everyone, is for jurors to be not aware of all the details and facts, and that they base their decision on the evidence, not what they've heard in the media. So having low numbers on these things is a good thing.
Okay. The media that we watched on your direct examination, almost none of it was live streaming from the court proceedings, correct?
Correct.
It was third parties' commentary on the case. Correct?
Which is what worries me, not the live stream where very few people are watching.
Sure. But that's correct, right? What we were watching commentary on the courtroom proceedings.
Right. So they're taking video from the courtroom or images and then telling the story of what happened at that courtroom proceeding using the images or the lip reader to tell you what the defendant said or his body language based on his movements and all those things. Yeah. So that's what worries me. It's not a neutral, sterile, here's the live stream, no commentary. Come here if you want to see what's happening and take away. So you're educating the public. Here's an opportunity to create sensational media coverage out of all this stuff.
For the person who wants to actually get accurate information, what's happening in the court, where is the best place for them to go?
I mean, to me, it's like we got accurate information for decades without live streaming. They're called journalists, and they would come and they would write stories, and we'd read about them and hear what happened. We don't need to create a circus-like atmosphere or reality show out of a trial.
What's the primary source that they would go to for accurate? To accurately see what's happening in the court, where would they go?
For who? What are you asking?
For the average citizen who wants to follow the case.
Well, I mean, that's complicated. So like a lot of people get their news on social media, right? Or podcasts, but that social media is also sharing information and content from traditional networks that now have to create more sensational content instead of maybe more quality content, because you have to get clicks and based on an algorithm that's like focused on sensationalism and reactions. So you're trying to create content to get attention there. So,
but that person that wanted the most accurate depiction of what's going on in court would be to come to court, correct?
To come to court? That would be great.
And watch
Sure.
the proceedings.
I guess. Sure. Yeah.
Well,
Yeah,
that's,
no, I
that's
agree.
where it's happening, correct? And short of that, a live stream would also provide that if someone tunes into the live stream.
If it was live stream with nothing else, because you basically have about 25% or so or less watching the live stream. So, and the other interesting thing, if you look at the live stream, it's a forum. All these people are coming to it and just spreading misinformation and conjecture about conspiracy theories and you should get the firing squad and all these things.
And those are third parties that this court can't control, correct?
That's on the live stream. That's not on third parties. That's just, if you looked at it was like Court TV, just the live stream of it, and you watch waiting for the stream to start or during it. It's just a forum of just spreading information that is not accurate, I would say. I'm sure we'd all agree if you looked at it, it's not accurate. But again, it's not like the majority of people are coming. If you balance it and you said, okay, well, 80% of the people are getting their information from the live stream. That's great. And very few people are watching all the sensational stuff. So the costs outweigh the benefits. But that's just not the reality. The reality is most of it is sensational media coverage that's being created from the live stream video. And then you get what we saw. It's not like people are coming to the courtroom or watching neutral live stream and then, wow, I learned so much about the courtroom process today. That's just not what's happening.
But it's not the live stream video that's causing this content by third parties.
Well, how
are pushing it out, correct?
How would the content exist otherwise? The video of it, that is the source of the information. It's take the live stream video, and then rather than reporting on what happened, we'll say like all this evidence was introduced in the hearing today, which is false, wasn't. And it creates the impression that there's all of this prejudicial evidence, which is not evidence, and no one's ruled on any of that stuff in these hearings when that's not what's happening. So people are being misled. They're not being given accurate information.
Okay, but that's created by third parties, not this camera that is behind me live streaming this proceeding today, correct?
I guess. I mean, I don't really get the point.
What do you mean what do you mean you guess?
I don't quite understand the point. So you're saying, yes, there's all this prejudicial stuff is coming from the live stream and it's creating all this prejudicial media content, but it's not from the live stream. It's not that guy over there.
A third party is taking the live stream, which is the accurate recording of what's happening today. And then they're taking that and creating something of it, correct?
So they're taking accurate information and then distributing widely misinformation. So a small percentage.
That's what you're suggesting.
That's okay. I mean, again, yes, I think if you just watched the live stream and there was no commentary on it, and in a perfect world, none of those things happen, then yes, but that's not the world we live in. And if you say there's no limit on the third parties using it, then that kind of defeats the purpose of the idea of just having a neutral live stream.
Okay. And to your question, have you seen any video footage or video clips of the courtroom proceedings from Tyler Robinson's case, for example, on court TV, YouTube, or social media? 74% of the people responded no.
Well, that's my point, is they're not watching the live stream. They're watching the news reporting on the live stream, like on TV, like all the stuff we just walked through.
Exactly.
That's the stuff they're seeing about what's happening. They're not watching the neutral live stream. They're not just saying, here's a sterile live stream of what happened today. They're watching this stuff. That's the stuff they're seeing.
Okay. But again, it's not the live stream that's creating that negative content.
I feel like I'm just going to keep saying the same thing. So, okay.
Yeah. Okay. Just one moment, Your Honor.
Yes, counsel.
Nothing more from the state, Judge.
Mr. Brooks. No further questions, Your Honor.
All right. May this witness be excused?
Yes.
All right. Thank you, doctor.
I'm all done. Thank you. You want me to leave this, sir?
Yes, please. Judge, in terms of a time allotment, I have discussed with the state that they are not going to take their 2 hours. So I don't know how that would affect my time limits, if at all, but I just wanted to let the court know that. I think their witness is going to be very brief.
All right, I see. Well, to the parties, what are the thoughts so you were intending to call the other doctor as your other witness?
Yeah.
The exhibits have been submitted. I believe that the doctors, she had a 36-page report in your original motion. Is that correct?
That's right.
All right. Well, I want to be provide both parties the equal amount of time. So what I'm proposing is that we turn to the state to their presentation of evidence, and if there is time remaining, returning to defense to call the witness as well, and see what time we have and take it from there.
I still think I have some time left on my 2 hours, or no?
Well, including cross-examination, we're about 5 minutes over.
Oh,
but that's from my accounting of time. But we can proceed in that matter, returning to the state, allowing them to present evidence. And if there's time remaining, certainly we return to you.
Thank you.
All right. Thank you, Mr. Burt. To the state.
Your Honor, the state calls Cole Christensen.
All right. Mr. Christensen, if you'd like to come forward, be sworn in. All right, have a seat. Do we have a water bottle for him? There should be water bottles for all of our witnesses, so. Perfect, thank you. All right, sir, if you'd like to make yourself, situate yourself, and then after you're seated, pull the microphone close to you. We want to make sure that all audio is captured. All right, Counsel.
If you could state your name and spell your last name for the record.
Cole Christensen, Christensen.
Where are you currently employed?
I'm currently employed with the Utah County Attorney's Office, Bureau of Investigation.
How long have you been employed with that office?
About 7 years.
Sorry, give me 1 second. Have you been specifically assigned to this case, the Tyler Robinson case, in your capacity with that office?
Yes, I have.
Were you asked to conduct research related to media coverage in the Tyler Robinson case?
Yes, I was.
And who made that request?
Prosecutors assigned to the case.
Did you complete that task?
Yes, I did.
Did you write a report about your findings?
I did.
Your Honor, permission to approach the witness?
You may.
I'm going to do what will mark as State's Exhibit 1.
Okay.
You recognize that?
Yes, I do.
What is that?
That's the report that I created from the assignment that I had.
Your Honor, pursuant to a stipulation by defense, the state would move to admit State's Exhibit 1.
Defense, that's my understanding. Is that correct?
That is correct.
Thank you. It is so admitted and may be published.
And we have nothing further.
All right. To defense.
You have your report there in front of you.
Yes, sir.
Part of your report says that you were your primary focus was identifying negative pretrial publicity toward the prosecution, right?
And
Erica Kirk and Charlie Kirk.
Correct.
And how did you define negative publicity toward the prosecution, Erica Kirk and Charlie Kirk?
How do I define that?
How did you define that when you were doing your search?
I just defined that by the media coverage that was out there.
Right, but how did you determine, well, this is negative or positive?
Based on the way the media slanted, or the way the article or the interview went.
How the interview went.
Uh-huh.
And what did you look at? Did you look at newspaper articles?
I looked at newspaper article, traditional media sources, local, national newspaper articles, social media, podcasts, online platforms, that type of thing.
Did you look at any of the coverage by the major networks, the electronic media coverage sites?
Yes.
And what did you look at in that regard?
What did I
What
look
did
at?
you look at?
I looked at, for one example, I looked at KUTV 2 News, I think is a CBS affiliate.
Mhm.
I found negative pretrial publicity there toward the defendant.
Toward the defendant.
Correct.
And was that generally true of the other major electronic media outlets, that the focus was on negative publicity toward Mr. Robinson?
I'm sorry, I'm not sure I understand the question.
Was when you were looking at the electronic media coverage, and specifically the national network coverage, was the tone of that in general negative toward Mr. Robinson?
No, I think the tone of it went both ways. I think some of the tone of it was negative toward the prosecution, and some of it was negative toward the defense as well. Some of it was negative toward Erica Kirk, and some of it was negative toward Charlie Kirk.
Negative in the sense of making some derogatory comment about Charlie Kirk?
Correct. I did find that, yes, sir.
Okay. And did you do some sort of quantitative analysis in terms of how much there was in each category you were looking at?
No, I just took a sample size. So as far as I could tell you, there's a lot out there, but as far as like a comprehensive review or to quantify it, I didn't do that. I just took a sample size.
How big was your sample size?
Well, I looked at trending high-profile media articles, whether they be in social media or traditional media sources from when Mr. Kirk was shot and killed up until the present time.
you cite in your report a study that says that 86% of US adults say they get their news from smartphones or computers, correct?
Correct, yes.
What was the source of that number?
Do you mind if I refer to my report?
Yeah, sure. I think it's
Okay.
on page 1.
And the question was?
Question was, do you cite in your report a source which indicates that 86% of US adults get their news information primarily from smartphones or computers or tablets?
Yes. That's according to a study that was conducted by the Pew Research Center.
Okay. And is it true that a lot of the what you refer to as negative publicity toward the prosecution, I think you list on page 2, was coming from podcast sources? Candace Owens, for instance, you list.
Correct. That's one that I had found.
And high political figure statements in your report, what does that mean?
That would be, for example, some of the information we just heard, high profile political figures that can be national or local here.
Okay, Israel theories, what does that mean?
Correct. Theories such as Israel or Mossad was involved in the assassination of Charlie Kirk.
You saw a lot of that on the national media?
I did see some of that, yes.
And where did you see it, say, on ABC or CNN, where they were advocating that somehow Israel was...
No, I apologize. That was on social media.
Right. Most of the wackier theories are coming from fringe groups, right?
Correct. There are a lot of social media conspiracy theories out there.
And you were not making any attempt in your report here to compare how much weight someone would give to sort of a fringe report versus a national media report, correct?
No, I couldn't. I couldn't determine that.
Great. That's all I have. Thanks.
Thank you, Mr. Bird. To the state.
Nothing further.
Thank you. May this witness be excused.
Yes.
Thank you, sir. To the state.
Judge, for this hearing, this is all we have as far as state's evidence.
Right. And do you cede your time to defense?
Yes, so long as we were able to wrap this up today with argument as well.
All right. So just to provide some guidance, it is 3:20. We've been going on for about 2 hours and 20 minutes. We're going to take a brief 10-minute recess to allow people to stretch. And how we'll handle this is we'll return so we'll start oral arguments so we'll come back at 3:30 and we will go till 4:10 and allow each side 15 minutes for closing arguments. And then I have some matters that I need to address with the parties as it relates to scheduling a ruling from the court. So we need to coordinate our schedules because we need to end at 5 o'clock. All right. We'll go ahead and be in recess until 3:30. Thank you.
All right. So he's got 15 minutes. Or you got 40 minutes. How much? I think 4:10. 15, 20 minutes.
how they interpret evidence, so a bunch of different things, how they deliberate. So that's what I spent predominant time doing.
When did you get your PhD degree?
In 2001.
What was your dissertation?
My dissertation looked at the effects of negative defendant pretrial publicity on juror and jury decisions at non-deliberating juries and deliberating juries, to look at the different effects of those exposed to pretrial publicity who deliberated versus not deliberated.
Okay. And was your dissertation published? Since that time, have you published a number of studies on the effects of pretrial publicity?
Yes, I have. And my most recent was published just recently in 2006.
How many studies? How
And I've also done a couple of reviews, book chapter reviews, that have also been peer reviewed.
Okay. You, in addition to the 2 reports that are in evidence, also prepared a very lengthy PowerPoint presentation, correct?
Yes, I did.
And you know we're not going to have time to put that on.
I understand that.
All right. If I could bring up, I don't think I'm hooked up yet for some reason. See the screen, but I'm not on it. While we're doing that, let's answer the question. My positive pretrial publicity mitigate the effects of negative pretrial publicity?
And so I've actually looked at that, and I've looked at it in 2 different ways. One that's not realistic and one that is realistic. And so in a case like this, the realistic way, where you have a lot of negative or anti-defendant pretrial publicity come out first, we find that positive pretrial publicity that comes afterwards. So that primacy effect is that information that you receive first has priority. So for example, in a case where a juror has been exposed to pretrial publicity, that information actually influence how the jurors then process the trial evidence, their memory for the trial evidence, and then ultimately how they deliberate in the jury room. And so positive pretrial publicity, if it's presented like a back and forth, like one negative defendant article, one positive defendant article, one negative, when we do that, like every other article, which is unrealistic, to what we call level the playing field. But when you front load the pretrial publicity with all negative pretrial publicity, then it's difficult to overcome this.
All right, and you looked at the pretrial publicity in this case? What we just discussed in terms of negative, positive, et cetera.
So I reviewed all the pretrial publicity that was in the motion. And so I have not, there's no way a single person could review everything in this case, but I reviewed that pretrial publicity. And what I reviewed was predominantly anti-defendant. There was very little that was anything other than anti-defendant, especially early on and in the mid parts of what I reviewed. It was predominantly anti-defendant, looking at the defendant, again, like Dr. Edelman said, painting the defendant light, dehumanizing language, accusations of guilt, and basically giving your opinions upon what kind of sentence he could get. So there was a lot of anti-defendant that went to the credibility of the defendant, which is really important, but also publicity that is likely to engage the public in moral outrage, okay? Because something morally wrong has happened, it's horrible, and again, we have high-profile individuals like the president, the past attorney general, the FBI director, the governor. So a lot of people that have a lot of power and influence coming forth and saying these things about the defendant.
What does the research show when you have a situation where high authority figures, the president, the vice president, the governor, the attorney general, the head of the FBI, are putting out anti-negative publicity on the one hand, and on the other, you get these wild conspiracy theories from fringe podcasters? How does that balance out? Does the podcaster conspiracy stuff swamp or overcome all the negative publicity coming from the authority figures?
And so now you're getting into more of the conspiracy theory research, which I am somewhat familiar with, and I've looked at it, and it is pretrial publicity tangent, correct? Because in this case, we can call these conspiracy theories pretrial publicity, right? Because they are a form of pretrial publicity. And the credibility of the source of conspiracy theories definitely has an effect. We have not, we don't look at the credibility so much in the research of the source of the individual, talking about the pretrial publicity, but they're published in reputable journals, or I'm sorry, not reputable newspapers or TV. And so that gives the impression that there's some authority, there's some credibility there, but actually looking at who is saying it, my research hasn't looked at that, but there's other research that has looked at credibility effects on people's willingness to accept something as true. And definitely in the social psychology and conspiracy theory research, they do find credibility matters.
So how does prejudicial pretrial publicity influence jurors? What is the mechanism?
And that really is what I looked at from the beginning, because it was already established, and I don't think anyone today would say it doesn't affect jurors, at least not in the research community. But I wanted to know how. So the first way that I looked at was how it influenced basically their memory for the trial. And so what we call source memory. So when a juror is exposed to pretrial publicity, they have two sources of information. They have the pretrial publicity that they get prior to trial, and then they have the trial evidence. They are then have to differentiate between all of that information they got before trial from the evidence they got at trial. And this is a very difficult task. And it's a difficult task because many memories are not tagged with sources. Instead, individuals have to, and this is an unconscious process, look at external factors that have been basically remembered to the side and decide, was this memory formed when I was prior to trial, or was it formed when I was at trial? And so my research has found that jurors with a high amount of confidence believe that information that was only presented in the pretrial publicity was presented at trial. They then use that information to make decisions about guilt unknowingly. They're not aware of this because it's an unconscious bias. And that's really what I look at is unconscious biases. It's an unconscious bias. And then they talk about the pretrial publicity during deliberations as if it came from the trial, as if it is actually trial evidence, and other jurors fail to correct them for the most part during deliberations. And so we do this thing called mediation analysis, and we find that these source memory errors are actually the mediator, or actually the factor that is responsible, one of the factors that's responsible for these biased verdicts. Of the information is different from the actual source. So yes, they made a source memory error where they believed the information that they were discussing actually came from the trial, the live stream, when in fact it did not. It came from the governor's press conference. So they were confusing the source, which is not unusual, and it's something that we all do.
And in the situation in the clips, they were talking about a press conference and a court appearance, and they're broadcasting that all occurred on the same day. What is the effect when the pretrial publicity is followed by a long delay, and then you have the trial evidence, and then you have more of a delay because of the length of the trial, and then you get the jurors in deliberation trying to figure out where they heard the evidence from? What does the research show about that?
So memory for source and memory for the information are two distinctive processes. And memory for information lasts longer than memory for source. We sometimes discard the source of our memories, and we keep, though, the gist, the information itself. And so if there's a delay over time, we could discard that source. But also going to source memory, what's really important here is when you're showing these clips of, you know, I don't know if it's going to be this courtroom, but a similar courtroom where the trial is going to take place, you have the attorneys that are going to be here, the same judge. You're not giving prospective jurors any distinctive features to hold on to be able to discriminate, well, this was something I got prior to trial, and this is something I got at trial, because the two sources now are basically entangled. And it's going to be a very difficult thing to do to try to discriminate those two sources of information.
Last area I'm going to have time for is does research say anything about whether video or live streaming has a greater impact in terms of prejudicial pretrial publicity than other forms of pretrial publicity? And second part of that is, does repetition of the information play any part?
Okay, so first part, yes, there's evidence that video has a stronger impact, and a lot of that is because video, one, it catches our attention more, right? So you have more attention is going to be paid to video, but also it can result in more emotional responses, more visceral emotional responses, and so it will be better remembered too, because visual stimuli is. A lot of times it's not just the visual stimuli, there's auditory stimuli connected to the visual. It's going to be better remembered. And both meta-analyses and individual studies have shown this. And as for delay, you know, in a trial, and I've seen this, you know, pretrial publicity comes and goes. The best way to learn something is to learn it spaced out. And this is what we see with media that follows a case, making it to trial. It ebbs and flows, and so you'll see a lot of it every time something like this happens, a hearing happens, or just before you go to trial. And so it isn't like it completely stops. And when you have this spaced learning and this high repetition, think about what your professors told you in school. Space out your learning, repeat. This will result in very long-term memory for the information, a very strong and long-lasting memory.
I think I want to leave some time for cross-examination.
The state. Thank you, Mr. Burt.
Professor,
Good afternoon.
we're talking a lot about the effects of pretrial publicity
Correct.
On jurors,
Correct.
prospective jurors, correct? Is it true that the effects of pretrial publicity goes both ways, meaning it can negatively impact the defendant, correct?
Correct.
And it can negatively impact the state?
Correct.
Okay. In your declaration in this case and in the slides that we haven't gotten to, you've referred to a number of theories. For example, pre-decisional distortion theory.
Correct.
Emotion.
Yes.
Or affective
Yes.
PTP, I think.
Yes, emotional, because affect is a little different for us, yes.
Okay.
Emotion is more specific.
Thank you. The story model approach.
Correct.
You talked briefly about primacy effects.
Yes.
Belief persistence.
Yes.
Confirmation bias.
Correct.
Source memory errors.
Correct.
And group polarization or polarization effects.
Yes.
Are those one and the same?
Yes, they are the same. And I know on the slide sometimes it gets truncated, but they are group polarization. Yes.
Okay. All of those theories, as applied to pretrial publicity, can affect both sides, correct?
That is correct.
Negatively or even positively.
It's not positive for justice maybe, but positive for the side that, yes.
Fair enough. Thank you very much. If I could have you turn, do you have a binder there?
Yes, I do.
In your declaration, I believe this is tab number 6. I can have you turn to page, it looks like it starts on page.
This would be my supplemental material because my
I think it's
declaration.
your original declaration.
Okay, so that, yeah, I have it as 5 here.
Okay, tab 5. You could go to page 6, paragraph 10.
Okay.
You're talking about a study that you, a 2018 RUVA study.
Well, this actually is not a RUVA study. This is my peer review, one of my peer review chapters where I reviewed the PTP research to date at 2018.
Okay, perfect. The second sentence in that paragraph reads, DeLuca, 1979, found that mock jurors exposed to 3 pieces of anti-defendant information were more likely to convict than those exposed to only 1 or 2 pieces.
That's correct.
Consistent with this, Daftery, Kapoor, Penrod, O'Connor, and Wallace, 2014, reported that jurors who read a high amount of anti-defendant PTP, 10 news stories, were significantly more likely to render guilty verdicts than those exposed to a lower amount, 5 stories, correct?
Correct.
And then you indicate, conversely, greater exposure to pro-defendant pretrial publicity reduced the likelihood of guilty verdicts compared to lower exposure.
Correct. And so if they're only exposed to, one type of pretrial publicity in these cases, correct.
Okay, thank you. Pretrial publicity, again, as it applies to both the defense and to the prosecution, can persist. The effects of that can persist through jury deliberations. Is that accurate?
Correct.
Okay. And negative victim pretrial publicity can hurt the prosecution's case. Is that accurate?
That's correct.
Okay. If I could have you turn to your slides, which I think is I thought it was tab 7, but it might be tab 8.
Okay.
Can I have you turn to slide 58?
Okay.
In slide 58, you write, quote, jurors exposed to anti-victim PTP are less likely to vote guilty after deliberations than before them, close quote.
Yes, and that's a polarization effect. Correct.
Thank you. If you turn to the next slide, slide number 59, you wrote, quote, jurors exposed to negative victim PTP discussed trial evidence in a pro-defense manner and favored not guilty verdicts, close quote.
Correct.
Thank you. And then if I could have you turn back to your declaration in the previous tab, page 34 of that declaration, it's paragraph 59. And I think in this paragraph,
Hold on. I thought
okay,
it was.
that's fair.
Oh, again, I think I'm on the wrong. I'm on the supplement. I'm sorry. There's too much stuff in here.
What was the page again?
Page 34.
Thank you.
34. I'm there now. And what?
Paragraph 59.
Okay.
I think you're sort of, this is page 34 of 36. So I think you're sort of summarizing some of the
Yes,
conclusions
yes.
of your research. It states, these findings collectively indicate that victim PTP or pretrial publicity can significantly distort jurors' verdicts, perceptions of credibility, interpretation of evidence, and memory accuracy, and that deliberations are not a reliable corrective mechanism. Instead, deliberations may perpetuate or spread bias, undermining the fairness of trial outcomes.
That's correct.
Okay. And again, it applies to both sides.
Yes.
Okay. I noticed that in most of the conclusions or your findings in your declaration and on the slides, which again, that we haven't referred to specifically today, you couch your findings or conclusions in conditional language. For example, you write, information processing can be biased by information that comes before the to be remembered event.
Yes.
In your declaration, you stated live streaming of all proceedings can lead to deep-seated bias. Is that
Yes.
correct? Why the conditional language, Professor?
So as a scientist, we never prove anything, right? It's probable, there's a high likelihood, it's reliable finding, but we never say that something's definitive. We always, there could be other factors, and so we always say can, but there's an overwhelming evidence, and again, we find this over and over again, it's reliable finding that, pretrial publicity does bias how jurors interpret information, and is actually a mechanism through which, this primacy effect, this pre-decisional distortion, the story model, which they're different, but it's not important the differences. They all basically lead to the same results. They result in biased verdicts. But again, as a scientist, I would never say that I proved something, but there's a good likelihood that this will happen.
Okay. So it demonstrates your intellectual honesty, correct?
Yes.
Okay. A couple of other examples. In your declaration, you wrote, cognitive bias can be unconscious.
Yes.
So it's not certain, but it can be.
There's cognitive bias, and we didn't get to my slides, but I talk about explicit bias, which is bias that's easier for the courts to deal with, versus implicit bias, which is much more difficult for the courts to deal with because jurors are unaware of their own bias.
Okay. Let's briefly talk about the studies. The majority of these studies, or perhaps all of them, you can correct me if I'm wrong, but your studies are based upon mock jurors and mock trials. Is that accurate?
My own studies, yes, but the research that I cite in here, there is some that is not. So there's some field research and some survey research, but my own research are all mock, what we call jury simulations. So experimental studies.
Okay. Kind of a laboratory.
Yes.
Okay. Not the real world, but you're trying to get there.
We're trying to mimic it as much as we can.
You mentioned some of the studies are survey studies.
Not mine, but individuals. It's a mixture between a field and a survey study. So yes, there's studies that go out and ask jurors, for example, something similar to what Dr. Edelman did, but it's a little different when you ask jurors, prospective jurors in the venue where the trial is going to take place. And this is for research purposes only.
Sure.
How much pretrial publicity they've been exposed to, what they can, specific facts that they can recall, that type of research.
What are the limitations in survey studies? You speak to it briefly in your declaration, and there was even a slide about that.
And so the problem with survey research is that although it might be high in realism, because you're talking to people who might actually be a juror in that venue, the problem with survey, that particular type of survey research, is that we can't infer causation because nothing is controlled. We can't systematically vary how much pretrial publicity someone gets. We don't know exactly what they were exposed to, and so we cannot infer causation. We don't measure anything, that isn't any implicit types of bias. Instead, we look at explicit bias. We can measure, explicit, but we can't measure the implicit bias, the things that I measure in my study, and so that's some of the weakness there.
You mentioned that implicit bias cannot be measured, or it's difficult to identify.
It's difficult to identify, but you see it in behavior. So, for example, when I see individuals who have a very strong opinion that information was presented in the trial that was only presented in the pretrial publicity, I know that they have no reason to lie to us. as a researcher, and they're doing this with a high amount of confidence, and that's a type of implicit bias where they truly believe that their memory is accurate, but it isn't. And then we also have this pre-decisional distortion paradigm where we can actually see them distort trial evidence that aligns with the slant of the pretrial publicity they were given. So in an empirical research study where we have control over everything, we can measure those things.
Okay. This probably goes without saying, but none of us can predict who is going to be summoned to jury service in the future, correct?
Correct.
Let alone which 12 members of the community will actually sit in judgment in a particular case. Is that accurate?
Correct.
Okay. In some of your writings, you talk about, for lack of a better word, remedies or some things that we can do in the court process to identify bias.
That's correct.
Certainly explicit bias.
Yes.
And what might even help with respect to implicit bias. What are some of those tools that can be used?
So for implicit bias, the bad news is I really can't say that any of the tools that I discussed are really, I've done research on it too. Implicit bias is something that's really hard to remedy because jurors are not aware they have it. It's unconscious bias. So how do you correct something that you're not aware of? And I could go into more detail, but I know I don't have time. Explicit bias is different. If you use, well-prepared, thoughtful juror questionnaires, if you have, extended voir dire that is individual juror voir dire, so we don't have that social desirability effect, you can identify but depending on what you do, you have a better chance of identifying explicit bias. It's the easier bias to deal with.
Okay. And in a case like this, a notorious criminal case like this, your recommendation would be that we have extended pre-voir dire questionnaires,
Yeah.
correct? Individual voir dire questioning of jurors.
Correct.
Turning to the implicit bias, with respect to these extended voir dire questionnaires, what can be asked that may help us identify implicit bias?
So one of the recommendations, and I know it's probably in here somewhere and I don't know where, is that you need to find out the amount and type of pretrial publicity that jurors have been exposed to.
Okay.
Because even if they believe that they can be impartial, and that's part, they want to please the court, they want to please the judge, and sometimes they do truly believe that they can set aside bias. It's asking those questions to get at how much have they been exposed to, what is the type of information they've been exposed to, that will tell you if they're biased. Asking them whether they are biased or they can set aside bias does nothing. Jurors will say they're not biased and they'll truly believe it. And we find that they're biased in that we look at their verdicts, and those that say they can not, they're impartial, they're not biased, they showed the same bias when exposed to pretrial publicity as those that explicitly say, no, I'm biased. I know that I can't be impartial.
Okay, so extended questionnaires that asked about someone's exposure,
Yes.
what they look at, how
Yes.
much,
Yes.
could help identify potential problematic jurors.
Correct.
With respect to bias.
Correct.
From pretrial publicity. And it's not your opinion that someone cannot set aside their bias, is it?
When it's implicit bias, it's very, very explicit bias, but implicit bias, the problem is that in order to set aside implicit bias, you have to be aware of the bias. First of all, you have to be motivated to correct that bias, and then you have to know the amount and the direction of that bias. And those are rarely there for unconscious bias. For explicit bias, yes, but for unconscious bias, how does someone guard against how they're going to interpret all trial evidence? How does someone guard against the fact that they're now unable to discriminate what they saw prior to trial versus what they're seeing in trial? And so when they don't follow judicial instructions, because we do instruct them not to use pretrial publicity, and so when they don't follow instructions, it could be that they're willingly not, but a lot of times it's because they're not aware that they're not following the instructions. They truly believe they're being good jurors, but they have this unconscious bias that they cannot remedy themselves.
Understood. Thank you. And again, the bias due to pretrial publicity can go both ways, correct?
Correct.
I could have you turn back to your declaration. I think you're there
I'm
still.
there, yeah.
If you go to page 26, paragraph 40. In this part of your declaration, I think you're talking about the survey data that was used in support of Utah's law, creating the presumption for cameras in the courtroom. And you're talking a little bit about what California did. They did some additional research here. They used some interviews and systematic observation to perhaps bolster the basis for their law.
Correct.
The last sentence or last two sentences in that paragraph, you wrote, each trial, witness, set of jurors, judges, attorneys are different, correct?
That's correct.
You then say there is no control over any variable, and hence there is no way to conclude that cameras do or do not affect trial players' behaviors, memory, or decision-making, close quote.
That's correct.
Correct. Thank you. Nothing further, Judge.
Thank you. Mr. Burt.
In your PowerPoint presentation, you kind of summarized that there are three methodologies. One is survey research for studying effects of pretrial publicity. One was survey research, right?
Yes.
Second
Correct.
was jury simulation research.
Yes.
And the third was meta-analysis.
Correct.
And do those three areas of research kind of come together with some common understandings about the effect of pretrial publicity?
Yes, they all converge on the same finding that pretrial publicity influences jurors' decisions, and that there's also another that I don't explicitly list there. There's a shadow jury paradigm, which I believe the prosecutor, he alluded to, where we looked at, I didn't look at it, it was Neftari Kapoor. They looked at it where it's kind of both a field research and an experimental study. And in their study, they found that the findings, once again, converged, depending on what the jurors were exposed to, regardless of how they were exposed to it in the real world, out, in the venue, or, experimentally, they were biased towards the side that the pretrial publicity was against. So if it was negative defendant pretrial publicity, they're more likely to find the defendant guilty. And this is, again, converges over all of the methodologies. And if it was, I think in that case, in that shadow paradigm, if it was positive defendant, it was pro-defense.
Is the overall purpose of your study to try and eliminate bias on, if possible, on both ends of the spectrum? In other words, is your concern that both the defendant and the government receive a fair trial, not impacted by prejudicial pretrial publicity?
Yes.
A lot of the focus of the questioning by the state was, well, it prejudices both ways, but in either side of the spectrum, you're getting prejudgment, right?
That's
the
correct.
effect of the pretrial publicity. One is prejudicing the defense, the other prejudicing the state.
That's correct. And neither, like I say, neither is acceptable in my opinion. And, obviously I think in probably the court's opinion, you don't want that bias prior to trial. You would like jurors to come in that really can be impartial and not have a favored side. And that's, when they come to trial favoring the defense or favoring the prosecution, that is going to just result in a biased outcome.
I want to be clear on one point. Were you suggesting that there is a way to eliminate implicit bias by using jury questionnaires or doing open-ended questions or any other method that we know of?
It's not a way to eliminate, but it's a way to better identify jurors that might have bias. You're not going to eliminate the bias, but it might allow you to identify individuals that have bias. And so again, it's not asking, you find out that someone has been exposed to something at that point, and you find out how much they've been exposed to, what they've been exposed to. There's no sense in asking them if they can be impartial. If they've been exposed to a significant amount of pretrial publicity from one side or the other, then we can just assume that they're going to be biased.
Last question. Based on your review of the publicity in this case, do you believe that the negative publicity, and negative, I mean negative toward Mr. Robinson, has mitigated the anti-Charlie Kirk publicity, has somehow remedied the negative publicity, given the nature and the timing in particular of the publicity?
No, and again, I think because predominantly early on, and there's just a lot more by credible sources that is anti-defendant than is, anti-Charlie Kirk or anti-Erica Kirk or any, and you have to remember, when we look at anti-victim pretrial publicity, especially when it comes to murder, in murder cases, because we do look at different types of cases, in those cases, the anti-victim pretrial publicity kind of points that the victim somehow was responsible for their own death because they did something they weren't supposed to do. And I'll just give you an example. For example, they came into their ex-wife's house with a gun, and the ex-wife thought that they were an intruder in the house and shot and killed them, versus, the ex-wife or the estranged wife, in this case, called her husband over so that she could. So it gives an ulterior view of what happened to the crime. So it isn't just credibility of the defendant, of the victim, or we don't like the victim. That is not what we manipulate in these anti-victims. It makes them look like some way they maybe could be culpable for their own victimology.
Like myths about rape victims, for instance.
Yes.
A lot of the studies
Yes.
have been done in
Yes.
that area.
And that has been done too, yes.
Is the publicity in this case easily characterized as pro-defendant or anti-defendant? For instance, there's some articles about suggesting, Mr. Robinson allegedly was involved in a conspiracy with others, Israel or whatever. Does that exonerate Mr. Robinson, that kind of conspiracy theory?
No, it still points to the belief that he was guilty. He was just, someone else was also involved too. And so it doesn't absolve the guilt, and it doesn't point away from the guilt of Mr. Robinson. Instead, it says there might be other actors too that are involved in this.
That's the same thing as the sort of rape victim myth.
Yes.
Kind of things that are studied in the
Yes.
literature. Okay, thank you.
Thank you. Anything further?
Judge, I have two quick areas of questioning.
All right, Mr. Grunander.
In turning to your last slide that you prepared, it was slide number 82. The title to this slide is Expert Conclusions. And number one reads, based on my review of the empirical research literature, the pretrial publicity identified in the defense motions and the Utah County Public Opinion Survey, it is my expert opinion to a reasonable degree of psychological certainty that this case is situated within a highly prejudicial pretrial environment that presents a substantial risk to juror impartiality.
Right.
You wrote that, right? So with respect to pretrial publicity, you reviewed the defense motions pretrial publicity.
That is correct.
You did not do your own deep dive into publicity.
No, I was not asked to do that.
Okay. If respondents to a survey were responding with words to describe Tyler Robinson as a scapegoat or cover-up or fall guy, would that indicate that conspiracy theories that or theories that he was not the guy who did this are taking hold in the community?
I mean, I don't know how widespread that is, but, and again, I would need to, maybe look more at what else was said, but it could. I mean, there's a possibility. There are some stories out there, but as I stated, there's just overwhelming anti-defendant pretrial publicity and what happens with pre-decisional distortion is that we actually throw away things that don't fit our initial story. So if we don't think it fits our story, I'm going to think that that's just crazy.
The
That's
story
just
model
ridiculous.
approach.
Yes, the story model approach.
But if people were listening to conspiracy theories that were advanced starting the day of the charges,
yeah, that's different. Yeah,
that could affect their
Yes.
story model.
yes, correct.
Okay, thank you.
All right. Anything further for this witness?
No, Your Honor.
All right. Thank you, doctor. You may step down. All right. So counsel, we'll turn now to closing arguments, but I do have some questions for counsel. As you know, I ultimately need to make the decision on what's being requested. And so I did have some questions for you. The court is bound by Rule 4-401.01 in deciding whether to allow or restrict electronic media coverage. First, subsection 2A states that there must be a presumption that electronic media coverage by a news reporter shall be permitted in public proceedings where the predominant purpose of the electronic media coverage request is journalism or dissemination of news to the public. In assessing the predominant purpose, is the court required to consider the purpose of the requesting news media organization? For example, for today's hearing, the requesting media organization is ABC4. The court form does not require the media to represent the purpose for the coverage. So what criteria should the court apply in determining the predominant purpose of the electronic media coverage?
Unfortunately, Your Honor, there is no guidance in the case law. No court has interpreted this rule. The only thing we have to look at is the genesis of the rule, which is the final report in 2012. And if the court looks at that report, you'll see heavy reliance on a study, a law review article that was done by Ninth Circuit Judge Kaczynski back in the 90s. And one of the things that he emphasizes in that study, and the only indication I could see of what is meant by the predominant purpose, is he uses the O.J. Simpson trial as an example of what is not for the predominant purpose of journalism, but is rather sensationalism. And he uses how the camera is dramatizing events in the courtroom, and is the best example I saw of what could have been meant by that language. It's also noteworthy that that language was not part of the original rule when it was adopted. It was put in by amendment several years after the rule was adopted, I think in 2015, and I did diligent search on this. I could not find any indication in the Judicial Council proceedings or anywhere else of what was meant by this. So it's kind of an open question of how the court goes about and interprets it. I don't think it's governed by how the media represents themselves. I think it's more governed by the substance of it. Is it sensationalistic? Is it more focused on advertising? A lot of the coverage you'll see on the clips, even the live stream coverage, has commercial breaks in it. And one of the factors that the Supreme Court cited, Estes, Maxwell, those cases, is the effect of having court proceedings that include product advertisements and the kind of disrespect that could result from that, from putting the court in the position of at least appearing like they're advertising goods here as opposed to doing justice. So in the absence of any indication, and this language also is unique to this state. I could not find it anywhere else in terms of what that meant. So my best answer to the court of the question is that I think the court has to look at, is it serving an educational purpose? Is it, and that's what journalism is. You're reporting the news, you're not creating it. You are reporting on what's happening in court. you're not making arguments for the prosecution to show that Mr. Robinson is guilty. And one of the things we've tried to demonstrate in the hearing today is that at least the electronic media, the predominant theme there is advancing the prosecution's side of the case. It's not educational in nature. It certainly is affected by a profit motivation, but more importantly, it's sensationalistic and it's prejudicial. And I would say that that is not within the scope of the language that the court is talking about.
All right, turning to the state.
Judge, I don't know that I have a whole lot to respond to because these are unknowns. But the language of this, so there is a presumption that electronic media coverage by a news reporter shall be permitted in public proceedings where the predominant purpose of the coverage request is journalism or dissemination of news to the public. So when I first think of that, I mean, we have all kinds of media coverage that is probably not journalistic in nature. Some of the podcasts, some of the different streamings that can occur that we can find on the internet, online. I don't know that you would couch those individuals as journalists so much, but ABC4, KSL News, these are journalists that are live streaming these proceedings. The difficulty here that we're confronted with is what is being done with that coverage by third parties, which can't really be controlled. But a news organization that comes in to actually live stream these proceedings, they're then streaming those proceedings to the public. It's very educational. It's very newsworthy. It's disseminating the news. And so I think if the request from the court was from a YouTuber, some sort of broadcaster, or some sort of podcaster, there may be problems there. But when it's coming from a traditional news organization, they are in fact disseminating this news. But it's about the best I can give you right now, Judge.
All right, and just two more questions and I'll ask you first. Subsection 2D of the rule states that any reasons found sufficient to prohibit or restrict electronic media coverage shall relate to the specific circumstances of the proceeding rather than merely reflect generalized views or preferences. The court reads this as requiring individualized findings for each proceeding rather than permitting a blanket order prohibiting coverage. Is that your understanding?
I believe that is accurate, Judge. That is my understanding, and that's why I think a request to just simply eliminate electronic media coverage in this case is premature. It's not warranted. There are going to be times, probably throughout these proceedings, where a hearing should be closed for safety purposes, or if there's some sort of controversy that could prejudice one side or the other. But just a blanket exclusion of the media, I think, would go well beyond what this allows for.
All right, and so is this what the court must undertake this process for each hearing?
Well, I think the court has sort of a foundation of the issues before it, has an idea about what the effects of pretrial publicity can be for or against either side, possibly even both. We didn't discuss what happens to people who look at both sides of the slanted coverage, what the effect on that individual is. But I would suggest that the court can take what it's learned through these hearings, the evidence presented here, and apply that to the proceedings moving forward. And if we have to reconvene or if there has to be further argument, we can make those arguments, and the court has a basis to draw from now.
Thank you, Mr. Fernandez. Mr. Burt, the same question posed to you. Subsequent 2D of the rules states that any reasons found sufficient to prohibit or restrict electronic media coverage shall relate to the specific circumstances of the proceeding rather than merely reflect generalized views or preferences. So the court reads this as requiring individualized findings for each proceeding rather than permitting a blanket order prohibiting coverage. Is that your understanding?
No, it isn't, Your Honor, because I think what that section is referring to is you can't base a finding under the rule based on general concerns. It's got to be related to the specific publicity in this case. And the reason I read it that way is if the court looks at 2A, it says the judge may prohibit or restrict electronic coverage in those cases. It doesn't say in those proceedings. It says in those cases, as if the court can make a ruling regarding the entire case. And that reading, I think, makes sense in terms of the practicality of having the court have to revisit this issue every time we have a court proceeding. I think A points in the direction of the court being able to make a finding that applies to the case as opposed to a particular hearing or proceeding, and D directs the court that when you're considering the issue, you shouldn't take into account just generalized concerns like prejudicial publicity in general is harmful, but you have to look to the particulars of the case and decide in this particular case, is there a reasonable likelihood that the defendant's fair trial rights will be jeopardized under the first factor. There are other factors, of course, but I think that is, or for instance, on the privacy concerns, I think D is calling you to look at not in general, well, juror privacy or witness privacy may be jeopardized. That's a general concern or a general view. What the rule is saying you should do is don't look at general views or preferences. Look at whether the witnesses or potential jurors in this case could be impacted in terms of their privacy rights. That's the way I read the rule.
All right, one final question, Mr. Burt, I'll start with you.
Sure.
So the court's not limiting argument on the factors set forth in Rule 4-401.01. However, I would like counsel to address one specific factor, 2BV, which allows me to consider whether electronic media coverage will create adverse effects greater than those caused by media coverage without recording or transmitting images or sound. Even in the absence of electronic media coverage, the media retains a First Amendment right to observe and report on the proceedings. Is there evidence before me that would assist the court in comparing these two circumstances?
There is, Your Honor, and in particular, the report set out in great detail in Dr. Ruva's declaration, and we didn't have time to explore this in detail here, but the declaration indicates that the source of the media does matter, that electronic coverage has a greater impact than print media because it's more visual. And from the perspective that Dr. Ruva talked about, this source misattribution theory, the visual of the courtroom is much like what a juror is going to be hearing during the trial. So in that scenario, they're much more likely to make the kind of source misattribution errors that cause jurors to have this implicit bias. They're thinking, oh, I've heard this before. And what they may have heard before is the kind of coverage we saw today where the court proceeding is in the background. They've silenced what's going on in court, and the media talking heads are saying, let's look at the text, let's look at the confessions. So the danger here is that they're going to confuse those two and not know that they're confusing them. And so that comes from the visual looking at the images. You're not going to get that according to Dr. Ruva's declaration from print media alone. And she cites a number of studies on that issue. So I think there is evidence before the court on that.
Well, then that creates another category, which is audio, because the audio is available to anyone if it's not a closed hearing. And so walk me through the scenario if audio is played and then, as you described, media is doing what you just described with the audio clips being played and then them commenting on that.
I think the situation is not comparable to the video scenario, because in the video, they're using it as a backdrop. It seems unlikely that they can use an audio backdrop, silence the audio, and make the kind of commentary that they're making here. They're using those images as a dramatic way to say, look, we're in court, and the announcer saying, and we heard during the hearing the text messages. Well, that didn't happen, of course, but how would you do that with an audio? You couldn't silence the audio and have the commentators putting in that prejudicial content. It's I think, qualitatively different.
Okay. All right, Mr. Grunander, I'll pose that same question to you and happy to repeat it if you'd like.
That's okay. Okay. I'll just pick up on where Mr. Burt left off. Certainly the media could, certainly an outlet could grab the audio and splash something up on the screen, which we see as well too, that could prejudice one party or the other. So I think the court raises a good point that the audio is going to be always available. Certainly I think that intense coverage of any proceeding, there's a greater risk, right? I think that that's fair to say. One thought that came to my mind though is that even perhaps a middle ground, if the court has concerns here, is the WebEx broadcast. That would give the court control of the camera. There couldn't be zooming in and zooming out, stuff like that. But there is a greater risk with additional coverage.
All right.
I would say.
All right. So we have about 24 minutes, and I realize that your closing arguments, well, they are important. And so I'll give the parties an option. You can have a very brief closing, or if you wish to submit your closings to the court for consideration in written form, I'm happy to entertain that so you're not limited to a time constraint. What are the thoughts of the parties?
I have submitted to the court, I think it's getting near the 200-page limit of written arguments in front of the court. And
Sure.
The hearing has provided the court, I think, with some sense, but the real important stuff is in the declarations that were submitted in support of the motion. Those, that declaration is thoroughly addressed in the written motion. So I'm not sure it would be helpful for the court to burden you with yet more paperwork. I mean, I'll do it, but I think the court has the tools in the written submissions. I do want to, in the brief time I have, say a couple of things that I wanted the court to focus on that have come up since we filed the pleadings that I think are important. And I think if the court could give me a little time to do that, then I'd be satisfied with keeping within the time limits and submitting it based on the pleadings that are in front of the court.
Sure. How much time would you like?
I'll try and do it in 10 minutes.
And how about 5?
Deal.
All right.
One of the things the court, when we were discussing this issue the last time, the court asked me whether the Estes case had been overruled. And I've been thinking a lot about that after that. I'm not sure I answered it satisfactorily. I said no, that there is still this notion of prejudicial pretrial publicity in high profile cases, which this is. I stand by that argument, but I went back and took a look at Utah Supreme Court cases since Chandler was decided in 1981 to see whether there was any sort of hint in Utah cases suggesting that Estes was no longer good law. And I also looked just in general at how many times that case has been cited. It's been cited as of yesterday about 4,200 times, which is not generally how overruled cases are treated. It's not listed in Westlaw as overruled. It's cited a lot. And the Utah Supreme Court, after Chandler was decided, cited it 3 times. Or they either cited Chandler or they cited Estes in 3 opinions. One of them was when they were considering modifying back in the 80s prohibited in-court coverage. And in 1981, the Utah Supreme Court published a brief memorandum of opinion about that proposed modification. And the court cited Chandler in its discussion. And the proposal was that the prohibition be eliminated. And the Supreme Court says the members of this court are unanimously of the view that Canon 3's prohibition against televising, broadcasting, or recording of judicial proceedings should be reaffirmed, and that the petition for modification of those provisions should be denied. We are not satisfied that the balance between the interests of news reporting and the interests of a fair trial represented by Canon 3 would be improved by the proposed changes. Experiments underway in other states may yet suggest appropriate modification to the canon on the subject, but for the present, we remain unconvinced that change is warranted. And they note that Chandler was decided before they published this opinion. So they recognize that Chandler was on the books. They did not go down that path. And so that's the first time they cited it. They cited it again in a case 1983, 672 Pacific 2nd, 1254, where they discuss it in the context of a juror misconduct claim for jurors who had, despite the court's instructions, had read the pretrial publicity. And it's cited for the, Estes is cited for the proposition in the defense. There is no constitutional right to have cameras in the courtroom in televised trials. So we're not talking about the clash between two constitutional rights. We're talking about the clash between a federal constitutional right and a state rule presumption that applies only if the nature of the publicity is news and not sensationalism. And the other factors that the court has to consider under the rule are not met. So however the court balances those factors under the state rule, the court still has to contend with the federal constitutional issues here. And those issues and the rules there are much different. And they argue strongly in favor of granting this motion. The last thing I want to say to the court, and I know I'm close to 5, if not over it, is one of the factors under the rule, if the court just is going to balance under the rule, is privacy concerns. And we have privacy concerns of witnesses who have expressed to the court that they do not want to be televised. We do not know the privacy position of the vast majority of witnesses who will testify in this case. So whatever the court does here, I don't think the court can make a blanket ruling that says you will never reconsider whether to take cameras out of the courtroom for witnesses who don't want to be televised. I think that may have to be something the court's going to have to deal with down the line. And similarly, I don't think the court in ruling here is excluding the possibility that certain hearings would also have to be subject to possible closure, most relevantly the preliminary hearing, because favor of closing the hearing. So we presented the court with a broad argument here that cameras should be excluded, especially under the federal constitutional test. But however the court rules, I don't think this issue is going to go away unless the court just says, I've looked at the publicity, I've balanced the interests at stake and all things considered, and given the fact that we still have a chance to keep this case in this county, because the survey shows that we don't have overwhelming prejudice here. There is still room to take action to try and stem the flow of the kind of publicity that we've seen so far. And that's why we're urging the court now to step in and do the one thing you can do. You can't control the witnesses. You can't control the media lawyers who have spoken out of court. You can't control the prosecutors who have also spoken out of court about things that perhaps should not be spoken of. But the one thing you can control is, and the U.S. Supreme Court has said you can control, is time, place, and manner restrictions. You can say to the electronic media, you are certainly free to attend. You are certainly free to write about anything you see in the courtroom. The court is open to all. That serves the function of open access, transparency. But because of safety concerns, privacy concerns, fair trial concerns, I am balancing the factors in favor of closing the hearings to further electronic coverage.
Thank you, Mr. Burt.
Thank you, Judge.
Mr. Grunander.
Thank you, Judge. Your Honor, mischief lurks in the dark or in secret. Or that's at least how many people view the workings of government, even the courts. And while this is primarily the media's fight here, we do not represent the media. We strongly support open and transparent proceedings in this case so that the public will trust the process here. There are conspiracy theories that abound. There are questions being raised, and the best antidote for falsehood is the truth, is accuracy. It's the actual real proceedings. And that's why we favor opening this court and allowing the cameras in the courtroom. Again, as I said before, an option the court could undertake is broadcasting these proceedings via WebEx. In 1981, the Supreme Court squarely held in Chandler that states may permit cameras in courtrooms, and that doing so does not, without more, violate due process. The court explained that the mere presence of broadcast media does not inherently render a trial unfair. Quote, the court said, an absolute constitutional ban on broadcast coverage of trials cannot be justified simply because there is a danger that, in some cases, prejudicial broadcast accounts of pretrial and trial events may impair the ability of jurors to decide the issue of guilt or innocence uninfluenced by extraneous matter, close quote. It is a challenge. It will be a challenge in this case because of the pretrial publicity in part, for and against the defendant, for and against the state in identifying impartial jurors. But it can happen, Judge. And I don't believe that prejudice has been shown. Irvin v. Dowd, a 1961 Supreme Court case, gives the standard for impartiality with respect to jurors who've been exposed to pretrial publicity. That court said, it is not required, however, that the jurors be totally ignorant of the facts and issues involved. In these days, mind you, this was 1961, in these days of swift, widespread, and diverse methods of communication, an important case can be expected to arouse the interest of the public in the vicinity, and scarcely any of those best qualified to serve as jurors will not have formed some impression or opinion as to the merits of the case. This is particularly true in criminal cases. To hold that the mere existence of any preconceived notion as to the guilt or innocence of an accused without more is sufficient to rebut the presumption of a prospective juror's impartiality would be to establish an impossible standard. It is sufficient if the juror can lay aside his impression or opinion and render a verdict based on the evidence presented in court, close quote. That was the reason I kept asking the first witness about, at the end of the day, yes, I understand this is about cameras in the courtroom, but at the end of the day, the question is, can we seat an impartial jury? Can Mr. Robinson receive a fair trial? And the evidence indicates that he can, Your Honor. In looking at the survey findings from Mr. Edelman, and I'll point to just a few that I asked him about towards the end of my cross. Well, the question about, whether they had heard about President Trump saying something about the death penalty or life without the possibility of parole. 81% said no. Other public officials having commented on that, 65% no. Whether they'd heard about a confession from Tyler Robinson, 56% no. The question of DNA, 65% no. And ultimately the question of, have you seen any video footage or video clips of the courtroom proceedings from Tyler Robinson's case, for example, on court TV, YouTube, or social media? So all these large different media mediums, and 74, I believe it was, 74 responded no. That is significant, Judge, because for argument's sake, if we forecast picking a jury in this case, and we were to choose 1,500 prospective jurors to summon into court, 1,110 of them would not have viewed courtroom proceedings because of the live streaming in this case on YouTube or social media or elsewhere. So that's the ultimate question before the court. Today, the question before the court is whether or not the defendant can receive a fair trial with the current coverage that's going on. Whether his right now is compromised and it's going to be compromised in the future, we can't predict that with any certainty, but there has been a substantial amount of coverage to this point. And it goes both ways, Judge. It's clear from this survey that there are negative feelings towards the defendant, which can help negative feelings towards the victim, which can help the defendant. 25% of the public responded negatively about Charlie Kirk. So at the end of the day, again, mischief lurks in the dark or in secret. Let's shine a light on these proceedings, a bright light, so the public can have confidence in what happens in this courtroom. Thank you.
Thank you. Thank you, counsel. I appreciate the arguments and the evidence presented today. I do want to read a brief statement, and then we'll go to scheduling when the court will make its ruling. The court takes this opportunity to remind all counsel that if any counsel is found to be in contempt of the court's pretrial and trial publicity, it's order docket number 23, and as amended in docket 242, that attorney faces possible sanctions ranging from orders to attend CLEs, public admonishments, and fines up into include jail time, removal from the case, and in the most serious instances, dismissal of that case. These sanctions do not address the consequential nature, the natural consequences that arise when the court must take time away from the regular course of case matters to determine if an order to show cause is appropriate and possibly hold an evidentiary hearing to determine whether contempt has occurred. That being said, counsel would do well to carefully consider their decision to make extrajudicial statements that have a substantial likelihood of heightening public condemnation of the accused, and should consider this before doing so. With that, let's turn to scheduling. Counsel, it looks like the next availability of this court to do a WebEx ruling would be May 8th at 3 p.m. And what is the availability of counsel?
Friday. State's available, Judge.
Thank you.
Yes. That was 3 p.m., Your Honor.
3 p.m. on May 8th
And that would be WebEx.
on WebEx.
We're all available on that date and time.
Thank you. And counsel, before we adjourn, I encourage you to keep your foot on the accelerator in regards to this case. I acknowledge the hard work you're doing. I encourage you not to let up. The court will issue its ruling on the two issues in regards to a continuance of the preliminary hearing and the motion before the court today. Ms. Nestor.
Your Honor, with respect to the hearing on May 8th, we would again request that our client appear via WebEx with no video.
Thank you, Ms. Nestor. I appreciate that clarification, and that will be the case. All right. Anything further before we adjourn today?
Yes, not from the state.
All right. Thank you to all parties. Court is now in recess.
All rise. Okay, folks.
All righty. Well, there we have it. That was long, friends. That was long. So the judge is going to take weeks, as he tends to, for these decisions. So we shall see. I think the keep your foot on the accelerator was a little nod to the defense, like, don't slow down. Being prepared for the nothing is decided. That's just not how it goes. It takes time, my friends. Which, they're all different. Some of them will just decide something right there, be prepared for that. Others take a lot of time. This guy does. So, first of all, the judge has to just determine whether he's going to give the defense more time for the preliminary hearing. And then he's got to make decisions about cameras in the courtroom. It's quite a day. Found it very bizarre. The prosecution's statements about negativity toward Charlie Kirk and Erica Kirk in the prosecution, and that's somehow the same as negativity toward Tyler Robinson, because Tyler Robinson is the only person facing a murder charge with an ultimate penalty of death. None of those other individuals are. that is not a fair comparison at all. That really just, that felt way wrong to me for them to make that comparison. That just didn't feel right to me. I don't know. I'm curious what the judge thinks about it, that somehow this is an us versus them situation where if people talk bad about the prosecution, it's just as bad as if, misinformation is spread about Tyler Robinson. And I don't think that that's true. I don't think they weight the same. You know what I mean? I don't know. Curious what you all think. Let us know. I don't know. I was pretty stunned by that. To just imply that is just that they're the same, that they are weighted the same, that a person who disliked Charlie Kirk couldn't still find Tyler Robinson guilty of murder if they felt that in fact was the case. I just think they're wrong about that. I don't think that that's the same thing as the sensationalism around Tyler Robinson. It is. Christy says it's a bit, Mark, everyone is mean to me means. It is a little. I mean, yeah. I mean, when you make yourself a public figure, like these prosecutors and defense attorneys too, people are going to have opinions about you. And it's not always nice. This is the internet. But does that actually affect the outcome of a trial? I don't think it does. I really do not think it does. So, but again, that is simply my opinion, as we know. I appreciate you joining today. I know it's been a long one, but it's important. All of these steps that we take toward trial, and in this case, really steps we take toward preliminary hearing, are very important and important parts of the legal system that we want to work, and that we want to work the same for everyone. Because that's the only way the legal system works, is if it works the same for everyone here in the United States. All righty. Well, it is Friday. It is the end of my day. Have a great weekend. Take good care of yourselves. Get away from true crime for a while. Get outside if you can. It snowed here yesterday, but it's supposed to start getting better now. So fingers crossed we'll be able to be outside by the weekend, or at least the end of the weekend. And you know it. This has been True Crime Squad Trials. Thanks for being here.